Good morning, everybody. Welcome back for what could be our last day. This could be our last day of Commonwealth versus Karen Read. Oh, we're going to get these closing arguments. And I'm not real sure what to expect from the Commonwealth here. Not real sure what to expect. I expected a lot more from the opening that I got, and so I'm kind of wondering if closing is going to follow this same pattern where the Commonwealth is just unable to commit to a theory of the case, and so they just tell us they put on witnesses. They might even name all those witnesses for us. It was one of the worst opening statements I've ever seen. The whole purpose is to introduce you to what the case is about and then tell you about the evidence as just a way of explaining how you're going to reach the conclusion that the Commonwealth thinks you're supposed to reach. But the problem is the Commonwealth really didn't want to make any commitments in their opening. Didn't want to tell us, here's what the evidence is going to be. And now, of course, looking back in hindsight, we can see perhaps why that is. Because they don't know. There's too much in conflict, and sorting all of that out would require them to commit to a theory, commit to a timeline, commit to a mechanism, commit to whether anybody saw him, a black blob outside or not. Just all of these various details where cases are won and lost. They were going to have to commit to one and stick with it and then advocate for that position. And for whatever reason, they just seemed completely unwilling to do that. So we didn't get much of a story from the Commonwealth other than this very broad outline of there was a fight in Aruba and relationship problems, and then everyone went out to the waterfall. John never came inside, and then the few details about the Hosslong to die in cold search didn't happen until 6:24 in the morning. And Karen's tires spun her wheels up to 24 miles an hour in reverse over 60 feet, backed into him, breaking her taillight. Well, all the evidence is in now, so the jury's heard it all. And it's going to be the Commonwealth's responsibility to explain, tie the pieces together, explain what happened, and resolve these conflicts. Who do we believe and why? If we should disregard some of Karen Read's evidence, some of Karen Read's witnesses, explain why. If Lucky Loughran is not believable, explain why. John's health data doesn't put him in the house, explain why. And not just, I don't agree with it. Explain why Mr. Green is wrong when he says this stuff is super reliable. And by the way, your clock was wrong when you said it couldn't be in the house because it happened at 12:21 and they were still over on Oakdale Street, not even at 24 Fairview yet. So it must just be a glitch. Yeah, your clock was wrong. Mr. Green explained that. You're going to have to answer all these things. You're going to have to answer, why shouldn't we believe these highly qualified accident reconstructionists that we just heard from yesterday that insist this did not happen the way that Trooper Paul has posited that it happened? It just simply doesn't make any sense, doesn't work with the physics and the science. And that's such a big hurdle to overcome, because if they don't, if they don't, the rest doesn't matter. The rest doesn't matter. If she didn't hit him with the car, the rest simply doesn't matter. But I'd be lying if I said I had a lot of faith in Mr. Lally's ability, competence, dedication, motivation to really go swinging for the fences with his closing argument here. Make the closing of a lifetime with his plea to the jury. Now, I got to tell you, I'm kind of, if I'm going to make a prediction, I'm expecting what we got in opening, more of the same. We'll just hear a recap of what happened. We'll maybe hear the witnesses' names again. He'll remind us all these names of people that came in to testify. Not the substance of what they said, problems with what happened, what unfolded. No, we'll just get those names, and then those few things that they have to hang their hat on, that they want us to ignore everything else and just focus on, I hit him, I hit him, I hit him. Taillight pieces in his clothing. And we're just supposed to ignore the rest. We're supposed to just ignore. It's not physically possible that Karen Reed hit him with a car and projected him, causing his death. It's not possible. Because she said I did. And that's what they got. I do, however, have high expectations for the defense. This is a closing you look forward to. I said this yesterday. This is a closing you look forward to. You don't get cases like this many times in your career. Cases where just the evidence falls in your lap. So much of it. The FBI just happens to be involved and be investigating and decides to share all this with you. It doesn't happen. It just doesn't. There happens to be an eyewitness to the early morning hours of the house who drove by and saw the yard that police chose not to talk to, and you find him. That stuff just doesn't happen very often. So there's such a gold mine here. Just a wealth of good evidence for Karen Reed's team. And this is the chance to show some artistry with the lawyering. This is where you get to rely on that skill set, that communications aspect of the trial, to be able to distill it all down and make it simple, just like the experts could. The lawyer has the same responsibility. You got to explain your case like a child could understand it. And make it real clear. I bet we're going to hear about the commitment the defense made in opening to show us that Karen Reed was framed. That's what we were promised. Karen Reed was framed. And closing is the time to revisit that commitment and show the jury we kept our promise. We told you this is what the case is going to be about, and now we showed you through the evidence. So now it's your turn. It's your turn to do your part with what we were able to present. I'll just give you a little bit of thoughts about how I kind of plan to go forward, how I plan to proceed with what's going to happen and everything. We have, of course, our poll up, and I need to check it here, see where we're at. Where are we at with our poll? I don't want it to echo on me. I can't see it. The chat summary is in my way. Okay, here we go. A lot of people taking the under. A lot of people taking the under on 3 hours. You guys have some feelings about this case, don't you? Yeah. 2/3 on under 3 hours and 1/3 on over 3 hours. Well, I got to tell you guys straight. I'm in the over camp on this one. 3 hours. It would be very short. Not saying it couldn't happen, and not saying I wouldn't understand why it happened if it did happen that fast. But it's just hard. It's hard to find that likely, just given the volume. Juries do want to be careful. They want to make sure that they get it right. And there is just always the possibility of the holdout or the person who isn't quite sure, needs to be walked through the process and just get that conclusion really nailed down. So I'm inclined to take the over, but of course we're going to see what we're going to see. What I'm expecting to do today, of course, we're going to get the instructions and we're going to get the closings. And then the jury's going to get the case. So we're going to treat it like a normal day in trial, just as far as this particular live stream goes. We'll take your questions, your comments. But I'm not planning to wait until a verdict comes, just because it could be quite some time. It could be. We just don't know. So I will plan to just keep an eye out on the announcements. It will certainly be announced when the jury has a verdict. Everybody will be notified. They got to get back to court. So we'll hear about that. We'll have some notice, and I'll go ahead and plan on coming back live for that. And then, we'll have some reactions. Whatever way the verdict comes out, we'll have some reactions. So that's my plan. Just as Bev would say, our scheduling. We're going to discuss our scheduling. That's what I'm planning as far as covering today and then the verdict, whenever that will be. And yeah, guys, this case is coming to an end potentially. I should say, I'm predicting an acquittal. I'm certainly not. I know I'm not alone in that. I know most of my audience is predicting acquittal. A lot of what I've seen just out of the, public opinion seems to be favoring an acquittal as far as what I'm seeing. So I'm not expecting a conviction, but if one happened, there would be an appeal. We would certainly follow that. Certainly would follow that. But not really expecting that to be the case. But, guys, I have gone down a little bit of this rabbit hole that is the Sandra Birchmore. I've gone down this rabbit hole. In fact, I found the civil case. So I've been looking through that. Learned that the family of Sandra Birchmore, this case was filed actually way back in the end of 2022. So it's been out there for a little bit. It's fair ways into the process. And she has, or her estate, has sued the city of Stoughton, the Stoughton Police Department, the Office of the Chief Medical Examiner, the Office of the Attorney General. No, they didn't sue the Attorney General. I think that just may be an additional party. And then the individuals, Matthew Farwell, William Farwell, Robert Devine, and Joshua Heel. So these are all individuals that were discussed in the Case podcast, which is where I first started getting information about this particular case. So it's not set for trial until 2025. Not set for trial until 2025. Discovery is going to be ongoing throughout this year. The cutoff date is not until December of 2024. But it's already cleared hurdles as far as motions to dismiss and those kinds of preliminary processes to allow it to go forward. There's likely to be there's a protective order in place already for discovery, so there are likely to be some limits on what the public is going to see through this process. But I'm definitely interested now in seeing how this unfolds, Granted that even if criminal cases are not really all that likely to go forward to trial, civil cases even less so. Even less so. They're just so likely to be settled, in part because it's just involving money. And so, especially with institutional defendants like the town, the police department, they have insurance for this. So they don't necessarily have a lot of skin in the game when it comes to going out on a limb for these bad cops. There's a whole separate angle with the police unions and the contracts, the collective bargaining protections that may be in place that sort of require them to protect cops in terms of just their employment and the kinds of downsides, the kinds of consequences there can be, administrative actions relating to their employment. But when it comes to civil liability, does the town really want to jump on a grenade for these guys? No, they really don't. So at least as they're concerned, and insurance is likely to play a role there. And to the extent that insurance covers active law enforcement officers who were acting in the scope of their law enforcement duties, which is the basic allegations, right? It's the operation of this Explorer program. The allegation is just they groomed her. They groomed her and, started a relationship with her when she was quite young, still a minor. And the allegation is, as a result of that caused her death. That led to her suffering extreme emotional distress that led to her taking her own life. The officers are likely, to the extent they were active law enforcement officers at the time, probably also covered by insurance. So that's always got a role to play. Now, insurance typically does not cover intentional wrongdoing, but they have an incentive to kind of plead that down, so to speak. Negotiate a settlement that wouldn't involve any kind of intentional tort, any kind of assault. Nothing like that, just perhaps a negligence or something like that would be covered by insurance. So don't necessarily have super high expectations that, for example, it's going to go forward to trial and that people would be able to see the evidence, see what happened, see what how do people explain themselves in all of this. But the process itself, as we've seen just in the last week, it does open some doors to potentially getting new information. I did see there was a statement that the new chief of police of Stoughton made about this medical examiner report that has since come out. So we saw some news stories about that, and it is arising out of the civil suit. It is a pathologist that's been hired by the family who wrote a report, and in that pathologist's determination, this was a homicide. Now, in and of itself, that's maybe not that remarkable. You expect a family in a civil suit is going to be able to hire somebody that will say something that will support their theory of what happened, their version of events. And it really would have to be a homicide for wrongdoing to attach, right? If the cause is her independent decision to take her own life, it's hard to overcome that. That's kind of a superseding cause of the death. It makes it not wrongful, not attributable to the conduct of these particular defendants. But homicide, homicide means they caused it. It means they caused it. So in and of itself, I don't know that that's super remarkable. It's kind of expected in the context of a civil suit that they would find somebody who would be able to support that theory. But what was surprising was this statement that came down from the chief of police, because Stoughton is they're adversarial in this case, And so you would expect they would poo-poo it. They would say all of the things that you normally expect people to say about experts. Oh, this is a paid gun for the defense, and we conducted a thorough investigation, and we stand by our medical examiner, and so forth. No, that's not what she said. Not what the chief of police said. She said that she is disturbed by the findings in this independent autopsy report, this defense autopsy report, and that it warrants further investigation. So that kind of raises some eyebrows. She says this in her capacity as somebody who has years of experience doing investigations, that she's disturbed by what the autopsy report has to say. Well, I think a lot of us are disturbed by the situation just in general. So I do intend to keep an eye on that, see how that unfolds. I'll potentially do some streams where we can go over the process to date, look at the complaint, look at the motion to dismiss, how some of these rulings have come down. There was one that I saw that just gave me a little chuckle because, boy, it's everywhere. It's everywhere these days, guys. There's an order for sanctions in there because the plaintiff's attorney relied on AI to do their briefing. And guess what? Guess what? Lo and behold, the AI made up some cases. Yeah, it made them up. Well, to his credit, the attorney in this particular case, the attorney for the plaintiffs, did not do what we have seen in some of these other high-profile cases where they double down. They double down and insist that that law is real and that they did their due diligence and so on and so forth, and just dig themselves a much deeper hole with their lack of candor to the tribunal and then their inability to substantiate the claims that they've made. This attorney did not do that. This attorney immediately, mea culpa, my bad. Yes, I relied on the AI. It was negligent of me. I should have double checked the citations. I didn't realize. I won't do it again. So I can respect taking responsibility for your mistake. Mistakes happen. People do try out shortcuts. Everybody is looking for more efficient ways to get things done. And if you mistakenly think these things are reliable, then yeah, it can happen. It's unfortunate. But it's really the worst thing is always to just try to cover it up, try to escape responsibility. Just step up and admit your mistake. And so this attorney did that. And as a result, it's not the end of the world. It's embarrassing, sure. Nobody likes their mistakes being out there in public, but it speaks to the person's integrity. Just that you go ahead and own up to it, and don't really dig in. Don't get your hole deeper trying to pretend that everything you did was legit and on the up and up when you're just never going to be able to back that up. So I'll be looking into that. We got a Koberger hearing coming up on Thursday as well. I will definitely be going live for that. That's Thursday at 10 o'clock Pacific time. I get to sleep in. Yay. Get to have a little bit of a normal day again. I'm not even sure what normal is anymore as far as my schedule. I'm waking up before the alarm. It's wild. Of course, I got this rooster now that's starting to make all this noise at about 4:15, 4:30 in the morning as soon as the sky starts to get slightly light. He's woken me up a few times. He's really come into his man voice, learned how to really announce the day. But 10 o'clock on Thursday, I'm not really expecting fireworks at this hearing, although I don't even know what to expect in this case anymore. Honestly, it's just been such a roller coaster, such a ride of fear and relief and expectations and disappointment and jaw-dropping WTFs. Like, the case has really been all over. But this is just a scheduling hearing, so for that reason, yeah, not really expecting massive fireworks as far as getting dates is concerned. But it is going to be interesting because part of the purpose of this hearing, they want to have scheduling for these defense motions that are being contemplated. And the defense has signaled this many, many times over the last several hearings that there are many motions coming, not just a motion to suppress, not just like one problem that they're going to go in and identify, but multiple. And we've heard some suggestions about what's at play in that. We've heard Brady has come up. We have heard Franks has come up. Franks is the case that concerns false information or misleading information in a probable cause affidavit supporting an arrest or a search. In this case, it would be the searches, because as we heard from the last time around when we were in court, we got that testimony from the cell site location expert, Cy Ray. It's not all that clear that the Moscow PD followed a legitimate process to locate Mr. Koberger digitally and place him where they really need him to be for him to be the perpetrator of these murders. So Frank's issues have been highlighted, forecast. And then there's so much that we still don't know, so much in the background that could relate to, for example, the investigative genetic genealogy. This is such a cutting edge issue in terms of both just factually what we heard in this particular case. Oh, the FBI routinely ignores the restrictions that people place on law enforcement access to their own data. They have all of these workarounds to be able to go into these databases and access the profiles of people who opted out, who said, I don't want my personal, highly detailed genetic information to be shared with law enforcement. And they're going in and getting it anyway. This is pretty novel. Just hearing about that in the first place was a little bit of a jaw dropper. It's the kind of thing that you might suspect, but to have a contractor who does this work for the FBI get on a stand and testify, yeah, they do it all the time. It's routine. Everybody knows how to do it. You don't expect to hear that. You really don't. So there's that lurking in the background of this case. We don't know for sure that happened, but there's a reason why they brought it up. There's certainly a suspicion that happened. And so if it did, yeah, that's a novel legal issue because it's one of those things we can all look at and think that that's a problem. That should be a problem. We should all be disturbed by that if that's happening. I'll be the first to tell people, I am not ever sending my DNA to any database. Not private, not public, none of it. I will not do it. That's just my personal preference when it comes to privacy and those types of things. You would like it to be confidential, but just no real guarantee that it will be. And even given the parameters that these companies have put in place right now, as far as just whether you consent, who they share it with, and so forth, those can be changed at any time. You're at the mercy of whoever you decide to share your DNA with. So personally, I'm not going to do it, but other people have, and people did it with the expectation that their preference, their privacy was going to be respected. This is just such an intrusion on a level that something like an STR identification profile that law enforcement uses, this is just, it's so much worse than that. Because these profiles that are used for investigative genetic genealogy that exist in these databases, these are the profiles that reveal who you are on a very fundamental biological level. What your ancestry is, a lot of your potential disease history, physical characteristics that you have, a lot of stuff about you. And the more we learn about the human genome and about genetic bases for all kinds of different things, like, I don't know, maybe personality, criminality, a lot of stuff in there that I don't think anybody submitted their DNA, to 23andMe expecting, oh yeah, anybody's going to be able to look at that and find out all about it. I don't think that was the plan. So it's really, really at a cutting edge from a legal standpoint, because there's a problem doctrinally with this, and that's standing. The problem is the way that we have interpreted these laws, these Fourth Amendment restrictions on law enforcement so far. Defendants don't get to complain about violations of other people's rights, only their own. So if it's not his own DNA in a database that's been wrongfully accessed, as far as the courts are concerned, it really isn't his business. It's not his business. And I think intuitively, people might appreciate that. That kind of seems wrong. It kind of seems wrong that law enforcement could go out and violate the privacy rights of millions of people, and then just use what they find, use the fruits of this pilfering against an accused. But that's what the law is. That's how it works right now. So the standing is a big problem from a legal standpoint, and that's going to require some creative kind of lawyering to get around that. There are potentially other arguments that can be made besides a Fourth Amendment violation. Due process is an option. Oh, I got to find my screen here. Conduct that shocks the conscience can be a violation of due process. So it's possible we'll get arguments like that. But it's a bit of an uphill battle. So these are the types of things that are potentially on the table for Brian Kohberger. Look at Jen McCabe just staring right at that camera. So here's the Albert family over there sitting with the O'Keefe family. Guess that tells us who believes who, doesn't it? So yep, there they all are. Carrie Roberts over there with them. For anybody who is wondering, there we have it. If you questioned whether anybody's mind was going to be changed by this trial, if the verdict comes back not guilty, I've been saying, guys, I hate to say it, but I'm going to say it again. What you're going to hear is the jury got it wrong. And the defense did all of this hocus pocus and magic and waved their hands. It's unfortunate. It's unfortunate because we saw for ourselves. We watched in good faith. We considered the evidence, and we have no stake in this outcome. We got no dog in the fight. It doesn't matter to me at all if Karen Read did it or did not do it. But it matters to me that she be proven to do it beyond a reasonable doubt if she's going to be labeled as a murderer and she's going to be punished as a murderer. That matters to me quite a bit. So it's unfortunate because this family has already been victimized by what happened. But you have a choice with how to react to that. You have a choice to be resilient, or you have a choice to continue to victimize yourself. I would like to see this family be resilient, and you do that by embracing the truth, embracing the facts, letting go of your biases and your preferences and what you really want to be the case. For whatever reason, they really want Karen to be guilty. I don't know if that's because of the relationship. I don't know if it's because of the friendships cultivated since John died. But I'm afraid that continuing to blame Karen, blame the system, blame the defense, blame the jurors, that's just choosing to re-victimize themselves. And I hate to see stuff like that. I really do, because it's not a good way to live. It's not a happy way to live. Oh, we're not going to stare at that fan, I'll tell you what. Nope, we're not going to start on day 31 with staring at that fan. So it is a little bit sad to see, but you know, I understand. I understand. It's a hard thing for people to come to terms with. Nobody wants to believe that something like this could happen, that law enforcement could be involved, that their son, their brother, their cousin, who was a law enforcement officer, that somebody in the same unit could be involved in something like this. One of his brothers, you know, if they have a high opinion of John and his profession, then there's probably going to be some halo effect like that on his coworkers. They would not want to believe that about other police officers. I understand. I really do. I get it. I saw last night, my old friend of the channel, Duty Ron and Ed Wallace had some things to say. They had some things to say about this investigation and these police officers. I was so glad to hear from them about this. I'm not somebody who's ever going to say like, oh, people have to cover a certain case or a certain topic or anything like that. Like, no, creators get to talk about what they want to talk about. It's entirely their choice. And if they had never spoken up about this case, I would support that. It's fine. That's their choice. They get to decide what they want to cover. But I got to tell you, I was so pleased that they did, because if there are guys in a position to criticize what we've been seeing here, yeah, it's those two. It's law enforcement, other law enforcement. This is good cops once again being our protection against bad cops. And it was very good to see Ed Wallace, of course, on Ron's channel. He's the CSA guy. He's a forensics expert. That's what his focus is on forensics. And I learn a lot from Ed, because you certainly learn about different techniques and things like that just in the course of different criminal cases. But there's always stuff out there that you just, you don't get exposed to. All the training that they've had, what they're told as far as what protocol is and how they're taught to do things. I don't necessarily know all that unless it comes up in a case. So I learn a lot from Ed. Last night was no exception. Ed talked about, well, okay, how how should you do a search in the snow under these kinds of inclement conditions? Should you be out there with a leaf blower? No, you do non-destructive search methods first. And so he described what he would do if this was his scene. He would go out there, he would set up his tent. They would do the grid sifting, which is what Lieutenant O'Hara kind of described happening. But then when we see those photographs, that's not what's happening. That's not what we're seeing documented in those photographs. We're seeing people shoveling the street is what we saw. So he described, yeah, you would go through, you would have your sifters, and you would carefully, sift out level by level and keep what's left, sort that, label it, mark it. That's how this stuff should have been done. And just as bewildered as I am with why did things go this badly in this case? Like, what is the excuse? What is the excuse for the complete failure to maintain a chain of custody of really any of this evidence? I can't think, is there a single piece of evidence that was properly handled? The plastic? No, left out unattended, booked in days later. Too many pieces in the wrong bag. The clothing? No, left out unattended 4 days before it's booked in. The taillight? It's sitting there in the conflicted Canton Police Department's Sally Port. Once again, for days. I mean, just almost nothing. The only thing that was really properly handled in all of this was John himself, John's remains. And why is it that I suspect that if these law enforcement investigators could have interfered with that, they would have. They would have. It's only the fact that the medical examiner goes and directly recovers him from the hospital. That's the only reason, because you don't think, with what we've seen, those guys would be above like taking a bat to his corpse, give him some broken bones, make it look a little bit more like a car accident. They were happy to do it to the taillight. We think they wouldn't do that to John? No, if they had had the opportunity, I believe they would have. And so as a result, that's the only real good evidence we got. And what is that evidence? What does that evidence show us? It shows us he wasn't hit by a car. Shows us he wasn't hit by a car. No, he looks like he got in a fight. Got in a fight, got his eye punched, got his nose punched. Fell over and cracked his head. And that was that. So I did. I appreciated that input from Duty Ron and from Ed, because it just goes back to what I've been saying about one of the aspects of the trial that's important. The reason why it's important for it to be public is that consensus building process. It's a group process to look at this and talk with each other and hear each other's perspectives. And through that, we can validate each other and recognize, no, we're not crazy. No, we're not bad people. No, we're not hurting anybody by looking for the truth. That's not what's going on here. And it's okay to not be gaslit. It's okay to not be manipulated, to just refuse. Say, no, I'm not going to let people guilt me into not talking about a case or not giving my sincere opinion. I'm not going to let people try to intimidate me into not having a sincere opinion about what I see. when all of us have our eyes on this and we're all seeing the same thing, yeah, that's very validating. It's very validating. And the counterpoint to that may give you some insight into why people who aren't seeing it that way are using the techniques that they're using. Because they aren't validated. And when you're not validated, what happens? You get angry. You lash out. You have all this cognitive dissonance going on where you have to come up with increasingly bizarre explanations to defend your worldview and your interpretation. I think it was Scott Adams way back. I don't love Scott Adams or anything like that, but he's said some things that have resonated with me that I found very insightful. And one of them that I did like very much is the cognitive dissonance tell. The cognitive dissonance tell is when there's like 1,000 explanations for something. Simple truths have simple explanations. It doesn't require a whole dissertation and a whole bunch of different reasons and this and this and this and this and this. It's a tell that your mind is generating justifications for where it already wants to go. So yeah, all these explanations, and yet at the same time, the willful blindness, right? These interpretations of the evidence that are willfully blind to the things that undermine it. The fact that it doesn't matter what Karen Read said, doesn't matter who she fought with, doesn't matter even if she's a likable person. Maybe people don't like Karen. Maybe people do think she's a whack job. It doesn't matter if she didn't hit him with the car. So I am glad. I'm glad that to the extent that's going to come to an end, it is coming to an end. Is it going to come to an end though? It didn't come to an end with Amber Heard, did it? Nope. The whole defending her with their whole chest in spite of everything that we saw unfold in that courtroom. All of the problems with the accusations, the way she just shamelessly lied to our faces. People still out there defend Amber Heard with their whole chests. Yeah, we could get the same thing here. We could. I mean, like we said, if the explanation is going to be the jury got it wrong, the defense was unethical and did this voodoo magic and cast a spell and made things look like something they aren't. If that's your perspective, it's how are you ever going to come off that? Because you're not accepting the reality. Okay. The defense did not create Lucky Loughran. The defense did not create these FBI witnesses. The defense did not create two different pathologists saying those are dog bites on his arm. The defense didn't create the phone data and the butt dials. The defense didn't conjure that up. The defense didn't conjure up their group chats where on the one face they're showing to the public they're so deeply concerned about this investigation, want to get to the bottom of it, their dear friend John O'Keefe. And with the other face, the ones that they're not showing to the world, that face is saying that if the investigators don't ask the right questions, it's on them. It's on them. So it is unfortunate, I think, that you would like a trial to finally and fully resolve all of this stuff. You would like it to be a way for everybody to see the light. But, justice is not perfect by any stretch of the imagination. And part of that is because it involves humans. And we humans are very, very far from perfect. We're very far from perfect. So if your hope is that this verdict is going to be the final word and you'll never hear anybody accusing Karen Read of being a murderer again, it's not going to happen. It's not going to happen. Hate to be the bearer of bad news there, but it's not going to happen. It's not how people work. There will very likely be an overwhelming consensus against that position, but there will always be voices out there that will point the finger, that will continue to maintain the accusation, and that's why an accusation is life-changing, even when it's not true. Even when it's not true, you never go back to who you were before. You never go back to the world you lived in before, because there are always going to be people that accept it, that buy into it, that advocate for it, that support it. So I'm seeing that the reason why the camera is up at sidebar is because there was a issue with a juror being called up. Don't like to hear that at this stage. So close to the end. We're so close to the end. We do not want problems with the jury. Takes a lot for there to be a mistrial. So not gonna get too concerned about that at an early stage without more information. But yeah, just pull this up right now. Absolutely. Kyle Rittenhouse went to trial. The people that watched a trial saw exactly what happened, saw how he reacted, saw the threat that he faced, and yet all kinds of people out there still absolutely adamant Kyle Rittenhouse is some murderer. Not just a kid who was out defending himself against a very obvious lethal threat. Well, I guess if we're waiting, we'll go ahead and go through some of your chats now. So Bobby Walter says Lally is going to close saying he saw Karen do it. That would be against those rules that we looked at yesterday. The limitations they have on closing argument, what's proper and improper. Facts not in evidence, and his own personal opinion. Yeah, I won't get to do that, but I gotta say, I can't say I have a lot of faith that he isn't going to try to walk the line of propriety very, very closely. I would just be lying if I said that. I'm one of the reasons I'm concerned about this consciousness of guilt instruction that's been proposed is that I wouldn't trust them to not try to argue that her contacting David Yannetti, having those communications with counsel on her phone, was consciousness of guilt. I wouldn't trust them not to do that. Just because it wasn't part of their argument doesn't mean that they wouldn't try. And so it's one of those things that, the defense would have to object to it. And then, there'd have to be some kind of instruction to the jury, disregard that. You're not allowed to draw that inference, but they've already heard it. The damage is done. And that's part of the problem when you have prosecutors who aren't motivated to be ethical, when that isn't part of what drives them in how they do their jobs, then that's all they care about is how many times they can ring the bell. It doesn't matter if it's fair or not. It just matters if they're going to suffer consequences for it. And we have not seen an awful lot of consequences on the prosecutors coming from this bench. Arla 7247 didn't investigate because they knew what happens. I mean, we're left with that conclusion, aren't we? I don't have a good, it's just, this is too much incompetence. As much as I tend to support Hanlon's razor, never attribute to malice what can be adequately explained by incompetence. I don't think that this can all be explained by incompetence. I just don't. There's too much, too many people, too many mistakes, and no excuse given this context. No excuse given this context to not, at the very least, button up the evidence and secure it. There's just no excuse for that. So unfortunately, yeah, that leaves us with the explanation, well, it's malicious. They did it on purpose because they needed to tank the investigation. Nobody wants to believe that, but that's kind of where we're stuck at this point. That's where the evidence has led us. Very unfortunate. Asian attack. Explanations are for chumps. Assertions are where it's at. Well, we're going to get those. We're going to get conclusory assertions from Mr. Lally. I don't doubt it at all. They're not going to, they're not going to go to any great length to support their assertions, to try to get the jury to believe them, because they just can't. Are there any facts that are really untainted, that are free of challenge by the defense? There's really not a lot. I hit him. They deny that she said that. They point to all the different contexts where it got reported, the fact that it didn't show up in any of the early reports, the way that it evolved, and the different stories that the people who report hearing it have for when and how they heard it. The fact that other people said they heard her saying, did I hit him? Could I have hit him? So I hit him is not a given, right? They got to justify, why should we believe that she said that and not one of the other things that was reported? Why should we not agree that memory is a funny thing? And it's not in the report. It didn't happen. The taillight's very much in question. Very much in question. Alan Jackson has signaled he's going to be showing the jury the taillight. That's going to be a big part of his closing, the visual, showing the side-by-sides of the taillight. Yeah, definitely not a gimme for the Commonwealth. And even Aruba, right? Even if we did take the Commonwealth's witnesses at face value, even if we didn't have to question, wow, why are you so hostile to her after all this time, when your big complaint was that she paid for too much of your stuff? It kind of raises my eyebrow. But even if we take that at face value, Karen thought John kissed Marietta, but she was just mistaken. It doesn't matter. It doesn't matter. She had plenty of reasons to be upset with John, notwithstanding any of that. Right? And it doesn't matter anyway. It doesn't matter if she was upset with John, if she couldn't have hit him with the car. So I guess it's being reported from the courtroom that the sidebar has concluded, but the judge has left the room. So we're all waiting on pins and needles to see what all of this means. Gen X chick, love that name. Hey girl, I see you. All of these talking heads are talking about how the O'Keeffes are going to immediately file a wrongful death lawsuit, and they'll win because the proof is so much lower. I would hate to see Karen have to go through this. I don't know what the statute of limitations is for a wrongful death lawsuit in Massachusetts. I would have to look that up. It's been over 2 years. So not 100% sure that would, be on the table, but it could be. I Yes, the burden of proof is lower. A lot of this work has been done for her, though, and the side issue, the potential risk of doing that is the possibility that Karen would be able to interplead. She would be able to cross-claim against the McCabe's, against the Alberts, against anybody else who was involved in potentially framing her, building this case against her, lying about her, fabricating evidence about her. Two can play that game. And Karen, Karen has spent a lot of her war chest on this case. There's no question about that. She's had to have a big war chest to spend on this case. But she had a fundraiser, crowdfunded assistance that raised quite a bit of money. Last I saw, over $300,000. So that would help. I don't know what resources she has, but she seems to be pretty well off. She's been a successful professional. She's a single woman, doesn't have kids. Makes it real easy to live a lot more cheaply, not having the kids. So she dresses very well in these very nice clothes. She drives a nice car. She picks up the tab for people all the time. Do the O'Keeffes have resources like that? Because you don't get insurance to pay for you to sue somebody. You don't get a lawsuit for that. You pay to be a plaintiff yourself. Karen could potentially have insurance to cover something like that. Auto insurance, homeowners insurance, business insurance. There's like a lot of different kinds of insurance that will have riders on them that cover like surprising things you might not expect. I remember how shocked people were to find out that Amber Heard's homeowners insurance included defamation coverage. Yeah, it does. It's pretty common. So Karen could have assistance in that battle where the O'Keeffes would be on their own. So yeah, it's just a question of do they want more? Do they want more? I've talked before about my perspective on the likelihood that a contingency attorney would take this up. I don't think that's likely. I don't. It's too high risk. Contingency lawyers like cases where liability is clear and the only thing that we're really arguing about is damages. And so you get in a car accident, you have a police report where the other person got cited or something, you're going to have a very easy time getting a lawyer because there's that independent investigation that establishes the other person is liable. They did something that violated the traffic rules, and that tends to be negligence per se. So then all you're really arguing about is how much are you entitled to for your reward. That makes it a very low risk proposition for someone to say, yeah, I'll take this case and I'll take a cut of whatever the eventual payout is. When the eventual payout can be zero and the potential costs can be very high, it's going to be a lot harder to find somebody who's willing to take on that kind of risk. And then the other side of that, the person who is willing to take on that risk, you don't always want that person as your lawyer. All right, let's see what we get here now. Tell us what's going on. So all we know is it's a potential juror issue is what's being reported. I'm sure there's a gazillion rumors because there always are, but we just don't know. I did find it quite strange to learn that the judge picks the foreperson in Massachusetts. That's bizarre to me. Had never really occurred to me that it would be done that way. Where I'm at, everywhere I've been, everywhere I've practiced, everywhere I've seen, the jury chooses their own foreperson. And that seems to me to be conducive to a good deliberation, because they choose who they perceive to be a leader, who they perceive to be able to negotiate through the deliberation process for them. The judge, what's she choosing based on? I don't know. Seems very weird. Seems very weird. Seems like there's an opportunity to, I don't know, sabotage a bit. They've had all of these weeks to observe the jurors and their interactions and kind of who hangs out with who, that type of thing. Who goes to lunch together, who chit-chats together, who shows up in the morning together. Opportunity to pick someone that's a really bad fit for that role. Not saying she's going to, it just, why would you have that as a possibility? It seems quite strange to me. Joe says the idea is that the bossiest person doesn't become foreman. I guess. I mean, I don't know what her selection criteria is. I don't know if maybe she is going to choose the bossy person because she thinks, that one's going to be able to bully them into a fast verdict before July 4th so my holiday plans don't get disrupted. I don't know what her selection criteria is. I guess at least in theory, the vote is supposed to be a check against that. Right? Just because somebody wants power doesn't mean they're going to be able to accumulate the votes to get it. It's supposed to be one of the upsides of a democratic process. But I could see, yes, I could see where somebody who has a strong personality, who really wants it, you have people that don't have such strong personalities, or perhaps maybe are even inclined to appease others, would find it easier to just go along with what that person wants and not rock the boat. Oops. Yuki Roma saying, concerned that Canton has a population of only 24,000 and worried the animals being in the gallery will intimidate the jury. I mean, they do have a right to be there. Now that the evidence is closed, they have a right to be there. It's not like the jury didn't know that they're involved. Didn't know that the spotlight of suspicion has been trained directly on them. But yeah, it could be just that little extra bit of, the thumb on the scale, seeing them actually there watching. Because now we're expecting they'll be there for the verdict too. They'll be there for the verdict too. They'll be eyeballing those jurors as the verdict is returned, and they're going to know that. It is concerning, but that's the process. It is. And you just gotta hope and pray that the jury takes its oath seriously. They usually do. The jurors usually take that responsibility very seriously. I do believe that. And aren't going to be swayed. We gotta hope. I would love to see Lucky in the jury, in the jury box over with, not in the jury box, over in the witness side. No, that would be bad. But just as a reminder to the people on the jury that, yeah, this is what bravery looks like. How many of the Alberts does he know? All of them. All of them. Grew up with them. Still got up on that stand and said what he knew. And maybe Alan Jackson will remind them of that in his closing. We'll have to see. Bird says, is Lally doing clothes? Thought his assistant was doing. I am expecting Lally to do it, and that the assistant just handled the legal side of the jury instructions, like she's been handling the legal sides of the briefing and stuff so far, the motions that have been filed. That seems to be the role that she has taken in this trial, is like their research and writing assistant, basically. She hasn't said a word with the jury in the room, you know, throughout this whole process. So I would be pretty surprised if they decided to shift gears suddenly right now and have her deliver the closing. I think it will be Mr. Lally, but we'll see. There's no guarantee. They can change their mind. Absolutely. Lori J, if the frame doesn't fit, you must acquit. It doesn't fit. Doesn't fit. No matter what they wanted to do, they could not make him look like he was hit by a car, and that's the ultimate problem here. That's the thing that it's hard to get over. More to the fan. Not going to stare at that. Arla 7247, Sally Port made me 100% convinced. That's what shows the malice in my perspective. It's just I have a hard time coming up with an explanation for how that was just an accident, or it was just incidental that it got produced that way. It wasn't an intentional act to try to deceive the jury, because they would have told us straight up from the beginning, by the way, this looks weird, but it's actually the driver's side door. This is actually a mirror image. They would have told us that from the outset if their interest was in being honest and forthcoming and direct. So the fact they didn't do that, and they went through the entire song and dance of watching it, describing what we're seeing, and never once mentioned, this isn't what it looks like. It's actually the opposite of what you think it is. That tells me they wanted me to be deceived. It's a lie by omission. You didn't tell me what I needed to know to be able to understand what it is that you're showing me. So if I'm the jury, you've lost me at that point. How am I to have faith in you? The defense had to call it out. The defense has been who I've been able to rely on throughout this entire trial to not only give me commitments in their opening statement about what the case is going to look like and what the evidence is going to show, but then follow up on them. Live up to those commitments that they made. I've been able to count on the defense to bring this stuff to light. I haven't been able to count on the Commonwealth. They put the witnesses on the stand, and then they don't ask them about the butt dials, the bad stuff. If it's not for the defense, the jury isn't hearing any of that. So yeah, the Sally Port really just drew a line under that, under the problems with what just looks like bad faith on the part of the investigators and on the part of the prosecutor. It looks like bad faith. And if I'm the jury, yeah, I'm not forgetting that. Snoozy Girl, my prediction, defense will mirror the drama of their opening by starting their close with the C word and other quotes from Proctor. I kind of hope they don't. I'm sick of getting demonetized. I've gotten like demonetized just about every day since Proctor was on. It gets reversed sometimes, but like it's too late. It doesn't matter. The process takes too long. Everybody's already watched the video at that point. So I would prefer it if he would maybe lay off the C word a little bit. But I would think if they want to mirror their opening, they're going to go back to that very first statement they made. Karen Read was framed. We told you Karen Read was framed, and now we've shown you that Karen Read was framed. And she was framed by those people sitting over there in the witness stand. not in the witness stand, over in the audience. No, he probably can't do that. It wouldn't be good taste to do that. But something along those lines. And that would mirror the drama, and then walk us through how she was framed. Show us the taillight. Show us the taillight. Here's how we know she was framed. John didn't die as a result of a car accident. He was never hit by a car. That's the bottom line here. And then look what they did to frame her. Look at this taillight. Look at this taillight. Anspan 65. Hi, Andrea. Will Bev cut off Lally if he goes over? I certainly hope so. I mean, what's the point of having rules and limits if they're going to just blow past them? But maybe she would wait for the defense to object. I don't know. But I would hope that she would. If she is going to set a limit on the time that they have to make their arguments, then it's kind of her authority, right? That's on the line, that's at stake. And if nothing else, I feel like she would want to police that. It makes her look bad if he's ignoring the restrictions that she put on it. So I think she would. James Cassatelli, this case has inspired me to get more involved with our judicial system to try and prevent these sorts of things from happening in the future. How can I get started without going to law school in my 40s? Boy, what a great motivation that you have here. If anybody is interested in getting involved in their local justice system, one of the things I would recommend as an entry point that anybody can do, anybody can volunteer, is a CASA. CASA is a nationwide program. It's court-appointed special advocates is what that stands for. And CASAs are typically appointed to represent, to work with children, to communicate with children who are involved in the legal process, help support them through that. So these are often children that are going through the foster system. They've been removed from their home. There's some kind of dysfunction that's going on in the family that, sometimes parents are in jail. Sometimes their parents have addiction problems. Just sometimes it's abuse. There can be all kinds of issues that come up, and these children are the victims of that. And it's the problem, though, is that the removal process itself is also very traumatizing to these children. So one of the factors that can help children be resilient and recover from having adverse childhood experiences, things like being removed from the home and in-home conflict and stuff like that, is having good adult role models, having adults that they can trust and that they can rely on. So the CASA plays a really important role in that process of just helping to understand what is the family dynamic here, what does the child want, are the parents motivated to improve, or are they, too far down the road of their addiction? Just things like that. CASAs tend to be, their perspective is valued by the court because these are people that didn't have to, they, again, don't have a dog in the fight. They don't have to get involved. They're choosing to participate because they care. So I definitely recommend that. It's a very important role to play, but it also is a good foot in the door. You will get to know who the participants are in your local court system. You'll get to know the judges. You'll get to know the prosecutors. You'll get to know the defense attorneys. If you're in a small community like I am, you get to know the clientele. Like there's a lot of overlap with who shows up in court and who's related to who and who's friends with who and all that type of thing. So that would be my recommendation, short of going to law school and taking on like a whole new career path. Consider volunteering as a CASA. It's very important work. It's badly needed, and it can make a real difference for the kids involved. Carazola X, just got in, but I knew exactly what you were talking about, LOL. That ME said that Michael Brown didn't have any signs of struggle, also defended OJ. I mean, it's just, there's once a narrative is set, once a narrative about a case is set, it's extremely difficult. It's extremely difficult to shake it. It's just very, very difficult to shake it. I read everything there was about Michael Brown. I read the Department of Justice investigation. I read the grand jury stuff. I read it all. And, I mean, if you're going to try to grab a cop's gun, there's going to be consequences for that. Nobody likes it. Nobody likes when somebody gets shot and killed by police. But sometimes it's justified. Sometimes it is. One of my big, kind of becoming aware of the disconnect between narrative and reality in criminal cases and in the media was the George Zimmerman trial with Trayvon Martin. Another one. I couldn't watch the entire thing. I watched a lot of it and I followed the live tweeting on that one, got as much information as I could about what was going on. That was when I first encountered Andrew Branca, Law of Self-Defense. He covered that case from the courtroom. And it was my first kind of awareness. Oh yeah, lawyers can do that. And it's actually quite helpful to have lawyers in the courtroom paying attention to what's happening. Because the narrative was just so far off from what the evidence in court was unfolding to be. And I found that to be very frustrating because clearly I'm somebody who cares a lot about the racial issues that just unquestionably exist in our criminal justice system. At every single stage of the process, there is disparity that cannot be accounted for by difference in perpetration. It's not that people involved are trying to be racist, but there is just something about the process and how different people get treated differently that accumulates at every point where there's discretionary opportunities and results in more convictions, worse punishment, worse outcomes, less lenience, just all of that type of thing. So I care very much about these issues, and it's so troublesome to me to see these narratives that are not based in reality, that are kind of driving that conversation. It seems to me to be increasing the polarization because it's so easy to look at these cases and be like, well, that case is bullshit, therefore the entire problem is bullshit. The entire problem is not bullshit. It's really not. These are just really bad examples that are being seized on to further narratives. So Turtle Boy, I guess, is reporting that Juror 3 has been dismissed. Don't know what that's about. But looks like we're coming back.
For the Honorable Beverly Cannoni, Justice of the Norfolk Superior Court in the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
22-117, the Commonwealth versus Karen Reed.
All right, good morning again, counsel. Good morning, Ms. Reed. Good morning, jurors. I don't know how many times I start in the morning by saying we appreciate your patience, but today is one of those days. Again, we appreciate your patience. You may notice that one of your fellow jurors is not sitting with us today. I can assure you that that is because of an issue that is just personal to that juror and has nothing to do with any concern of any of you. So please disregard.
So no mistrial, at least.
I do have to ask you those 3 questions. Were you able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here yesterday? So now we're at the point of the trial where the lawyers get to do their closing arguments for you. I've given them each an hour to do so, and they both tell me that they want me to give a 5-minute warning. I just don't want you to think I'm scolding them when I give a 5-minute warning, so we'll let them do that. When I was a trial lawyer, I tried a lot of cases in this courtroom. The thing I liked least about the trial was just before I stood up to give my closing argument, the judge would say, jurors, remember, closing arguments are not evidence. but it's true. So because of that, you have to put your notebooks away. All right, so if you just put your notebooks away and just listen, and though the closing arguments are not evidence, they're certainly a very important part of the case. And you've all seen how hard the lawyers have worked for this long period of time. And we've all noticed that you've paid great attention throughout the entire trial. I'd ask that you extend your courtesy to the closing arguments. And in Massachusetts, because the Commonwealth has the burden of proof, the Commonwealth goes last. So we will hear now from Mr. Jackson.
So we do hear from defense first. How weird. What a weird system.
Thank you, Your Honor. Look the other way. Look the other way. 4 words that sum up the Commonwealth's entire case. 4 words that sum up the hopes of those who have tried to deceive you. Conflicts of interest? Doesn't matter. Just look the other way. Magic hairs, magic glass. Look the other way. Late night calls and Google searches, falsified affidavits, inverted videos, and butt dials galore. Just look the other way. That's what they want. That's what they're counting on, but the uncontrovertible fact is you have been lied to in this courtroom. And your job is to make sure you don't ever look the other way. Your singular duty is to stare down the evidence and do it unflinchingly and do it unwaveringly. You see, you're the only thing standing between Karen Reed and the tyranny of injustice. It's a job you didn't ask for, probably a job you didn't want, but it's the greatest responsibility we have as citizens here in America. Lest the government stop answering to us and we start answering to the government. And low betide any one of us who might find ourselves in the crosshairs of a Michael Proctor. Preparing for today, I was reminded of a quote. It's a quote about the truth, and I want to share it with you. It is of great importance to set a resolution never to tell an untruth. There is no vice so mean, so pitiful, so contemptible, and those who permit themselves to tell a lie once find it much easier to do it a second time and a third. This falsehood of the tongue leads to that of the heart, and in time, it depraves all its good dispositions. What does that mean? It means that it's been observed that to tell an untruth, to exaggerate, to make a false claim, it's a cancer. One lie begets another, and it's a malignancy that grows over time. And that, folks, is how a cover-up is born. That's how a Massachusetts state trooper says in whispered tones to his friends when he thought no one was looking or listening, how he would make a case, how he would make it cut and dry, no matter the truth, how he would make sure to put, quote, serious charges on the girl. In other words, pin it on the girl. You may ask yourself, how does this happen? How could this happen? It's 2024. Surely people aren't going to come to this courtroom, this hall of justice, and lie to us, just give us false information. They wouldn't do that. They wouldn't try to cover up the truth. The Alberts, the McCabe's, Higgins, Lank, Michael Proctor, Yuri Buchanan, Brian Tully. You don't have to wonder if they would lie to support their narrative. You need only wonder how many times they did lie. Over and over and over. They and others were caught deceiving you. Big things, small things. It didn't really matter. They feared nothing. They'll look you in the eye and deny phone calls. They'll deny secret meetings. They'll claim that calls are butt dials and butt dials are answered. They'll show you a video and tell you left is right and right is left. They'll magically turn 3 pieces of plastic into 5 right before your eyes. And even when they're caught with their own lies, they won't blink, they don't sweat. They'll just look you in the eye and demand, pay no attention. You folks look the other way. Ladies and gentlemen, there was a cover-up in this case, plain and simple. You'll surely say to yourself, I don't want to believe it. I don't want to believe that could happen in our community. But sadly, over the past 8 weeks, you've seen it right before your eyes. So how does a cover-up happen? How could that happen? Well, let's count the ways, shall we? Handpick your investigator. Make sure it's someone we know, someone on our side. Keep him close. Offer him help. Offer him a gift. Have secret friends and family meetings. Get your story straight. Delete your call history. Make mysterious phone calls at 2:22 a.m. Delete Google searches. Monitor police activity. Get rid of evidence. Get rid of your dog. Destroy your phones. Destroy your SIM card. For the investigator, decide on a narrative early on. Don't go to the crime scene. Don't take witnesses in for questioning. Question all the witnesses together. Ignore witnesses who don't fit your narrative. Allow friends and family to contact those same witnesses. Don't record interviews. Write vague and false police reports. Omit witnesses' names. Omit witnesses' interviews altogether. Don't photograph the evidence. Don't conduct any forensics. Don't document the evidence. Don't document the logs. Don't create any logs whatsoever, and don't maintain a chain of custody. Keep all the evidence in the hands of one person and then manipulate that evidence, including videos. Don't turn over videos. Invert videos. Turn 4:16 p.m. into 5:30 p.m. in affidavits. Turn 3 pieces of taillight into 5 pieces of taillight. Delete 42 minutes of surveillance footage. Hide personal relationships. Make this case cut and dry and ensure the homeowner, quote, never sees any shit because he's a Boston cop. But most importantly, pick your patsy and pin it on the girl. It's not that it could happen. It's that every single one of those things I just mentioned did happen right in front of you. But this sort of injustice can't happen in a vacuum. So what about the prosecution? What about the Commonwealth? What does it look like when the government picks a narrative and then tries to form a prosecution around the narrative instead of the other way around? Looks a lot like this. If you don't have actual evidence, just throw every single thing you can against the wall to see what sticks. Drag her through the mud and make sure you attack her character. And that's what you saw in this case. The Commonwealth spent much of their time and resources trying to vilify Karen Read. They desperately resorted to calling witnesses to talk about Karen Read and John O'Keefe's arguments. They even stooped so low as to call the children and put them through this ordeal. All to say that John sometimes got upset because Karen was too kind, too nice, spoiled them too much. Their arguments illustrated what anybody could imagine is a normal set of ups and downs for any couple. Even on January 28th, they talked it out, they communicated, they worked out their issues, and they had a nice, affectionate evening out with their friends. And you don't have to take my word for it. Pull the tape, as they say. Look at the videos. C.F. McCarthy, Waterfall. What are the words that every single person who testified in this case used about Karen Read and John O'Keefe that night? Getting along, no issues, good mood, happy, affectionate, even lovey-dovey. No issues, no toxicity. They were a loving couple right up until the time Karen Read dropped him off and he walked into 34 Fairview. If an argument with a loved one is a motive for murder, folks, we're all in trouble. Speaking of which, what is the evidence that John went into the house? The Commonwealth will tell you, undoubtedly, no, he never went in the house. And they'll point to certain witnesses who they say didn't see him go in. Well, the question you have to ask yourself is, can you rely on that? First, these are all people who are related to or committed to the Alberts in some way or another. That all-powerful Canton family, it's easy to say, I didn't see something, because how can that really be challenged? Some actually may not have seen John walk into the house. They were in the kitchen, as you recall, from Nicole. Third, at least one witness, Brian Higgins, forgot his narrative, at least for a second, and he admitted a man did, in fact, come into the house. And when he was caught and asked to describe that man, he had to. It was a little bit vague. You remember what he said. He was tall with dark hair. That was a telling slip of the tongue by Brian Higgins. But what's the real evidence of the unbiased data, the data that's not connected to the Albert family? How about John's Apple Health data? It shows that at 12:21 a.m., an important time, John arrived. That's established by the monotonic time clock that you heard about in this trial. It was on his phone, and that represents a huge problem for the Commonwealth. It shows that he took 80 steps and ascended or descended 3 flights of stairs at that time. And that makes perfect sense, doesn't it? It matches. Walks into the house, goes directly to the basement. There's your 80 steps and your descending flights of stairs. The big problem for the Commonwealth is he wasn't outside at the car ascending and descending stairs, wasn't climbing on top of the car. So they'll tell you, wait, don't look at the Apple Health data, look at this other thing called Waze. But Rick Green explained that if you apply the 3-minute offset that is built into that monotonic time, it aligns perfectly. They don't want you to see that. They don't want you to pay attention. They want you to look the other way. But even more importantly, at approximately 12:32 a.m., someone holding John's phone takes another 36 steps and travels 25 meters. Why is that so important? Because by 12:32 a.m., Karen Reed was gone. She had already left the location. She left at 12:30. Trooper Garino told you that Karen Reed's phone connected to John's Wi-Fi at what time? 12:36. It is undisputed in this case that it's a 6-minute drive on a good day from 34 Fairview over to One Meadows. She was gone by 12:30, and John's phone was taking 36 steps and logging 25 meters at 12:32 after she left. So don't be fooled. John walked into that house, after which Karen drove away, and the scientific data all prove it. But also, Ryan Nagel and Heather Maxson prove it. In addition to the Apple Health data, Ryan and Heather both independently testified that they passed Karen's SUV as they drove away after talking to Julie. And Karen was alone in the SUV. John was not with her. He wasn't in the car. He wasn't standing outside the car. He wasn't sitting beside the car. He wasn't laying on the ground beside the car. He was nowhere in sight. There's only one other place that John could have been, and that's in the house. Exactly where the Apple Health data places him. So it all fits. And Ryan was right behind her, remember, staring at her taillights, undamaged, brightly lit. That brings up another difficulty for the Commonwealth, and that's their star witness, Jennifer McCabe. You'll recall that Jennifer McCabe claimed that she was looking out the door, staring at that SUV over and over and over again from 12:29 to 12:50. She was very specific about that time frame. But we know that the SUV was gone from 34 Fairview by about 12:30. Had to be in order to connect to the Wi-Fi at 12:36. So unequivocally, Jennifer McCabe was lying about watching that SUV, and it makes you wonder why. And to add to that deceit, she was also blatantly lying about the calls to John's phone. You remember that colloquy back and forth. She said that every single one of those calls to John's phone during that time was a butt dial. How are those lies connected? And why are they connected? Jennifer McCabe knows. Was she butt dialing John over and over? Or was someone looking for John's phone that went missing? Let's talk for a second about what actually happened in the time leading up to everyone going to 34 Fairview. Brian Albert, Brian Higgins show up drunk at the waterfall. They'd been drinking in the afternoon. You know about the flirtatious texts that were sent between Karen Reed and Brian. Higgins was clearly pining over Karen, but for her, the flirtation had ran its course. It was done. She was happy and committed to John. You can see that in her actions with John that night. You don't have to guess. Brian Higgins, however, you can see in his actions, he wasn't quite so satisfied and he wasn't done. His text message, well, meaning, what the hell, Karen? What about me? Seemed aggressive, seemed annoyed. He didn't like being ignored. That was pretty clear. So he's 5 or 6 whiskeys deep into the night by this time, and she continued to ignore him. Then oddly, Higgins, who doesn't know John all that well, seems to want to coax John to 34 Fairview. I draw your attention to the waterfall tape if you want to take another look at it. It's at the 11:57 mark, between 11:57 and 11:58. Take a look at that tape. He's just about to leave. Higgins is just about to leave. He points over at John and he motions for him. Come on, come with me. And then at 12:20, he texts him, "You coming here?" This is a person he doesn't really know and didn't really talk to that entire night. Ask yourself, why was Higgins so insistent that John go to 34 Fairview that night? And then there's that sparring and fighting that he and Brian Albert were engaged in. Of all the things they could be doing, this is what they were doing just minutes before John O'Keefe walked into that house at 34 Fairview. We know that once John actually did walk in the door, it's about 2 steps, 4 feet or so, 2 steps for an adult male to reach that basement door. Remember, everybody was gathered in the kitchen. That's what Nicole Albert said. And every single witness agreed that at some point, Brian Higgins and Brian Albert left the group and went to another room. Where did they go? Where did they go together? Another important point. Chloe was not upstairs. Brian Albert slipped in one of his testimony that he provided. Quote, "I was watching Chloe downstairs, monitoring her because of the other people in the house. She's not good with strangers." Remember that testimony. So what happened next? We absolutely know that John was in the house. The data, Ryan, Heather, they all established that. We know that John ascended or descended stairs. We know that Brian Higgins and Brian Albert excused themselves. How long does it take to have a crossword? How long does it take to have a fight? How long would it take for Brian Higgins to say to John, "You know, your girl's been texting me"? A push, a punch, a fall, pull Chloe off his arm, and now it's done. What is that? 5 seconds? 10? Doesn't take long at all. And then the panic sets in. It wasn't intended to go that far, but what's done is done. And then some very, very odd things start happening at the Albert household. Very odd indeed. What do we know? We know through the testimony and key swipes that Brian Higgins very oddly goes directly to Canton Police Department. Why would he do that? After a night of drinking and partying, why go to CPD when you're drunk? What was so important there? He couldn't even get his own story straight. First he said it was administrative work, then he said he was moving cars, then he said it was a factor of both. Is it both? Was it neither? Or was he there to gather intel? Ask yourself, why go? But the odd things keep piling up, and here's another. Chloe was the Albert family pet. Not only did she appear to be gone from the house that morning on January 29th, nobody saw her there. Even Jim McCabe admitted that I didn't see her there. But they actually got rid of the dog altogether. Within months of this incident, the dog was gone, out of the house, rehomed, never to be seen again. This was a dog they had had for 7 years. Also a dog who had a bite history. Why was it so important to get rid of that dog? Was there something about the dog they did not want law enforcement to find out? Recall what Dr. Russell said. She's seen up to 1,000 animal attacks. In her expert opinion, John's right arm, those injuries are from an animal, quote, most likely a large dog. And Dr. Russell's testimony, I'll remind you, was undisputed by any witness for the Commonwealth. But there are more odd and unexplained things. After a night of drinking and hanging out and partying, after being together for the entire day, at 2:22 a.m., Brian Albert decides to call Brian Higgins. That call was missed, but 17 seconds later, Higgins calls Brian back, and they speak for 22 seconds. Now that call is odd and suspicious enough, and just in and of itself, the fact that the call was made. But what's even more incriminating is that both men, both of them, lied about the calls happening. They both claim astonishingly that those calls are, you probably say it with me, they're butt dials. Amazing. But Albert and Higgins take it a step further. Not only did they claim that they were making calls as butt dials, but they were answering calls as butt dials. And Higgins seemed awfully defensive about that call, didn't he? Remember on cross-examination when I was asking him, can you have a conversation in 22 seconds? He unequivocally said, no, that's impossible. It's not reasonable. You can't do it. Well, let's test that out. Hey, did you make it over to Canton? Yep. Haven't been any calls. Nobody knows a thing. All right, don't talk to anybody until we talk again. Okay, fine. And by the way, come back over. I need help moving something heavy. How long did that take? 15 seconds? Maybe? But the odd behavior isn't done yet. 5 minutes after that call that we just talked about, Jennifer McCabe is on her phone at her house, Google searching how long it takes for someone to die in the cold. That was at 2:27 a.m. That timeline seems to fit, doesn't it? And it fits a very telling and a very clear story. That search became a focal point of the Commonwealth's entire case. This case was starting to look a lot more like the defense of Jennifer McCabe than anything else.
Mm-hmm.
That's probably because there is no innocent explanation for that Google search at 2:27 a.m. None. At the end of the day, clearing away all the confusion, the Commonwealth's experts were left with two things that are true. First, neither of their experts could absolutely rule out that Jennifer McCabe made that search at 2:27 a.m. Neither. And second, the only person to use the actual phone model, the actual data, and the actual precise operating system was Rick Green. And he was clear. That search was at or before 2:27 a.m. And then it was deleted. So what else was going on at or around this same time when all this suspicious activity was happening at the Albert house and the McCabe house? 3 minutes after that search and 8 minutes after the Albert Higgins 2:22 a.m. call, Brian Loughran drives down the street in his snowplow. And he told you that there is no body laying on the lawn at 34 Fairview at 2:30 in the morning. Importantly, he didn't just simply say he didn't see a body, he wasn't paying attention. He said there was no body there. He knows the property, he knows the owners, he's grown up with these folks, he passes by all the time, not once, not twice, 3 passes. There was no body on that lawn, period, at 2:30 a.m. And what other suspicious thing happened that night? By 3:30 a.m., someone moved a Ford Edge in front of the very area that would obstruct the view of where John's body would ultimately be discovered. Who's the only person in this case that you've heard about with a Ford Edge? Brian Albert. Remember, as you're thinking about this, the basement at 34 Fairview is serviced by a bulkhead. It's a quick and convenient door to the backyard. And that backyard is serviced by a side fence. And that side fence is easily accessible to the front yard at the side of the house. Which side of the house? The side where John's body was found. And by 6 a.m., John's body was, in fact, now outside. While this flurry of suspicious activity was going on with the Alberts and the McCabes, what's happening with Karen? All she knows at this point, think about it, at approximately 2:21, she dropped off John, he walked into 34 Fairview, and that's all she knows. She knows nothing else that was going on. So what was she left to think? He goes in to check the party out, but all of a sudden he's not coming back, he's not responding, minutes start to pass, 1 minute turns to 2, 2 turn to 10. Where is he? Why isn't he responding? She's sitting in the cold, dark, freezing outside in the car. Naturally, she's perturbed. Being perturbed turns into being peeved. Being peeved eventually turns into being pissed. By 12:30, Karen's mad. She's left 34 Fairview to make a point, but she's still texting and calling. What could she reasonably be thinking at this point? What's going through her mind? 12:33 turns into 12:34. I can't believe he'd do this to me. 12:34 turns into 12:35. Where is he? Why aren't you answering, John? 12:35 turns to 12:36. Jesus Christ. I'm calling and you're not answering. Where are you? Pick up the phone. But there's still no answer. There's still no response. By 12:37, she's getting furious. She does not know that something has happened to John. She does not know that. So she leaves the first angry voicemail. Illustrates frustration, aggravation, all the normal responses anybody might have, you and I might have. But little did she know. The next open voicemail has Karen parking at John's garage after she gets home. You can hear her heels clicking across the garage floor. For all she knows at this point, John's just drunk, he's been partying, he's hanging out, just forgot about her, blowing her off. But John's still not responding, and as the minutes tick by, Karen becomes increasingly upset. Those are the voicemails that you heard. How could he do this? Why is he ignoring me? Why is he ignoring the kids? Those are the thoughts bearing down on Karen Reed as she sat in an empty house late at night by herself. Ladies and gentlemen, she did not know what had happened to John. But within the next voicemail, you quickly learn what she was thinking and what she was feeling. Now it's 5:23 a.m. She's woken up, she's realized that he hasn't come home and he hasn't responded to a single text, not a single call. And anger quickly turns to panic and abject fear. She's so distraught, she reaches out to him again. John, where the fuck are you? She says through tears and desperation. And at 6:03, the question was answered and her worst fears were realized when she finds his body laying, dying in the cold in Brian Albert's front yard. You heard her, you can feel the grief, you can feel the raw anguish, you can see it. You don't have to wonder the emotional journey that Karen traveled that night. You can see it in the video. You can hear it in the audio. From the time he left her and walked into 34 Fairview and she called, she reached out 53 times. She called him 53 times before finding his body. Think about that. The Commonwealth wants you to believe that she murdered this man. And then after that murder, she called him not once, not twice, 53 times. It makes no sense. What does make sense is that she emotionally moved from anger, then to panic, then to grief. So back at 5:07, when she began her search looking for John, she backed out of the garage, and what would happen next would change the entire course of this case. As she backed out of that garage, she hit John's Traverse and cracked her right rear taillight. Folks, the Commonwealth has one job to do in this courtroom. It's an immutable responsibility to provide you with the truth. That's it. Not to win the case, but to seek justice and to do it through the truth. Ask yourself, did you get that truth from the Commonwealth? The Commonwealth continually tried to tell you that that video showed that the SUV came close to John's Traverse, and it took us showing you the video to unequivocally establish that Karen hit that car and cracked her taillight at 5:07. You can almost hear an audible gasp in the courtroom when we finally showed you the actual video. You can see that tire move. I'm only going to show you one series of exhibits during my entire closing, but it's that important. And it's this. Look at the condition of her taillight when she pulls out of the driveway at 5:07. That taillight, and I'm going to choose my words very carefully here. That taillight is cracked, but it's not completely damaged. And if there was any question in your mind about the level of damage to that taillight at 5:07, all doubt was extinguished when Dighton Police Officer Barrows walked into this courtroom. He's a sworn officer. He's not associated with Canton. He's not associated with the Alberts. He's not associated with the McCabe's. He doesn't know Michael Proctor. In other words, he doesn't answer to any of these folks. He's an outsider and he's completely independent. And his words were the following, quote, "That taillight was not completely damaged. It was cracked. A piece was missing, but not completely damaged." Take a look at this photograph and tell me, which one looks like Officer Barrows' description? The one on the left or the one on the right? The reconstructed light on the left is what that light looked like before it was in Trooper Proctor's possession. Remember that. That's what it looked like before Trooper Proctor had access to the SUV. And you have an independent police officer telling you so. You'll recall that after John's body was discovered, Lank, very good friend of the Alberts, walked into Brian Albert's house and had an off-the-record meeting with them. No one's ever going to know exactly what that meeting was about, what they discussed, because that interview, like everything else in this case, it wasn't recorded. It wasn't memorialized. But we do know that shortly thereafter, the Canton Police Department was recused from the matter entirely. And the case was assigned to one Michael Proctor. You have to believe that when the Alberts found that out, they thought they hit the lottery. They thought they hit the lottery. What are the chances? The department where my brother works, that would have been great to investigate this case, but that department's been recused. That's tough luck. But the guy who catches the case is Michael Proctor, a guy we go back with for decades. At such a break, they probably thought, when this is over, we need to get that dude a gift. Oh, wait a minute. They didn't think that. They said it out loud. But still, you've got to imagine that the Alberts had to be stressed, what with that whole thing about a dead body being on their lawn. That might get some attention, and they had to be wondering, will he set up a crime scene? Is he going to come into the house? Is he going to search the house? Is he going to send in a forensics team? Is he going to interview witnesses? Is he going to take us to the station? Will he take our phones? Will he look at our communications? Will he look at our Google searches? Will he look at our early morning phone calls? Is he going to look in the basement? And Michael Proctor answered every single one of those questions resoundingly. Nope. He's a Boston cop too. And with that, Michael Proctor didn't draw a thin blue line. He erected a tall blue wall. A wall that you can't scale. A wall that Karen Reed certainly couldn't get over. A wall between us and them. A place you folks are not invited. We protect our own. It's us or it's them. And by the way, who's she after all? Nobody. An outsider. This is going to be easy. Or so they thought. Let's look at what Michael Proctor actually did and did not do in this case. One of the consistent issues that's come up throughout this trial is how evidence always seems to be changing and evolving when in Michael Proctor's hands or somebody in his orbit. If it happens once, let's chalk it up to a mistake. Twice, it's starting to look a little bit like incompetence. If that happens every single time, it becomes intentional, which means it becomes corruption. The defense spent some time, we spent some time discussing the tow time that Michael Proctor swore to in affidavits. There was a reason that we believed it was so important, and I want to talk about that for just a quick second. Because this was a concerted effort by Michael Proctor to falsify the time the car was seized, so that no one would know that he actually had possession of the car before the first pieces of taillight were ever discovered at the scene. But he got caught. And when he did, the best he could come up with was it was a typo. Like a dozen times, a typo. You'll remember what that testimony was. The truth is that car was in Michael Proctor's possession from about 4:12 in the afternoon. He said it was 4:16 when he finally had to tell the truth, or some version of the truth. Those first pieces of taillight were not found until after 5:45 p.m. That is the very fact that Michael Proctor was trying to hide by those falsified affidavits, saying he didn't seize the car until 5:30. But that wasn't Michael Proctor's only manipulation of the investigation. What about Brian Lochran? You met him. Michael Proctor did his level best to not just hide evidence, but to hide human beings from you and from us. Michael Proctor was informed that the plow drivers were out that night. There would be a witness, potentially along 34 Fairview, at the exact times in question. Even Michael Trotta expressly told Michael Proctor that 34 Fairview had in fact been plowed that morning, and by whom. Proctor not only did not interview Brian Lockman, he never disclosed his name in a single report. He hid him. This is a witness who was literally on 34 Fairview at the time in question where a body was found on the lawn. Wouldn't you want to get the truth from an eyewitness? Wouldn't you want to seek that out? Not if you're Michael Proctor, a close friend of the Alberts. If it were up to Proctor, you literally never would have heard of or from Brian Lockman. That's a scary prospect. I want to touch briefly on the additional physical evidence, or some additional physical evidence presented by the Commonwealth in this case. You'll recall Christina Hanley. She established to a scientific certainty that the glass on the bumper, which was told to you in opening statement, was going to have something to do with this case. The glass on the bumper was going to match that cocktail glass. She told you unequivocally the glass on the bumper did not match the cocktail glass. They came from two different sources. The glass on the bumper has nothing to do with the cocktail glass. So that glass on the bumper had to get there somehow. It didn't get there by being broken from the cocktail glass. See the point? It had to get on the bumper somehow. It didn't jump up there by itself. And what's really interesting is that there was one piece on the bumper, only one, that matched something else in the case. It was a perfect match to a piece of glass that was supposedly found at the scene. Who do you think had possession of that matching glass? Michael Proctor. So the glass on the bumper had to be placed there. And the only person who had anything close to matching the pieces that had to be placed there is Michael Proctor. You do the math. That leads us to the magic hair. The Commonwealth spent a lot of time bringing in experts about mitochondrial DNA and maternal DNA lines and comparative analyses, and all that sounds really great and really sciencey, except for the fact that it just doesn't matter. Why? Because you would have to believe that that little hair, tiny, tiny little hair, barely perched on the side of that SUV survived nearly 75 miles of a raging blizzard outside. That would be a magic hair indeed. A magic hair means nothing. The DNA means nothing, and that's because the hair was from somewhere else. It certainly was not from a motor vehicle incident at 34 Fairview on January 29th. That hair was placed there. The DNA on the outside of the taillight housing also merits very little discussion. John's DNA would be expected to be found all over that SUV, inside, outside, the exterior, the interior, everything he touched would have had his DNA on it. Here's what's actually important about that DNA. No DNA was found on the interior of that taillight, the taillight that they now claim crashed into his arm and shattered. No blood was found anywhere on that taillight or any taillight pieces, and no tissue was found anywhere on that taillight or any taillight pieces. But we're to believe that that taillight literally exploded on John's arm at 25 miles an hour with 1,000 pounds of pressure. We talked about the evidence doing very funny things when in Proctor's possession or the possession of somebody in his orbit. Now think about the videos that you saw. How many videos appear to be somehow manipulated or altered? Just about every single one of them. Look at the video of the Sally port. Let's take that one, for example, that grainy one. It's missing the exact time that would show the condition of the taillight when it was pulled in to the Sally port. Pretty important time, wouldn't you think? Did someone not want you to see what the condition of the taillight was at that exact time? But the good news is there's a second video. It's much clearer. And it's from the same time frame. We didn't get that one for about 2.5 years into the investigation. Literally, it was after the trial started that that one was turned over. And this is important. The Commonwealth introduced you to a person by the name of Yuri Buchanan. They presented video showing what was clearly the right side of the car. They asked questions about the right side of the car. You'll recall, Mr. Lally asked Sergeant Buchanan, did you or Trooper Proctor ever go at or near the right side of that taillight? And while he was asking the question, what appeared to be the right side of the car, was looking at you. The video was still up. Buchanan paused, turned earnestly into the microphone, stared at you and said, "Never. We never went anywhere around that taillight," while he was showing you the right side of the car. And that trick might have worked until we got up to cross-examine him. And only then, on the second day of his testimony, did he have to admit that the video was actually inverted. It was backward. And it was cleverly inverted at that. The timestamp had the proper orientation, which means that timestamp had to be removed, the video inverted, and the timestamp placed back on it, which means that was done intentionally. That was not a mistake. And when caught in that obvious fabrication, Buchanan doubled down and said, "It's exactly the same." You remember that back and forth. "It's exactly the same," he said, as if we're stupid. Is it exactly the same, or is it exactly opposite? Ladies and gentlemen, you were lied to. There is no other way to say it. It's inexcusable. It's abhorrent. But it's also a paradigm of everything that the investigators have been willing to do in this case: lie, obfuscate, manipulate, alter. And when they're caught, they just excuse it away. Doesn't matter. It's the same thing. What's the big deal? Just look the other way. And don't forget, Buchanan is Proctor's supervisor, and he was in that little group chat where Karen Reed's naked photos were being searched for. You know the saying about the apple falling from the tree. Ladies and gentlemen, we haven't even started talking about the taillight yet. You'll recall that at the very beginning of this case, you were introduced to no fewer than 5 CPD officers very early on who searched the scene. None of them, not a single one, found any taillight material at the scene. 0. Stephen Seraph, Sean Good, Stephen Mulaney, Michael Lang, Paul Gallagher, they were all there. They were all walking right around there. They were all looking. They were searching with their eyes. They were searching with their hands. Some said they were searching with their feet. They even used tools, a leaf blower. Not one piece of bright red taillight material was at the scene, not a single piece, but incredibly, over the course of the next 3 weeks, according to Michael Proctor, 47 pieces of taillight material would end up being found, some of which were the size of a salad plate. The CERT team shows up later on January 29th, and according to O'Hara, the first few pieces of taillight were found about 5:45. And here's some interesting testimony that you heard. Who else was there? Who did O'Hara say was there? Well, he said his team was there. We certainly expected that, but then he said there were others. These other mysterious figures, some from Canton PD, some from the Massachusetts State Police, that he could not account for. Heavy coats, big masks, hats. Even Lieutenant O'Hara could not tell who was who, but he did note Canton police officers were there who were unaccounted for. Massachusetts state troopers were there unaccounted for. And during that search that was overseen by Trooper Tully, Proctor's supervisor, 3 pieces of taillight material were found. That's super important, and I want to concentrate on that for a second. O'Hara said all 3 pieces were in an area about 12 inches square. That's an area about as big as your dinner plate. Tully, however, claimed that 1 red piece was found. About 3 feet away from that was a shoe. About 1 to 2 feet from that was a clear piece of plastic, and a few feet away from that was a red piece of plastic. So we have red, clear, and red over the span of about, added up, probably 10 or 12 feet. Ladies and gentlemen, both of those things cannot be true. Somebody is taking liberties with the facts. Then Lieutenant Tully comes to court and makes this big grand gesture of opening all these evidence bags. These 2 evidence bags in particular represent exactly what we're talking about, those 3 pieces, red, clear, red. They're marked, they're sealed, they look official. They're not stop and shop bags, thank God. At least they've moved up from that. They've even got evidence tape on them. Who knew? There's evidence tape around here. So this must be real evidence, right? It must be real evidence in this case. And after making that big theatrical display, he opens up the bag with the red pieces and he pulls 2 pieces out. That's okay. Put the 2 red pieces together. Good so far. Then he opens up the second bag under Mr. Lally's questioning. And you remember he hesitated just a second. opened that bag and pulled out one piece of clear plastic, then pulled out a second piece of clear plastic with no explanation as to how that could have possibly happened. And he quickly returned all 4 of those back into the bag, sealed them up, and we're done for the day. The next day, I asked about that evidence again. I asked him to open up that bag with the red pieces, and he did the same thing. Pulled out 2 red pieces of plastic. I said, you'll recall this, I said, look deeper, look closer, sir. Pull everything out of that bag. Would he have, had I not suggested it? And then he pulled a 3rd piece of red plastic out of the bag. So miraculously, Trooper Tully's 3 pieces of plastic became 5 pieces of plastic right before your eyes. Ladies and gentlemen, the forces at play that multiplied those pieces of plastic inside those evidence bags are the same forces at play that multiplied the pieces of plastic at 34 Fairview. Think about that. Let that sink in for a second. How easy is it? That's not sloppiness. That's evidence manipulation. That's how over the course of 3 weeks, those pieces of plastic go from 0 to 3 to 5 to 47. Ever increasing in size with every single search. Now, knowing all that, ask yourself the looming question, who had access to that taillight, the cracked taillight? Who was it? Go back and watch the Sallyport video. I'll give you the timestamp, 5:37. And see it for yourself. We know that Trooper Proctor, with binder in hand, walked by himself. Once we corrected the video from being inverted, you can see that he walked back by himself to the right rear taillight where nobody could see what he was doing. Higgins' own key swipes put him in the Sallyport that same afternoon and evening. And then the Sallyport video magically skips and Chief Berkowitz appears right next to Proctor at the back of that vehicle in the same spot, and they walk out of the Sallyport together. Where were they going? Remember O'Hara? Unidentified troopers and Canton cops were at the search at 34 Fairview. How hard is it to drop a piece of plastic? We spent a long time talking about the compromised and altered and tampered and manipulated evidence, and now I want to switch and talk a little bit about the true facts in this case, because you did hear some true evidence and true facts. The Commonwealth presented about 67, maybe more, witnesses and expended 30 plus days of trial and 9 weeks of your life. Maybe we're in the 10th week. For what? It should be relatively simple, right? The Commonwealth claims that Karen Reed pulled up to 34 Fairview, John got out of the car, she reversed into him and hit him, and then she drove home. That's 4 facts. It's just 4 facts, that's all it is. What evidence do they actually have to prove that that SUV ever hit John? The answer is none. They don't have any, there's no evidence whatsoever that Karen Reed's vehicle ever struck John O'Keefe or that Karen Reed ever wanted to strike John O'Keefe. In fact, every single piece of material evidence in this case unequivocally proves the opposite. John went into that house, that SUV was not damaged by hitting John, and John's injuries did not come from being hit by a car. That's what the evidence actually shows. The Commonwealth knows that, and they've known it for a long time, and Proctor knows that. And because of that, the Commonwealth just resorts to character assassination and talking for weeks on end about the snow. Let's talk about what the real evidence actually shows, the unassailable science. Let's talk about the truth. Concerning John's injuries first, the Commonwealth's own medical examiner, Dr. Scortibello, could not conclude that John was hit by a car. Think about that. And she would not even say that it was a homicide. She told you without any dispute in this case, quote, evidence pointing toward one manner of death is no more compelling than evidence of a competing manner of death, end quote. Her words, not mine. She went on to say it's just as likely that he was punched and fell backward. His injuries are consistent with that. In fact, in her expert opinion, his injuries are consistent with a physical altercation, as she testified, but they are not, in her words, not classical injuries from an auto pedestrian accident. That by itself is reasonable doubt. But the evidence and the truth goes far further. We introduced you to not one, but 2 thoroughly credentialed medical examiners or medical experts, Dr. Sheridan and Dr. Russell, both of whom said John's arm injury is consistent with an animal attack. Dr. Russell studied, diagnosed, and treated up to 1,000 animal wounds. She's an expert in animal wounds, and she was unequivocal. Those wounds are from an animal, likely a large dog, which means that John was attacked inside the home where Chloe was. There is no other possibility. And Dr. Sheridan, for his part, with thousands of 13,000 autopsies under his belt, decades of experience as the chief medical examiner who's triple credentialed in anatomical, forensic, and neuropathology, he told you that John's injuries are inconsistent with a motor vehicle accident or incident. They're consistent, however, with a physical altercation. In layman's terms, the science proves John was beaten. That also is reasonable doubt and should end this case. But the facts and evidence don't stop there. Two of the most highly educated and highly qualified engineers you'll ever meet, Dr. Dan Wolf and Dr. Andrew Rentschler, mechanical engineer and a biomechanist. They reviewed this case. They did testing, they did analysis, they evaluated the case scientifically. They were not hired by the defense, not by the Commonwealth. They're completely 100% independent of any party in this case. And they were equally available, by the way, to the Commonwealth. They could have called them. They explained that John's injuries were not caused by being hit by Miss Reed's SUV, and that the SUV was not damaged by coming in contact with John O'Keefe's body. That should end the inquiry right there. Both sides of the equation. From a physics, engineering, and biomechanical standpoint, they established that John O'Keefe was not struck by Karen Reed's vehicle, period. And that is yet another fact that establishes reasonable doubt and should put an end to this case. So instead of calling the ARCA experts, which they had available to them, the Commonwealth chose to introduce you to Trooper Joe Paul. You'll remember his testimony. I think I'm being kind when I say that Trooper Paul's analysis lacked credibility. Trooper Paul lacks the experience, the education, the training, the background, and the knowledge to not only render opinions on these issues, but to even understand the issues themselves. He makes the absurd claim that John was hit on the elbow area of his arm by a taillight. He was spun to the left in a pirouette. His arm stayed on the light long enough for the shards of plastic to explode around him, scratching his arm, even though he was wearing long sleeves, then projecting him 30 feet to the left, but not before making a stop to hit his head on either the curb or the pavement, before coming to his final resting place with his unbroken phone tucked neatly under his body. It's nonsensical. It borders on laughable. Compare that testimony to Dr. Dan Wolf and Dr. Andrew Rentschler. Both PhDs in engineering, both top of their field in accident reconstruction, both published peer-review articles on the issues. Both men are highly sought after by the likes of national sports leagues and the United States Department of Defense. And these men are unrivaled in accident reconstruction. What did Dr. Rentschler say before he left the stand? This was even under cross-examination. He said that the physics and the science don't lie. His words were, "You can't deny the science and the physics." John wasn't hit by that car, period. The Commonwealth cannot explain John O'Keefe's injuries. They can't explain his head wound. How did he get the head wound if he landed on snow-covered grass and dirt? And by the way, before Mr. Lally gets up and says it, because I know he's going to, there is zero evidence before you, zero, that cold grass and dirt turns into ice or turns into concrete. Zero. They can't explain the injury above his right eye, that laceration. They can't explain his nose. They haven't even tried to. They can't explain the injury to his tongue, the laceration on his tongue. They cannot explain the injuries to his back, to the back of his hands, the bruises, and certainly they cannot explain the injuries to his right arm. But maybe most importantly, they cannot and haven't even tried to explain the lack of injuries on John's body from the neck down. Nothing. He was pristine. Not a bump, not a bruise, not a fracture, not a broken bone. Nothing to suggest that he was hit by a 7,000-pound SUV going 25 miles per hour. And what of that right arm? According to the Commonwealth's best and brightest, Trooper Paul, John absorbed the entirety of the collision, the whole collision, with that 3.5-ton SUV entirely with his right arm, launching him some 30 feet. But amazingly, the arm suffered no break, no fracture, and didn't even get a bruise. So how are those injuries properly explained? The evidence is simple. John got into an altercation. He was punched. He tried to defend himself by putting his hands up. He may have even scratched his own nose by putting his hands in front of his face to defend himself. His hands were bruised in the covering up.
Five minutes, Mr. Jackson.
Thank you, Your Honor. As he continued, he got hit, punch went through, and he fell to the ground, fracturing his skull. At some point during that altercation, the dog got a hold of him, and the dog was pulled away. Every single injury is answered. Every single injury is explained by that. Ladies and gentlemen, given what we know about the facts and the physical evidence in this case, the actual truth in this case, how did this happen? How did we end up here? We ended up here because of relationships, insider trading, playing the who you know game, and building a tall blue wall, which takes decades and generations. But the real question is it going to continue? With this festering malignancy that allows a lead detective and his supervisor to gloat and sneer while looking over naked pictures or looking for naked pictures of the woman that they've targeted. Will that continue? And the answer should be, not if you have anything to say about it. Michael Proctor is the lead investigator in this case, and much as the Commonwealth might try, they cannot distance themselves from the stench of him on this case and this investigation. Those secret group chats illustrate the quality and character of his investigation. Remind yourself how an, quote, unbiased and an objective investigator, someone who's supposed to be looking for facts. Ask yourself, how did he approach his job late at night, sitting there in his office, deviously looking for naked pictures of Karen Reed and talking about her like she's a piece of meat, talking about her bodily functions, her medical conditions, calling her vile names. I don't even have it in me to repeat what he said about her. He reduced her to an object and went further by insulting her. He went further than insulting her, and he dehumanized her. And when he was done betraying that very humanity, he wished for her to commit suicide. That, ladies and gentlemen, is how you frame someone. That's how you dehumanize someone so viciously that you can just pin it on the girl and cover for the homeowner because he's a Boston cop. That's how you rip a person's life apart and sleep like a baby while doing it. And then further that by saying, I hope she kills herself. Ladies and gentlemen, I just began the discussion this afternoon or this morning with a quote about the truth, and I did that because that's what this case is about. Top to bottom, tip to tail, it's about the truth, not hiding it or concealing it, but exposing the truth. The truth is immutable. It's not a feeling, it's not a whim. It's unflinching, it's unchanging, and it's everlasting. That's why the law is steady. That's why it's not captive to the whims of people drunk with power who think they're above the law, who think they're above scrutiny. That's why you stand as the guardian of justice and the protector of justice. The law demands the very integrity that Trooper Proctor and his investigation lacks, and it requires that you cannot convict Karen Reed unless the Commonwealth has met its incredibly high burden to prove every element beyond a reasonable doubt and to a moral certainty. And a moral certainty is defined as the highest degree of certainty possible in matters related to human affairs. It's the highest degree possible in your life. That's the level of certainty. And I'll leave you with this. You have the most powerful tool known to American jurisprudence because you have your vote. No one can take that away from you. Not me, not the Commonwealth, not the court. You may not have asked to be here, but each of you have given something very special of yourselves. You've agreed to do that which is the highest calling a citizen can answer in any way. You've agreed to give your community your best. And my question to you is, what will you do with this moment? Ignore the lies and the manipulations, the misogyny, the bias, the lack of evidence, Could you ever do that? Would you ever do that? Or will you say with your verdict, I see the truth and I will not ever look the other way?
Great close.
When you stare the truth down, you'll see that the Commonwealth has not proven its case beyond a reasonable doubt into a moral certainty, not even close. Ladies and gentlemen, Karen Reed is innocent. Do justice and find her not guilty. Thank you.
Outstanding.
Thank you very much, Mr. Jackson. All right, Mr. Lally.
Outstanding.
Thank you, Your Honor. I hit him, I hit him, I hit him.
We knew it.
I hit him.
We knew it.
Those are the words of the defendant. 4 times. You heard testimony from 4 different witnesses who overheard and observed those statements from the defendant on January 29th, 2022. You heard testimony from firefighter Timothy Nuttall. He was trying to bag valve mask Mr. O'Keefe. He was working on resuscitative efforts to try to save Mr. O'Keefe's life. He asked if anyone saw anything or knew what happened, and the defendant said, I hit him, I hit him, I hit him, I hit him. Firefighter Anthony Flamati was asking if anyone had information on why Mr. O'Keefe was there in the snow. The defendant repeatedly said, I hit him, I hit him, oh my God, I hit him. Firefighter Katie McLaughlin was tasked by firefighter Flamati with asking for biographical information and for what the cause was of the traumatic injuries that all the firefighters testified that they observed on Mr. O'Keefe. She asked the defendant, and the defendant said, I hit him, repeatedly. Firefighter McLaughlin asked for clarification. You did what? And the defendant repeated, I hit him. Jennifer McCabe stated initially over the phone when speaking with the defendant that the defendant said, could I have hit him in the car while they're on the phone with Ms. Roberts going from Ms. McCabe's house to Mr. O'Keefe's house? Did I hit him? Could I have hit him? Once on scene, once asked, as Ms. McCabe described by an EMT, for name, age, things like that related to Mr. O'Keefe, what caused the trauma? She indicated in her testimony that the defendant said repeatedly, I hit him. You heard testimony from Officer Sarif, statements that he attributed to the defendant as saying that morning, this is all my fault. This is all my fault. I did this. This is what the defendant is saying on scene. Since then, stories changed a little bit. But those were the words that came from the defendant's mouth on January 29, 2022, as John O'Keefe lay dying on the front lawn of 34 Fairview Road, where the defendant had left him after striking him with her motor vehicle several hours before, and then left him freezing there in a blizzard. There's certain things that have come up over the course of this trial as far as evidence and testimony are concerned, little things. And what I would suggest to you, it's those little things that are quite telling as it pertains to the defendant's statements and the defendant's actions over the course of January 28th and January 29th and beyond. I'm going to bring some of those to your attention as I go through, but just ask you to keep that in mind as far as when you're deliberating, when you're reviewing this testimony and this evidence. The little things matter. The little things start piling up.
Indeed they do. Indeed they do.
Throughout the course of this trial, you've heard a lot of purported evidence or questions of witnesses in an attempt to distract you from the evidence in this case. It's essentially defense by obfuscation. It's a 3-card monarchy. Facts and the evidence in this case are your card, they're the Queen of Hearts. And so what I want you to, or what the defense wants you to do is not look at that card. Look at anything else. Look at movement, look at this person, look at that person, look at text messages, look at this evidence, because if you do, what it will ineluctably lead you to is that the defendant is guilty of each of the 3 indictments before this court. The evidence and the facts of this case are for you, the jury, to decide. Using your common sense, using your life experiences, as your guide through that as you go. Before I turn to that evidence that I will submit to you and electably demonstrates the defendant's guilt, let me first just address Trooper Proctor. The text messages from Trooper Proctor are unprofessional, they're indefensible, they're inexcusable. However, as distasteful as those messages are, and their content is, I submit they had no bearing whatsoever or impact whatsoever on the integrity of the entirety of the investigation that Massachusetts State Police collectively conducted into John O'Keefe's death here. As was asked of Trooper Proctor on cross-examination, these were texts from his personal phone that he never thought would see the light of day. He was asked whether or not he ever thought that he would be asked about these in a courtroom, put to him in sort of a safe space, a safe place for him to discuss, if you will. What do you not see in those text messages? You don't see any discussion or any illusion of any conspiracy, of any framing of the defendant, of any planting of any evidence, no evidence whatsoever. Why? Because it didn't happen. There is no conspiracy, there is no cover-up, there is no evidence of any of that beyond speculation, rampant speculation and conjecture on behalf of the defense. Two things can be true at the same time. They're mutually exclusive. The texts from Trooper Proctor are distasteful, they're disrespectful, they're unprofessional, there is no defense to them. And the defendant killed John O'Keefe. Turning to the evidence, let me first talk a little bit about John O'Keefe. You heard a lot about him over the course of this trial, about his selfless story through his family and friends that loved him, including his adopted niece and nephew.
That's the
You
evidence.
heard a lot about the
People
lives he
love
touched
John.
and the different people who he had friendships with. You heard a lot about from those particular friends and from his family. Turning to what I would submit to you as a timeline. This may be a little hard to see up here. What I'm going to go is from left to right. January 28th, 2022, 9:49 in the morning, Karen and John begin fighting over text messages. 2:25 p.m. in the afternoon, the defendant texts Mr. O'Keefe, "Tell me if you are interested in someone else. Can't think of any other reason you've been like this." John texts back, "Nope." 2:25, Mr. O'Keefe texts the defendant, "Things haven't been great between us for a while. Ever consider that?" This is also testimony that you heard through multiple sources, whether it be phones, whether it be from the children, whether it be from other friends or family members as to the relationship in the months and weeks leading up to John's murder. 2:32 p.m. John texts the defendant, "Sick of always arguing and fighting. It's been weekly for several months now." He then texts the defendant, "OMG, stop calling." This is during the time frame that Trooper Garino was talking about, with 18 phone calls, most of which were rejected, some of which were missed, and a couple of which were answered over the course of this afternoon, as she's continuing to needle and try to engage him in a fight that he doesn't want to have. 2:33 p.m. The defendant texts John, "So you're not into this anymore." 2:34 p.m. John texts the defendant, "I am not answering, stop calling." The defendant then texts John, "Then stop starting with me." 2:38 p.m. The defendant texts John, "I'm going to grab a drink in here."
What do you think, Chad?
2:38 in the afternoon. Around 3 p.m. is the testimony you heard from Erin O'Keefe in regard to the defendant texting her, asking if she can go out without her husband, Paul.
I'll take under.
Asking him to go
She'll
out
cut
for a
him
drink.
off.
This is while Erin O'Keefe testified she was waiting for one of her children at the bus stop, picking that child up around 3 o'clock in the afternoon. This is also the point at which the defendant says to Ms. O'Keefe, "Wish I didn't speak to another O'Keefe after 2004. 7:30 p.m., you have Mr. O'Keefe and Mr. Camerano arriving at C.F. McCarthy's, with the defendant arriving at 8:51. 8:58 p.m. is when the defendant receives drink number 1 at C.F. McCarthy.
The drinks.
Vodka soda, tall cylinder glass, lime, and astronomy. 9:13 p.m., drink number 2. 9:20 p.m., drink number 3. 9:33 p.m., drink number 4. 9:57 p.m., drink number 5. 10:22 p.m., drink number 6. 10:29 p.m., drink number 7. 7 drinks from 8:58 p.m. through 10:29 p.m. when she receives that last drink at C.F. McCarthy's. A drink that she indicates to Sergeant Mechanic and several others on the next day that she did not take with her from C.F. McCarthy's to the waterfall, which several individuals at the waterfall testify that she produced from her coat when she walked in, and that you can clearly see on the C.F. McCarthy's video her walking out the door with the same tall cylinder glass in her right hand. Now, keeping understanding that some of these drinks are not the full tall cylinder drinks, what she's doing is she's getting shot glasses of vodka and then pouring them into the drink after she's consumed the drink. 10:54 p.m. The defendant and Mr. O'Keefe arrive at the waterfall, during the course of which, on an hour that they're there, the defendant receives drinks number 8 and drinks number 9. 12:10 a.m. From the waterfall video, you have Ms. McCabe, Ms. Kolakithis, and the defendant departing the waterfall together. Interestingly, around the same time, you also have the text and screenshot communications between Colin Albert and Allison McCabe in reference to him getting picked up at that time. You also have testimony from Brian Albert, Nicole Albert, Caitlin Albert, Brian Albert Jr. in reference to them sort of walking in from the waterfall as Colin Albert is walking out of 34 Fairview Road, gets picked up by Ms. McCabe, and then is driven home. 1 minute later, 12:11, Mr. O'Keefe is then on the waterfall video walking out with cocktail glass in his right hand. At 12:14 a.m., Mr. O'Keefe texts Ms. McCabe, "Where to?" 12:14 a.m., based on the fact that she's driving, and Mme. McCabe indicated in his testimony that she should call him instead of texting while driving, Ms. McCabe calls John O'Keefe, speaks with him regarding directions, sort of going over which way to come in Chapman Street over Cedar Crest as far as coming into Fairview Road. 12:15:38 a.m., the defendant's vehicle drives by the Canton Library. You can see that on the video. 12:17:56, the defendant drives by the Temple Beth Abraham video. Again, you can see that on the video. Remember also the testimony from Lieutenant Tully in regard to the CSLI data and the ranging data in reference to it coinciding with what you observed, the black SUV, from each of those respective videos. 12:19:32, Mr. O'Keefe enters 34 Fairview Road into his Waze app on his phone. 12:23 a.m. is when the defendant conducts a 3-point turn on Cedar Crest and travels back toward Fairview. That's from Mr. O'Keefe's GPS native location data from his phone. Around the same time at 12:23 and 12:24 is when you have that testimony from Ryan Nagel, Heather Maxson, and Ricky D'Antono pulling into Fairview Road around the same time and pulling in behind the dark SUV. 12:25 a.m. is the last native location GPS data of John O'Keefe's phone. It's in that area between 32, 34 Fairview Road, where his body is discovered the next morning, in which there is no movement of that phone from that 12:25 a.m. period until Ms. Roberts then picks up the phone on the grass underneath Mr. O'Keefe's body sometime after 6 a.m. What you have up on the screen right now is that data, those plotting points that Trooper Garino was testifying about as far as the movement of the vehicle. Movement of the vehicle as it comes down Cedar Crest, passes by Fairview, reverses direction, and then comes down Fairview, moving up, moving up, moving up as the witnesses described, eventually stopping in that area of the property line between 32 and 34 Fairview Road, which happens to coincide with the vehicle control history database information from the Toyota text stream, which you now have up on the screen before you here, indicating that following that 3-point turn, approximately 8 minutes after that, from Trooper Paul's testimony, as far as the mileage, 36 to 38 miles, matching up with the time that the vehicle is in front of 34 Fairview Road, that the vehicle travels in reverse, in a straight line, with 24.2 miles per hour for 62.5 feet with a minor steering angle change, which the trooper indicated was consistent with a pedestrian collision. At 12:30 a.m., you have that second triggering event 8 minutes after the 3-point turn when the vehicle's in reverse at 24.2 miles an hour. 12:35 is when the defendant calls John, and that's unanswered. 12:36 is around the time that the defendant's phone connects to the Wi-Fi at 1 Meadows Ave, Mr. O'Keefe's home.
They do not.
12:37 is
State
when the
always
defendant
gets the last
leaves
word.
this voicemail.
And yes, it always favors the state.
So within minutes of that vehicle's data, going 24.2 miles an hour in reverse for 62.5 feet, the defendant leaves that voicemail, seething in rage as she's screaming, "John, I fucking hate you." 12:40 to 12:42, Ms. McCabe is texting Mr. O'Keefe. She tries calling Mr. O'Keefe, gets no answer. If you recall from her testimony around this time frame, about 12:40, she was unsure whether the vehicle was actually still out front or if it had gone at that point. But she was looking for John because she had seen the defendant's vehicle in front of the house and no one had come in. So she was wondering where her friend, Mr. O'Keefe, was. 12:55, the defendant texts John, "See you later." 12:59, the defendant calls, leaves another voicemail for Mr. O'Keefe. Exhibit 637, it sounded like this.
"John, I'm here with your fucking kids. Nobody knows what the fuck you want, fucking pervert."
But somebody did know where Mr. O'Keefe was. The defendant knew exactly where he was. She had driven him there, she had struck him there, she had left him to die there. 1:02 a.m., the defendant leaves another voicemail with no content. And then she texts John, "Your kids are fucking alone." 1:09 a.m., the defendant texts John, "I'm back in Mansfield. The kids are home alone." She's not. GPS, as far as it never disconnects from the Wi-Fi until the following morning. There's no indication that Ms. Reed left and went to her home in Mansfield at any point. 1:10 a.m., the defendant calls her parents. 1:11 a.m., she calls Mr. O'Keefe and leaves this voicemail.
"John, I'm going home. I cannot babysit Amy. I need to go home. You are fucking using me right now. You're fucking another girl. He's sleeping next to me. You're a fucking loser. Fuck yourself."
1:18 a.m., the defendant leaves another voicemail. Now, about 1:43 or 1:45 a.m. is when Julie Nagel testified that they were leaving the house. And she sees a large black object on the lawn near the flagpole while leaving 34 Fairview Road. Doesn't think much of it at the time, isn't expecting Mr. O'Keefe or any body to be out on the front lawn. 4:42 a.m., the defendant calls and speaks. So the calls to her parents are finally answered. 4:49 a.m., the defendant calls Ms. Camerano, screaming, "Where's Mike?" 4:53 in the morning is when the defendant instructs Kaylee, Mr. O'Keefe's niece, to call Ms. McCabe. Why? Because the defendant doesn't have Ms. McCabe's phone number. Indicates that John didn't come home. We got in a fight, and I left him at the waterfall. Those are the first statements or the first version of events that she's able to communicate out to the world as to what happened to Mr. O'Keefe and where he is. We got into a fight. I left him at the waterfall. 5 a.m., the defendant calls Kerry Roberts, saying, "John's dead, Kerry, hangs up the phone. 5:01, the defendant calls Kerry Roberts again. And it's at this point that she indicates that John's dead, he must have been hit by a plow. 5:07 a.m., the defendant leaves 1 Meadows Ave. You have the video of that. It's number 153 in Exhibit 6. We'll get to that a little more in a moment. About 5:10 a.m., the defendant calls Kerry Roberts. Ms. Roberts starts calling hospitals, calling KPD, calling 911. Something that you would do if you didn't know where Mr. O'Keefe was for all of these hours, that all of these other phone calls are being made and these text messages are being sent, and calling your parents, and all of these other things. No calls to 911 from the defendant. while John O'Keefe is laying, freezing, and dying from a brain injury and a skull fracture on the front lawn of 34 Fairview Road. 5:11 a.m., the defendant's vehicle is seen on the Canton Library camera heading towards the waterfall. Seems to be sort of retracing the steps. 5:18 a.m., the defendant's vehicle is seen at Washington Street and Chapman on the Temple Beth Abraham video, heading in the same direction that it was the night before when it was heading to 34 Fairview Road. 5:35 is when the defendant arrives at Ms. McCabe's house. Ms. Roberts arrives shortly thereafter. Both of them see the broken taillight at that time in the driveway. Now that gap of 5:18 to 5:35 is way too much time to be driving from the area of the waterfall to Jennifer McCabe's house. And as I indicated a moment before, heading in the same direction, same directionality, retracing the steps from the night before, heading towards 34 Fairview Road. Why is it that the defendant can see Mr. O'Keefe when they eventually get to Fairview Road and no one else can? It's because she knew exactly where he was. She had hit him and left him there the night before. She had gone back during that time frame between 5:18 a.m. when she's seen on the Temple video and 5:35 when she arrives at Ms. McCabe's house. 5:33 is when the defendant, Ms. McCabe and Ms. Roberts, return to One Meadows Ave searching for John. 6:03 is when the defendant, no one else, spots Mr. O'Keefe's body buried in the snow. Exhibit 12, indicating this cruiser camera video, which I know you've seen a dozen times. So where I'm starting it from this point in this card right here is the spotlight that Officer Saraf had to use in order to locate, even with the vehicle of Ms. Roberts parked right in the middle of the road.
You're not the only one. I've talked about this too. Just the bureaucratic not caring that is what evil is.
In the darkness, in the snow, in the blizzard, in those conditions, the defendant sitting in the back seat of the vehicle knows exactly where Mr. O'Keefe is, covered in snow, as you heard from all of the paramedics, from the civilian witnesses, from the first responders. But the defendant knows exactly where he is. 6:07 a.m., Ms. McCabe calls 911. 6:08, the defendant leaves that 4 or 5 minute voicemail, leaving the phone in the car for some reason to Mr. O'Keefe's phone. 6:23 and 6:24 in the morning is when Ms. McCabe conducts those Google searches. 7:50 in the morning is when Mr. O'Keefe is pronounced deceased at Good Samaritan Hospital. 4:13 to 4:20 p.m. is when the defendant's SUV is towed from her parents' house in Dighton. 5:20 p.m. is when the search team arrives in the area of 34 Fairview Road to conduct the search for evidence. 5:30 p.m. is when the defendant's vehicle arrives at the Canton Police Department south. We circle back for a moment to Mr. O'Keefe, to his families, to his friends, and to his relationship with the defendant. We heard testimony from Paul and Aaron O'Keefe that they liked the defendant, that they thought he was good for John, thought he was good for the kids. All outward appearances of the relationship were good. You heard testimony from the children that that was not true behind closed doors. But Paul O'Keefe testified that he told the defendant's parents this, that he liked Ms. Reed, that he thought that she was good for John, thought that she was good for the kids, weeks before John's murder. He even blew her a kiss in the emergency department at Good Samaritan as he was walking out and she was still being treated while they were there. Invited her over to John's house to grieve with him. Invited her to sit down with him while he explained to their nephew Patrick about John's passing. Defendant shows up at the house. Abruptly goes upstairs with her father for a period of about 15 minutes, which is about half of the time that she spent there that morning, grieving with the family. She left with a bag of her belongings. drove with their family there, and then took an extra vehicle in the height of the blizzard, around 1 o'clock in the afternoon, drive that vehicle all the way from Canton, where it was parked at her boyfriend's house, where she stayed over on many occasions, drove that vehicle or felt the need to drive that vehicle from Canton all the way down to her. You heard testimony from Aaron O'Keefe of the text messages and the phone call on January 28th. We've heard that Aaron O'Keefe called the defendant on the morning of the 29th because she was concerned for her. She wanted to know what was going on with someone she considered her friend. The defendant yells, "John is dead." Ms. Robertson grabs the phone and then updates Aaron O'Keefe as to what's going on with John. Aaron O'Keefe again calls back later because she's concerned for someone that she considered her friend. How does the defendant respond? These are some of the little things. The defendant indicates to Ms. O'Keefe that she just has to remember the bad times and indicates to her, "I don't think I'll ever see you guys." This is after she's done her quick in and out at One Meadows Ave and is now with her parents or with her father, driving that car, essentially taking the murder weapon from Canton and bringing it down to her parents' house in Dayton. She's indicating over the phone to Aaron O'Keefe, "I don't think I'll ever see you guys." Why?
Because her boyfriend's dead and the mom
If
hates
she
her?
didn't kill John, why would she say that? You heard a lot of testimony about New Year's Eve in Aruba. You heard the testimony from Ms. O'Keefe in regard to them exchanging, her and the defendant exchanging text messages on the flight down, arranging times to meet up. And then the defendant telling Aaron via text message that she caught Johnny kissing Laura's sister in the hotel lobby. She got into an argument about it, and then they never met up. Meaning the defendant, Mr. O'Keefe, got into an argument about it, and she and Aaron O'Keefe never ended up meeting up in Aruba. You heard testimony consistent from Laura Sullivan, Marietta Sullivan, as well as the children. The kiss never happened. It never would happen based on the relationship, the godfather relationship that John O'Keefe had with Laura Sullivan, her family, and particularly Laura Sullivan's child. The defendant persists with this unfounded suspicion and accusations of infidelity in her text messages with Mr. O'Keefe, in her text messages with Mr. Higgins, where she's accusing Mr. O'Keefe of making out in the lobby with Marietta Sullivan. Both of the Sullivans and the children have the defendant and Mr. O'Keefe following this incident with Marietta Sullivan going into a room. Both of the children testified that they're in that room for about 20 to 25 minutes and they're arguing about the defendant indicating that Mr. O'Keefe kissed someone in the lobby. And you have Laura Sullivan's testimony about 20 to 25 minutes after her sister comes out and states her displeasure about the defendant. It's about 20 to 25 minutes before Mr. O'Keefe comes out, and then he and Ms. Sullivan have a conversation. Ms. Sullivan indicates that Mr. O'Keefe's phone is essentially blowing up, lighting up with calls and texts from the defendant. I would submit similar to the afternoon of January 28th. Mr. O'Keefe says she's crazy and he needs to take this and goes off from her. Ms. Sullivan has later conversations with Mr. O'Keefe on this Aruba trip, asks him if he's okay, asks him if he's happy. She indicated in her testimony that Mr. O'Keefe shrugs it off and says it is what it is. You heard testimony from the children about the arguments in the weeks and the months. And I know this is a displeasure to defense counsel that the children came in and actually testified as to what happened behind closed doors in the house. They both recall frequent fights. They both recall Mr. O'Keefe trying multiple times to break up with the defendant, asking her to leave the house, the defendant refusing to leave the house. His niece Kaylee, John tried to diffuse, tried to walk away, and the defendant would follow each time during each argument. They both indicated that Mr. O'Keefe had told the defendant that the relationship had run its course, similar to language within the text messages you have between the defendant and Mr. O'Keefe. That Mr. O'Keefe was sick of arguing, again, mirroring those text messages from January 28th, leading up into going out to see if McCarthy is eventually the waterfall. and
He
the
didn't
defendant
fly.
killing
It was
Mr.
Roadrunner
O'Keefe,
feet.
in the early morning hours of January 29th.
Trooper Paul made that very clear.
We have testimony in regard to the ring camera. Kaylee indicated in her testimony that John had had that for about a year. So during the course of the 2 years or so of the relationship with the defendant, he got it while he was dating the defendant. The defendant had the security code for the garage. Neither of the kids had access to the camera. Trooper Garino checked the laptop and the desktop that were left after the defendant did the quick cleanup upstairs with her father, upstairs in the home. Neither of those devices had access to the ring cameras. John had access on his phone. The defendant indicates, if you recall, in some of those text messages in regard to the romantic kiss that she placed on Mr. Higgins earlier on January, whatever it was, during the Patriots. Mr. Higgins and Mr. Jackson was indicating weren't very good friends with Mr. O'Keefe, but had been invited over to his home for a Patriots game, in which time the defendant escorted Mr. Higgins out of the garage and placed a romantic kiss on him. But during those text messages, when they're talking about that, if you recall, the defendant is saying something or joking about something that Mr. O'Keefe had been looking at the videos and had been asking her if there was something going on with her and Mr. Higgins. And what was her response to that? I know where the cameras are. There are only 2 videos missing from that ring system. One being the defendant getting to Mr. O'Keefe's house after murdering him, and the other when the defendant is showing Ms. McCabe and Ms. Roberts the broken taillight, both of which, both Ms. McCabe and Ms. Roberts testified as having occurred. No video. The variety of stories that the defendant tells on the morning of January 29th. There were text messages and voicemails from the defendant to Mr. O'Keefe, 53 phone calls from 12:33 a.m. to 6:03 a.m. 0 phone calls to 911. The defendant calls Katie Camerano. The defendant calls her parents at 1:18 in the morning, 4:38 in the morning, 4:42 in the morning. The call then from Kaylee's phone to Ms. McCabe, because the defendant didn't have Ms. McCabe's phone number. Both Kaylee and Ms. McCabe indicate that the defendant initially indicates or says that she got into a fight with Mr. O'Keefe and left him at the waterfall. From this information, Ms. McCabe then testifies she starts to call Julie Albert, because Chris Albert, Julie Albert, they live close by the waterfall. Maybe that's where he went. As the phone is ringing, this is a phone call that both Ms. Albert and Ms. McCabe testify was never answered. As the phone is ringing, her husband Matthew McCabe reminds her that they saw the defendant and Mr. O'Keefe and the car outside of 34 Fairview, so she hangs up. During this call, or during these subsequent calls, the defendant indicates to Ms. McCabe, maybe I hit him, did I hit him? She then calls Ms. Roberts at 5 a.m. on the dot, indicates John's dead, hangs up the phone, calls back a minute later, indicates that Mr. O'Keefe was now hit by a plow and that he's dead, and then indicates further that she's drunk and doesn't remember. She tells Ms. McCabe about the cracked taillight before they even get in the vehicle and go anywhere, as you recall the testimony of Matthew McCabe, indicating that he has some concerns about them driving around in a vehicle with a damaged taillight in the middle of a blizzard. Ms. Roberts' testimony that she saw the broken taillight in the driveway at Ms. McCabe's house, and that it was consistent with what she observed in the photographs that were shown to her of it later in the Sally Port at the Canton Police Department garage when the search warrant is executed on February 1st. You have the text messages between the defendant and Laura Sullivan from January 29th, in which the defendant indicates to Laura Sullivan that John is dead, indicates that we found him in the snow at 5 a.m. And every indication is that he was found in the snow by the defendant, Mr. McCabe, and Ms. Roberts around 6 a.m. 5 a.m. would be about an hour before.
Got her.
5 a.m. would be between that time where the defendant is unaccounted for, heading in the direction of 34 Fairview Road, 5:18 and 5:35. Little things. The defendant asked Ms. McCabe to Google how long to die in the cold. She did so at 6:23 and 6:24 in the morning. You have the testimony of Ms. Hyde and Mr. Whitford as to SQLite databases, P-list databases, Knowledge C databases, state DB tabs, as far as all of them. Also from Trooper Marino as well. These searches were unequivocally done at 6:23, 6:24 in the morning, and not at 2:27 and 40 seconds in the morning. They were not deleted by a user. That is not what deleted means. Frankly, Mr. Green, the last question that I asked Mr. Green is, was he aware that Cellbright, and by Cellbright, the person who designed that being Mr. Whiffen, had to alter exactly how their software worked because of people like Mr. Green misinterpreting the data as he did in this case. And what did Mr. Green say? Yes.
Mr. Green said he relied on everything but Celebrate.
But those questions, as far as how long to die in the cold, I would submit mirror the questions that the defendant asked firefighter Whitley in the back of the ambulance, if you recall those. She asked firefighter Whitley how long to die in the cold without a jacket. He knew how Mr. O'Keefe was dressed. She knew when she left him to die in the cold how he was dressed. The defendant made statements to firefighter Becker that the last time that she saw Mr. O'Keefe, they were in an argument. Again, in the back of the same ambulance as firefighter Whitley. You have testimony from firefighter Woodbury. Same kind of questions. If Mr. O'Keefe could be alive without a jacket. You have the testimony from each of these firefighters as to sort of the vacillating emotional state of the defendant that morning. What you have in the testimony from firefighter Woodbury is that despite all that, there were no tears that he observed from the defendant at that time. What each of those
No
first
tears, that's it.
responders indicated was that the defendant repeatedly stated, is he dead? Is he dead? Not is he okay? Is he going to be okay? How is he? Any sort of questions about the medical condition. Is he dead? That phraseology repeated over and over again. And when you take into juxtaposition that phraseology, text to Laura Sullivan, found him in the snow at 5 a.m. The unaccounted for time heading in the direction of 34 Fairview Road, 5:18 to 5:35. The repeated questioning, firefighter Whitney, firefighter Woodbury, asking Miss McCabe to look up those things in her phone. She's looking for confirmation, is what she's looking for. When she asks over and over again, is he dead? Is he dead? Is he dead? You have the testimony that you heard from Miss McCabe and Miss Roberts. I say them together because as far as these two women were concerned, they did not know each other really at all. The only time, as they both testified to, that they ever spent appreciably together prior to January 29th, 2022.
But they do now, don't they?
Is when Mr. O'Keefe nicely took them out for sneakers because he had some sort of deal at a Reebok's outlet or something like that to sort of try to pay them back for the help that they provided him and the children. Jennifer with respect to the niece and Kerry with respect to the nephew. But they're both contacted by the defendant in the early morning of January 29th.
We
As
know.
Ms. McCabe testified, John was my friend.
We've covered
I
that.
love John. He was an amazing guy. At the waterfall, Mr. Alberts
We're gonna hit that
said going home
firefighter
to have a
funeral
drink with his son, Brian
and
Jr., if
NYPD
anyone
too.
wants to come. Open invitation to the table.
The trip to New York.
She said to Mr. O'Keefe and the defendant, you guys should come. Both the defendant and the victim indicated that they wanted to come and that they were coming. She describes the phone calls and the text messages that she receives from Mr. O'Keefe, that she's providing directions. She indicates she's providing them directions to go down Chapman. She describes how that is. And you've heard this testimony from a couple of different witnesses as far as the steepness as you're going down Chapman, going down Fairview of coming off of Chapman. That you first go down a big, steep hill. It flattens out for a little bit, and then you go down a second. 2 hills going down on Chapman. Matching the GPS native location and the health data as far as where Mr. O'Keefe's phone is, a half mile away from 34 Fairview Road at the time that his health data is reporting that he's ascending or descending 3 flights of stairs. You hear the testimony from Ms. McCabe as far as the last time that she spoke to Mr. O'Keefe. And she's still trying to provide directions to Fairview because Mr. O'Keefe has never been there before and neither has the defendant, which is further corroborated in Trooper Garino's testimony as far as the vehicle passing by Fairview and then coming back in on the other side, having to reverse direction. But she's giving directions and she indicates that she uses a house that Mr. O'Keefe will be familiar with that belonging to Bella or Bella's mom. Bella's mom is an ex-girlfriend for a short period of time, a long time ago. However, in the defendant's mind, it's so prescient on her mind that she's still talking about it the next morning or later on that morning when she's riding, going towards Fairview Road with Miss Roberts and Miss McCabe in Miss Roberts' car. She's still talking about it at that time. It's that much on her mind. Miss McCabe indicated that she looked out and she saw the vehicle initially in front of the front door, as did Mr. McCabe, as did Brian Albert Jr., as did Julie Nagel, as did Brian Nagel, and the vehicle moved up several times or several spots to where it was then positioned. Initially at some point in front of the door, then it moves up further so that it's in the area of the fire hydrant and the flagpole where Mr. O'Keefe's body was discovered later on that morning, at least by Ms. McCabe and Ms. Roberts, and then moves up further beyond that. And I say that in the sense of it moves up further beyond that with sufficient distance for it to then go in reverse for 62.5 feet at 24.2 miles per hour, striking Mr. O'Keefe and leaving him where he was found later on the 29th. Again, the testimony from Ms. McCabe that about 12:40 when she's texting him, she indicated in her testimony she couldn't be certain if Mr. O'Keefe was still out front or had left at that point. She wakes up to a phone call from John's niece, Kaylee, at 4:53 in the morning. This is from an 8th grader, 14-year-old girl. That's why she answers the phone at 4:53 in the morning. She then hears the defendant screaming loudly over and over again, Jen. John didn't come home, got in a fight, left him at the waterfall. The variations, the different iterations of that story as it evolves and changes over the course of that morning. Ms. McCabe then indicates to the defendant, we saw you outside of my sister's house. Then she starts yelling, Jen, did I hit him? Could I hit him? Then they start discussing, or the defendant brings up her cracked tailgate. Then both Ms. McCabe and Mr. McCabe hear the defendant screaming outside of their home at about 5 o'clock in the morning, or shortly after 5 o'clock. They go to Mr. O'Keefe's house. And both Ms. McCabe and Ms. Roberts indicates, and you heard this testimony from a number of different witnesses, friends and family of Mr. O'Keefe, that he had a rule, pretty strict rule in his house as far as you take your shoes off when you come in.
That's
So
it.
what did Ms. McCabe
She
and
didn't
Ms.
take
Roberts
off her
both do
shoes.
when they're entering in that house on January 29th? They take off their boots, they get out in the snow, they take off their boots in the mudroom, and then they walk. What did they both indicate that the defendant did that morning when she came back to the house?
She didn't take off her shoes.
Walked right in with the shoes. You hear that second voicemail. It's after the defendants arrive back at One Meadows Ave, after her phone is reconnected with Mr. O'Keefe's Wi-Fi. And you can hear the footsteps. Part of that may be in the garage, part of that might be in the house.
With
Why
her
is it that
shoes
the
on.
defendant have no issue with wearing shoes in the house when Mr. O'Keefe has that strict rule? Because she knows where he is. She knows it's not an issue, he's not coming home because she hit him with her SUV and she left him in the snow. Ms. Roberts and Ms. McCabe are frantically sort of running around the house looking for Mr. O'Keefe. Defendant's not. They then get in the vehicle. They drive back towards Fairview Road. And again, the defendant from the back seat of the vehicle immediately sees the defendant, starts pulling and kicking on the door, and runs in sort of a beeline straight over to where Mr. O'Keefe is laying on the front lawn.
Nailed it. That's gold, Jerry. Gold.
You have the testimony from Ms. Roberts as far as John's phone. John's phone, when the firefighters pick him up, and you recall several witnesses testifying about that, pick him up on the scoop stretcher and they bring him over to the ambulance while they're conducting the resuscitative efforts trying to save Mr. O'Keefe's life. Well, Ms. Roberts indicated that she observed underneath it, only the phone, but the phone on the grass. On the grass in the area that is completely covered in snow in every other area except under Mr. O'Keefe, which I would submit indicates how long Mr. O'Keefe has been there. Now recall, around 12 o'clock or so is when it starts to snow and it starts to stick a little bit. You heard all that testimony. And I know it was a lot of testimony about snow, and a lot of testimony about weather, but there's a purpose to that. There's a point to that, okay? As far as the grass underneath Mr. O'Keefe's body, where his cell phone was, Ms. Roberts observed some 6 hours later after it starts snowing, is still visible only under Mr. O'Keefe where his body is, which I would submit as evidence to you as to how long he's been there. Now, on
It's
top
not
of
the
that,
photos.
you also have hours of ring videos of the driveway as far as shoveling and Paul O'Keefe and other people snow blowing and shoveling and all those kinds of things. There's a purpose to that as well. If you look at those, if you look at the video of the defendant crashing into Mr. O'Keefe's vehicle at a speed of anywhere from 0 to 5, which even Dr. Wolf would indicate would not cause the damage to the taillight that was observed in this case. You know what you don't see? You don't see snow move off Mr. O'Keefe's vehicle when they come into contact. You don't see any red or clear plastic pieces in the snow. And if you look at those stills, not the ones that counsel put up there during his closing, but if you look at each of the video and the stills, you can see the damage consistent with the taillight at each and every point. You see the damage consistent with the taillight from the 507 video. You see the damage consistent from the 822 video from Lieutenant Ray from the cruiser camera video when he's pulling into the driveway. You see the damage consistent from the Dighton video at the defendant's home. You see the damage consistent from the right here, February 1st, 2022, when the search warrant is conducted and Ms. Hartnett removes all those pieces from the vehicle. The weather is also important when it comes to the hair. The magic hair, as Mr. Jackson likes to call it. See, the magic hair was actually frozen to the vehicle, as was the glass to the bumper, because
The
the
whole
vehicle
reason
looked like that on the
they
left.
took it
when
there
was
so it
caked
wouldn't
in
be
snow.
frozen.
And Officer Barrow saw it in the driveway in Dighton as they were wading through 1.5 feet of snow, walking up. Because remember, they didn't even pull into the driveway because they had to have someone come down and plow it before they could get into it. That's what the vehicle looked like. What you can see, however, is the damage to the taillight, to the side of that taillight, consistent with it. So that hair, that 7/8 of an inch hair, was frozen to the side. And as you remember, the testimony from Sergeant Buchanan about the heated condition of the Canton Police Department garage, and that's one of the reasons that they took it there, because the other barracks that they could have taken it to didn't have that heated condition. So yes, after it's been in there from January 29th, about 5:30 p.m. until February 1st, when they conduct the
Does it
search
look a little
warrant,
red?
the hair isn't still frozen, as it's contained within heated garage, and the pieces of glass on the rear bumper have melted. The snow has melted, as you can see from left to right. The weather, also important, I would submit, weather was a weapon. Remember, the cause of death here is not just blunt impact injuries, it's blunt impact injuries and hypothermia. You heard all that medical testimony in relation to, and you heard all that testimony in relation to the snow and the weather and the wind. Wind gusts up to 37 miles per hour while he's out, Mr. O'Keefe is out there in just a shirt and jeans. Now, you heard also testimony from Ms. Roberts in relation to the injuries she observed to Mr. O'Keefe. That's initially on scene. There was one eye that was swollen, not the other. That's indication of the swelling that Dr. Scortibella was testifying to, and no indication of physical altercation. And then both eyes being swollen when Ms. Roberts viewed Mr. O'Keefe's body after his passing at the Good Samaritan. Submit that all the testimony tells you the same consistent account, internally, externally, from civilian testimony to investigator testimony to medical testimony to forensic testimony to the reconstruction testimony. You have the testimony from Ms. McCabe and Ms. Roberts that they couldn't see Mr. O'Keefe at Fairview when they initially pulled up. You can see that from Officer Saraf's cruiser. You have Mr. O'Keefe being covered in snow from the storm. You know where Mr. O'Keefe's body was. It's clearly visible on the cruiser camera from Officer Saraf. You have the testimony from each of the responding officers, anywhere from 5 to 12 feet off the roadway, and from the civilians as well. Ms. McCabe, Ms. Roberts, Officer Mullaney has 6 inches of snow on Mr. O'Keefe when he first sees him. Firefighter Kelly says that he couldn't even see Mr. O'Keefe until he was 5 feet away, in the darkness, in the snow, in the blizzard conditions. There's no footprints around the body. There's no drag marks around the body. there's no evidence of anything in relation to Brian Albert and Brian Higgins. Brian Albert and Brian Higgins spent January 28, 2022, traveling to New York City to go to a
Here it is.
funeral for another police officer, for another department, who they didn't even know. Traveled all the way down to New York and then came back before the blizzard, only to come back from that to go out drinking, to come back to Mr. Albert's house, to then murder another police officer who they did know, who worked for the same department as them. And then criminal mastermind genius that Brian Albert is, 28 years on the Boston Police Department, he's then going to just leave Mr. O'Keefe's body on his front lawn? Really? That's the conspiracy? What evidence do you have of that? You have statements that the defendant made to Sergeant Buchanan on January 29th. She was willing to speak, but didn't want to give too much detail. Conversational tone throughout. She indicated that the night before, they had gotten into an argument, something about what was fed to the children, nothing about the detailed arguments, incessant phone calls, and everything else that you saw from the defendant and Mr. O'Keefe's phone on the 28th. She indicated that she got to C.F. McCarthy's around 9 p.m., started drinking vodka sodas, the men were drinking beers. When asked where she parked her vehicle, she said she parked on Washington Street across from C.F. McCarthy's, facing northbound on the side, same side as Waterfront. Same testimony that you heard from Ms. Kolakithis, observing the defendant going over to her vehicle, getting in the driver's seat, and the victim, Mr. O'Keefe, getting into the passenger seat. She said they were left the waterfall, were invited to her residence. She drove her and John to the location in Canton. She dropped Mr. O'Keefe off, did not see him walk into the home. She, being the defendant, stated she made a 3-point turn and then left. When asked about the damage to her vehicle, she indicated to the troopers, "I don't know, it happened last night." June 2022, you have that other recording of that other version that she now has evolved into, as far as stating to Sergeant Buchanan, "Are you aware that John was beaten up by Brian and Colin Albert? We're all in on the same joke, right? John was pulverized and my taillight was cracked." What evidence do you have?
All in on the same joke.
Mr. O'Keefe never went in the house. You have testimony from Nicole Albert, Brian Albert, Jennifer McCabe, Matthew McCabe, Caitlin Albert, Brian Albert Jr., Sarah Levinson, Julie Nagel, all indicating never went in the house. John O'Keefe's phone never went in the house, from the testimony and the data points that you have from Trooper Green. You know how Mr. O'Keefe was dressed, and you know the defendant knew that. You have the testimony from Kurt Roberts, Jennifer McCabe, Matthew McCabe, Karina Kolakithis, Nicholas Kolakithis, Brian
Give me
Albert,
the names.
Cole Albert, Brian Higgins.
Lots of names.
All indicated in their testimony, and the defendant knew, based on her questions to the firefighters the next morning, that Mr. O'Keefe was not dressed for the weather when he left the waterfall. The weather was a weapon.
Was it the murder weather?
You have the testimony about the car, the defendant's car being there in front of the house, moving multiple times. You have that from multiple sources. You have that from Matthew McCabe. You have that from Jennifer McCabe. You have that from Brian Albert Jr. You have that from Julie Nagel. You have that from Ryan Nagel. You have the testimony of Ryan Nagel, Ricky D'Antonio, and Heather Maxson. Ms. Maxson indicated she saw a male passenger, female operator, as the vehicle was turned. Remember, they're coming towards Fairview at the same time. The defendant, after conducting that reverse or 3-point turn on Cedar Crest, is then taking a right onto Fairview, while Mr. Nagel, Mr. D'Antonio, and Ms. Maxson are taking the left onto Fairview. Mr. Nagel indicates that Mr. D'Antonio then flashes lights. During that time, Ms. Maxson can see inside the vehicle. She sees a male passenger. She sees a female operator. They follow the vehicle as they're turning onto the street. Lo and behold, they're going to the same residence. They park. There's nothing in between them and the defendant's vehicle. They indicate that at no time do they see anybody get out of the vehicle. At no time do they see any damage to the vehicle, or it hasn't happened yet. At no time do they see anyone leave the vehicle and go into the house. The vehicle moves up on different successive occasions, as testified to by Mr. Nagel and several others. And then as they're passing that vehicle, Mr. Nagel indicates that he sees a female operator in the vehicle with the dome light on. Interesting, when I asked Mr. Nagel, as far as when Julie Nagel came out to the vehicle, did he roll down the window or did he open the door? He indicated he opened the door. And I asked him, what happened when you open the door? What happens when you open the door to a vehicle? The dome light comes on. So there's reason I would submit, or the inference that you can make, is that no one sees Mr. O'Keefe in the vehicle because that's the moment he steps out of the vehicle. And then they're gone. The Nagels, Brian Nagel, Ricky D'Antono, and Heather Maxson drive away from that. We have the testimony from Julie Nagel and Sarah Levinson, the peanut butter and jelly sandwich conversation they have with Ms. McCabe, which while
How
they're
could
pulling
we
away from
forget
the
it?
house where everybody's attention is drawn, Ms. McCabe is turned around facing both of them in the backseat. Ms. Nagel is facing Ms. Levinson on the passenger side, looking out the window towards 34 Fairview Road. Ms. Levinson is looking back at Ms. Nagel away from that area, in which Ms. Nagel indicates that she sees a 5 to 6 foot dark blob on the lawn near the pole in the hydrant, which is just where Mr. O'Keefe is discovered the next morning.
Weird how Jim McCabe didn't remember that.
You have the testimony recalled, and you have text messages in regard to Colin Albert when he gets picked up.
Mr. Lally, 5 minutes.
Yes, Your Honor.
Thank
Colin
God.
Albert, Miss Allison McCabe, Brian Albert, Nicole Albert, Caitlin Albert, Brian Jr., all indicating that it was picked up around that time at 12:10 a.m. You have the testimony from Chris and Julie Albert, his parents, as far as when he comes home, kisses them goodnight before he goes to bed. You have that testimony in regard to Chris Albert, as far as how John O'Keefe and the defendant come to be at the waterfall in the first place, as far as John O'Keefe and his nephew coming in earlier in the day, getting a couple slices of pizza, what are you doing later on, contained within those
We
testimonies.
have Chris's testimony. Indeed,
You have
we
testimony
do.
from Lieutenant O'Hara, Lieutenant Tully, Sergeant Mechanic about those items being recovered. And in particular, the items being recovered on January 29th by that search. What did Lieutenant O'Hara say? The items were found close to the curb. The items were at ground level. 3 feet of snow that they had to sift through in order to find those particular things. The detail or the delay in the recovery of evidence. The photos in the video, most of which you have in evidence, is earlier in the storm. This is before the 18 inches of snow falls down, before there's drifts and 3 feet of snow in places. They found the evidence where it had been at that same ground level, in the grass, under the snow, at 34 Fairview Road. We heard all of the medical testimony, which I would submit is consistent, from firefighter Formati to Dr. Rice. We heard the testimony regarding the defendant's blood alcohol concentration from Dr. Fowler and Nick Roberts, 93 milligrams per deciliter, 0.07 to 0.08% at 9:08 in the morning. We heard it, Mr. Roberts' testimony in regard to the retrograde extrapolation, 0.13 to 0.29, extrapolating back to the time of the operation. The defendant admits to drinking vodka. It's on the receipts from C.F. McCarthy's and from the waterfall. And you have the witness testimony in the surveillance video in regard to it. The forensic testimony that you have. In regard to the medical testimony, you have the sort of pattern abrasions, clear plastic that's recovered by Lieutenant O'Hara and Lieutenant Tully on January 29th. The clear plastic that has the dimples on it. No one, not Trooper Paul, not anyone, at any point in time ever said Mr. O'Keefe's arm was out like this at the time that he struck him, and he did a
Well, he
pirouette.
did. He said
and
it was like
flew 30
this.
feet in the air.
He did.
12 inches of abrasions that the doctors were, the biomechanical people were talking about yesterday. 12 inches and then 6 inches to the tail end is easily solved by this. And the dimples on his arm are, that I would submit are consistent with the dimples on the tail light cover piece, are right around this area of the elbow. We have testimony in regard to forensics as far as Mr. Porto, Mr. Bradford. John O'Keefe's DNA is on that tail light housing, on the house. His DNA is there to the exclusion as well of Sergeant Mechanic and Trooper Proctor. Mr. O'Keefe's DNA is on the exterior of the broken drinking glass. Mr. O'Keefe's DNA and only Mr. O'Keefe's DNA is on his clothing and his fingernails, consistent with Dr. Scortibello's testimony that there is no evidence of a fight or an altercation. There's no one else's
Not only
DNA
his
on
on
his
the
fingernails,
clothing.
there's no one else's DNA on his clothing.
That's not true. That's a
You have,
lie.
testimony from
That's
Ms.
a lie,
Hartman and Trooper
Lally.
Paul as regard to the damage that they observed, the dent, scratches, the 7/8 of an inch hair. You have the testimony from Ms. Chart in regard to the mitochondrial DNA profile from that hair being consistent with the DNA profile of Mr. O'Keefe. You have the testimony from Ms. Valier and Ms. Hanley in regard to the microscopic pieces, 1/16 of an inch by 1/16.
You have 1 minute, Mr. Lally. Wrap it up.
Yes, Your Honor.
Wrap it up.
All consistent with pieces of taillight that are found within his clothing.
That was absolutely a lie. There was like one swab of his clothes that was only his DNA. Everything else was a mix.
605, this is what this vehicle looks like backing up at that speed for approximately that distance. There's another, years and years ago, started practicing in Norfolk County in Braintree, what is now Quincy. I eventually became a far smarter man than myself, eventually became president of the United States. His name was John Adams.
Oh
John
my
Adams
God.
once wrote, "Facts are stubborn things. And whatever may be our wishes, our inclinations, or the dictates of our passions, they cannot alter the state of the facts and the evidence." What the constellation of the facts and the evidence ineluctably demonstrate here
That's where
Is
he
that the
got
defendant-
ineluctably.
drove her vehicle in reverse for 24.2 miles per hour for 62 and a half feet, struck Mr. O'Keefe, causing those catastrophic head injuries, leaving him incapacitated and freezing to death.
Mr. Lally, I have to stop you. You've gone over. Okay.
I literally have one sentence.
1 sentence I'll give you.
From that facts and that evidence, I would submit ineluctably demonstrates her guilt on each of the indictments before you, and I would ask that you find this. Thank you.
All right. Thank you.
Ineluctably was his
Jurors, I have
Sesame
9
Street word
sections of
today.
law I'm going to give you. My guess is it's probably about an hour. I'd like to start it now, but does anybody need a short break? We can take a short break. Okay, we'll come back in 5 minutes.
So we're gonna do the short break and then come back for the instructions. Ineluctably, is this like the equivalent of trying to make things look sciency, or do you think your case looks intelligent because you used the word ineluctably instead of just inescapably or something like that? That's a little bit more plain language.
Hey there, Karen Reed, trial watchers.
My bad. Not gonna hear it, Jesse. Not today. Oh man. Well, I mean, this definitely competes with his opening in terms of just a complete lack of structure and coherence, all over the place, repetitive, not a consistent timeline, the name dumps of who we heard from, flatly ignoring the stuff that can't be dealt with. Your own medical examiner. How do you deal with that? You don't. So he just really illustrated what Mr. Jackson was saying was going to happen, didn't he? Look the other way. Look the other way. Don't pay attention to that man behind the mirror, that medical examiner, those engineers, those deleted calls, those butt dials. Look the other way. Look the other way. Instead, we got a timeline of the text messages and the voicemails. Yeah. The murder weather was a really nice touch, though. I did enjoy that. I mean, everyone's in on it except the Alberts, apparently. Even the weather gods, even old Zephyr himself was in on that murder. And the nobody else's DNA on his clothes. Flat out lie. Flat out lie. Flat out lie. There was 1 or 2 swabs from his clothes that had only his DNA. Everything else a mix. Everything else a mix. His shoes, so many people's DNA on his shoes that they can't even compare it. They can't even do a comparison because the mixture is too complicated at that point. There's just too many contributors to be able to sort it out. Multiple contributors all over his shirt. Flat out lie. Would have liked an objection. Didn't get it. Didn't get it. Yeah, God is an unindicted co-conspirator. I mean, yeah, just point the finger everywhere, but at At the McCabe's and the Alberts, apparently. Couldn't possibly them. Anybody else that it could be. Oh man, guys, we got a lot of comments to get through here while we wait for the instructions. Can't wait to see your takes on all this. John Duncan, do you think you may cover the Baldwin trial, Andrea? I am starting to take a look at that. I've been aware of it, obviously, just, peripherally, but haven't looked real close in terms of following the pleadings and stuff like that. But I'm definitely interested. He made comments in that Stephanopoulos interview that did not appear to be particularly helpful to me. He's kind of, made some claims that are going to be hard to back up as far as, I didn't pull the trigger and stuff like that. So it is an interesting one, but I think it's a situation where I feel like his role as the producer may have as much, if not more, of a role to play in how the jury evaluates the case, as just the fact that he happened to be the person who was on the set, following the instructions he says that he was given. Because of the fact, of course, we know already the armorer has been convicted, some pretty scathing language from the court at sentencing as far as just the culture that existed on set. It was extremely reckless, really no excuse for it. And to the extent he was a producer, Baldwin was at least partially responsible for that. I think that's going to be a big question I'm going to have, is what exactly was his role? Is this just a figurehead thing where he gets a billing, he gets a credit, he gets, some financial benefit from it? Well, if you do, then seems like you're kind of responsible for some of the accountability for what's happening on that set as well. So I am interested in it, but we'll see. We'll see how it goes. Mo DeAngelis, thank you for all your fantastic commentary and analysis as this case went along. Truly the best straightforward channel I found. I will absolutely follow you going forward. Well, thank you so much. We're just here to call it like we see it. That's it. Not everybody's going to see it the same way I see it. That's totally fine. I expect that. I get that. We all walk different paths and bring different perspectives and things like that. So, take my take for what it is. I try to be open about where I come from and what informs my perspective, the experiences that I've had that have led me to see things the way that I see them. And, some people may not find that valuable at all, but other people do. And I really appreciate that. So thanks so much for joining me here. Kat has gifted some memberships. Thank you so much, Kat. Thanks on behalf of everyone who got one of those. Not Squirrel, so I don't forget later. Thank you, Andrea. Thank you, Jeff Burkhart, for managing the chat so well and with humor. It's enjoyable to witness Andrea and Jeff's complete support and partnership. Yeah, we got it. We got a good little thing going here, don't we? Living the dream. Living the dream. Well, thank you so much for being here with us. You guys make it possible. You're the reason we have a chat to manage and conversations to have. So really appreciate all of you as well. Carazola X, from the makers of 23andMe, fingerprint friends, send us your fingerprints and we'll show you how many people have similar prints to yours. Yikes. Don't do it, people. Don't send your fingerprints to 23andMe. It might be interesting, but boy, that's when we could get into sometime the Brandon Mayfield case, the whole problem with fingerprinting. It's another one. Everyone thought it was super objective. Oh no, until you accidentally, match a fingerprint from the Madrid train bombing to an attorney down in Oregon who was nowhere near Madrid at the time. Yeah, then suddenly it becomes clear how much subjectivity there is, even in something that is supposed to be ostensibly objective, like comparing fingerprints and looking for points of similarity and stuff. Very much not the case. Everage, in the NL, they are seeking to access the databases. So I have seen a couple instances where police they've issued search warrants for the database, and I forget which jurisdiction it is, but at least one has approved that. They've allowed police to basically go in and seize that data from the database anyway, regardless of whether people consented to it or not, under the guise of a search warrant. So that's a little disturbing that it's just now your DNA, if you've submitted it, it's a public resource out there for anybody law enforcement to access as they see fit. Arla 7247, question, are you taking the break from the courtroom? I am. I'm not taking any new cases right now. I still have a caseload, appeals that are ongoing. It takes a long time for them to work through the system. But I'm taking a little sabbatical. I think I've been in the trenches for quite a few years, and it's just been a good timing wise, good opportunity for me to step away and kind of focus on some other things. Of course, still, maintaining my relationships with folks in the criminal community, criminal justice community here where I am and stuff. So I don't know if it'll be a permanent thing, but I am taking a little bit of a break right now. Farrell Drake, scared of the manslaughter instructions. It's normal, typical to address the instructions in the closing argument, especially the prosecutor. Go ahead and go through them, identify for the jury what they have to find, and then explain to them how those elements are satisfied. Did find it a bit peculiar that neither one of them even mentioned the jury instructions, other than Mr. Jackson addressing that definition of reasonable doubt. An abiding conviction to a moral certainty. I mean, it's pretty strong language they get in Massachusetts. I'm not super surprised that the defense doesn't mention the rest of the elements here, because their bottom line is she didn't hit him with the car. So the rest of it doesn't matter. All of the charges depend on her hitting him with the car. If she didn't hit him with the car, you can't convict of anything. For Mr. Lally, we just got the BAC as like an afterthought there at the end, not addressing all of the testimony from all of your witnesses that you've named off for us and told us why they're so believable, that she was totally fine, didn't seem drunk at all, didn't seem to be under the influence, no concerns about her driving. So I don't know that there is that much to be concerned about with the instructions. It all depends on, did she hit him with the car? That's what the defense focused on. It's the linchpin of their case. Franz Marks looks like murderer's row back there. Where's Nicole? It's kind of weird, who's choosing to be here and who's not. We got Colin, we got Brian, and we got Jen, and we got Carrie Roberts. Just interesting. Dominique Foster, unreal. After all the lies that have been uncovered, I'm surprised J.O.'s family still believes them. That makes me sad. They still hate her. Yeah, they do. I mean, it sounds like that preceded this anyway. If they're at the hospital blaming her for dropping him off, it's her fault. They can say after the fact, oh, she was great for John, such a good influence and so forth. But that, to me, that tells a lot. That is not an empathetic, not a kind, just how do you, I recognize you're grieving too, but your grief should not turn off your sympathy for the other people that are also grieving. This is an opportunity to bring you together. Why would you use that to blame somebody at a point in time where you have no reason to think she's to blame? Just literally blaming her for dropping him off. It's very sad. All right, looks like court is back. So let's go ahead and get those instructions.
Yes.
Thank you. Be seated. Close back.
All right, jurors. Thank you for serving on this jury and for being so attentive. You'll soon deliberate for the purposes of reaching a verdict in this case. But before you do that, it's my responsibility to give you instructions concerning the law. The instructions are divided into 3 parts. The first is general instructions that are provided in every criminal case. The second, specific instructions concerning the crimes alleged in this case. And third, guidelines for your deliberations. Please listen carefully to all of the instructions. Do not ignore any instruction or give special attention to any other instruction. To make sure that I give you the instructions accurately, I will read them to you. You will also get a written copy. I'll probably send in 3 or 4 to the jury so that you can refer to it in the jury room during your deliberations. I will try to make sure that my oral instructions match the written instructions. If there is any difference between what I say aloud and what the written instructions say, please follow what I say aloud. You must take the law as I give it to you. You may not quarrel with it. You can't do that regardless of any opinion you may have as to what you think the law ought to be. What the lawyers or witnesses may say or suggest about the law is not necessarily the law. That's because it's my responsibility as the judge and mine alone to instruct you on what the law is. So I now will turn to part 1 of the instructions, the general instructions that apply to all criminal cases. As I explained to you at the beginning of the trial, there is a fundamental rule that applies in all criminal cases, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Ms. Reed is presumed innocent of the charges in this case. That means you must consider Ms. Reed to be innocent unless the prosecution is proved beyond a reasonable doubt through evidence presented during the trial that Ms. Reed committed the crimes charged. I will explain reasonable doubt in just a moment. Ms. Reed does not have to do anything to convince you that she is innocent. She does not have to explain anything. Ms. Reed does not have to testify, call, or question witnesses or provide any evidence at all, because you must presume she is innocent. Instead, it is up to the Commonwealth to prove the charges against Ms. Reed beyond a reasonable doubt. The burden of proof never shifts to the defendant. After you have considered all the evidence carefully and fairly, if you have a reasonable doubt about Ms. Reed's guilt in a particular charge, then your verdict must be not guilty on that charge. You may find Ms. Reed guilty of a charge only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Now, how do you decide whether the Commonwealth has proven each element of an indictment is true beyond a reasonable doubt? Let's talk first about the roles we all have. You folks are the most important people in the courtroom. It all begins and ends with your function. You will determine the facts in this case, and that is your job and your job alone. You are the sole and exclusive judges of the facts. If there are any conflicts in the testimony, it is your job to resolve those conflicts if you can do so. Once you determine the facts, it is your duty to apply those facts to the law as I explain it to you, and to determine whether the Commonwealth has proven its case beyond a reasonable doubt. You must determine the facts solely and entirely on the evidence as you have heard it and seen it in this courtroom and on nothing else. No prejudice, no bias, no fear, no favor. You must not be swayed by personal likes or dislikes. Your deliberations are no place for emotion or sympathy, passion or prejudice. The Commonwealth and Karen Reed have a right to have the case judged by fair and impartial jurors. All parties who come before the court stand as equals before you. Therefore, your verdicts must be based on the law as I've given it to you, and on the evidence and the facts that you find, and nothing else. You cannot allow yourselves to be influenced by any personal feelings you may have about the nature of the crimes with which Ms. Reed has been charged, or the consequences of your verdict. Just the cool, reflective, and impartial sifting of the evidence so that here in this courtroom, justice may be done. Now, your focus is on the evidence. I am the judge of the law. My job is to teach you the law that you must follow in this case. However, I have no opinion about how you decide this case. You should not consider anything I have said or done during the trial as reflecting any opinion by me about how you should decide this case. If you believe that I have an opinion about the facts of this case, you must disregard it. You must decide this case based solely on the evaluation of the evidence. Now, the arguments of the lawyers are not evidence. They are not witnesses. If a lawyer during argument made a mistake in summarizing the evidence or argued something not supported by the evidence, you must disregard it. It is the jury's collective memory of the evidence that controls the matter. Lawyers' objections are a proper part of the court's procedure and are not part of the evidence. So don't hold it against the lawyers or their client if they made objections, motions, or other requests. They're simply doing their job during a trial. There was testimony at trial that the lawyers interviewed witnesses when preparing for and during the course of the trial. You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the lawyers are obliged to prepare their case as thoroughly as possible and may interview witnesses. Now, the verdict must be based only on the evidence and the jury's collective reasoning applied to the evidence in a fair and impartial manner. The extent to which you believe or disbelieve a witness or what an exhibit purports to show, the importance to give any testimony or other evidence is entirely up to your own good judgment. The evidence consists of the testimony of the witnesses and the exhibits in the case. There are some things you have heard about that have not been introduced into evidence, such as written statements by witnesses, police reports, autopsy, and accident reconstruction reports. Occasionally during the trial, you have heard references to such documents, and you may naturally wonder why neither side introduced any of them into evidence. The answer is that under our rules of evidence, such reports usually may not be admitted, although the parties may refer to them for certain limited purposes while questioning witnesses. So you should not hold it against any party that you do not have them, and neither should you speculate on what they may or may not contain. Similarly, as you view exhibits, you may find that some information has been removed because it is not relevant. Please ignore that and don't try to guess what may have been removed or why. Any information that you may have read, heard, or seen about this case outside of the courtroom is not evidence. My instructions to you and any other comments I made, the lawyer's opening and closing statements, and any comments they may have made are not evidence. Answers that I struck from the record and told you to disregard are not evidence. Only the testimony of the witnesses, that is, their answers to questions, and the exhibits are evidence. It is important to remind you folks that the verdict cannot be based on emotional reaction or sympathy for any person or side of this case. Certain of the testimony and exhibits may have provoked an emotional reaction in all of us. You may feel sympathy for the family of Mr. O'Keefe, and you may feel sympathy for the defendant as she sits here in this courtroom. But your job is to decide the case without bias, fear, sympathy, or favor, to view the evidence with a certain clinical detachment, and to decide the case based solely on the evidence and the application of the law to that evidence. I have allowed you to take notes during the trial, and you may refer to those notes during your deliberations. But remember, they are not evidence or a substitute for the evidence and your recollection. They are for your personal use. Please do not share them with other jurors. Consider the evidence as a whole. Do not make up your mind about what the verdict should be until after you've gone to the jury room to decide the case and you and your fellow jurors have discussed the evidence. Please keep an open mind until then. You'll remember that we took a view in this case. The purpose of the view was to help you better understand the evidence that you heard during the trial and to help you appreciate the locations and their surroundings. Your responsibility in the view was to see the places, observe them carefully, and remember what you saw. The view is part of this case. You may use and consider the observations that you made while on the view in your deliberations in reaching a verdict. The same is true about the demonstration we saw from the witness stand. The demonstration was done simply to help you understand the evidence, and you may consider it in your deliberations. It is the jury's job to earnestly seek the truth of the matter. In doing that, the jury must decide questions of credibility and reliability. The jury must decide how truthful or reliable or convincing any part of the evidence is. In deciding questions of credibility and reliability, you may rely on your common sense and reasoning powers and your life experiences. Consider a witness's testimony in the context of all the other evidence, not in isolation. You may consider the demeanor, candor, and appearance of the witness in testifying. Who was the witness? What relationship did they have to the case or to the other witnesses or the parties? Did the witness have any bias, reason, or motive to give false or shaded testimony? If so, you may consider that bias or motive in your deliberations and ultimately as to whether or not it impacts the credibility of the witness and the assessment of the evidence presented. Is the witness someone likely to give an honest and impartial account? Consider not just whether the witness was honest, but also whether the witness's testimony was accurate and reliable or honestly mistaken. A prior statement by a witness, if inconsistent with his or her trial testimony in any way, may be considered on the witness's credibility and reliability, and only for that purpose. Now, you've heard some evidence suggesting that the Commonwealth did not conduct certain scientific tests or otherwise follow standard procedure during the police investigation. This is a factor you may consider in evaluating the evidence presented in this case. With respect to this factor, you should consider 3 questions. First, whether the omitted tests or other actions were standard procedure or steps that would otherwise normally be taken under the circumstances.
She changed her mind. She's given the Bowden.
Whether the omitted tests or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omission of the test or other actions. If you find that any omissions in the investigation were significant and not adequately explained, you may consider whether the omissions tend to affect the quality, reliability, or credibility of the evidence presented by the Commonwealth. All of these considerations involve factual determinations that are entirely up to you, and you are free to give this matter whatever weight, if any, you deem appropriate based on all the circumstances. Now, during the trial, I gave you some limiting instructions on how you were to consider some of the evidence you heard, and importantly, how you are not to consider the evidence. I am going to summarize those limiting instructions here. Ms. Reed is not charged with committing any crime other than the charges contained in the indictments. You have heard evidence about interactions that Ms. Reed had with Mr. O'Keefe and other witnesses in Aruba. The evidence was admitted solely for your consideration as evidence of the nature of the defendant's relationship with Mr. O'Keefe and whether it goes to her knowledge or intent or motive on January 29th, 2022. You may not consider that evidence as proof that she has a criminal personality or bad character. You may not take the defendant's prior acts as a substitute for proof that the defendant committed the crimes charged here, or to conclude that if she committed the acts in Aruba, she must also have committed the offenses with which she is charged here. You can only use the evidence for the limited purpose of how it goes to the defendant's state of mind, motive, and nature of her relationship with John O'Keefe. Before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the persons who authored them were in fact John O'Keefe, the defendant, or the witnesses who testified about their communication with John O'Keefe and/or the defendant. If you do not find it is more likely true than not that John O'Keefe, Karen Reed, or the witnesses who testified here before you were the persons who authored or transmitted the electronic communications, then you may not consider the electronic communications in deciding the case. Now, the Commonwealth has introduced photographs into evidence. The photographs may be graphic and unpleasant. As I told you when you first saw them, your verdict must not in any way be influenced by the fact that these photographs may be graphic or unpleasant. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy. Consider a photograph only as it may show a medical condition, the nature of the injuries, or the details of the incident itself. You've heard evidence of statements made by John O'Keefe. These statements were admitted only for a limited purpose of establishing John O'Keefe's state of mind. You are not to consider this testimony as proof that the defendant has bad character or propensity to commit crimes. The testimony of witnesses recounting conversations with Mr. O'Keefe or messages the defendant's cell phone received from him can only be used as they go to the defendant's motive or intent on January 29th, and only if you find that the defendant was aware of John O'Keefe's state of mind at the time of the crime and would be likely to respond to it. There need not be direct evidence that the defendant learned of Mr. O'Keefe's state of mind, so long as you reasonably can infer from the evidence that she did learn of it. You've also heard testimony about statements allegedly made by Ms. Reed. Before you may consider any such statement, you are going to have to make a preliminary determination whether it can be considered as evidence or not, and for what purpose it may be used. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she is alleged to have made, and that she made it voluntarily, freely, and rationally. In determining whether or not any statement made by the defendant was voluntary, you may consider all of the surrounding circumstances. You may consider any evidence that you have heard about the defendant's physical and mental condition, her intelligence, age, education, and experience. Your decision does not turn on any one factor. You must consider the totality of the circumstances. Some testimony came from witnesses who saw or heard something. Some witnesses also told you about opinions or conclusions they reached based on some special training or experience. But special training or experience does not necessarily make the witness's testimony any more believable or important than any other evidence. So you should consider the same questions about witness testimony that I mentioned earlier, including any bias or motive these opinion witnesses may have had to testify in a certain way. You may also consider the witness's level of experience and training, and whether they base their opinions on the facts that you find to be true. There were hypothetical questions asked of some of these witnesses. You may give whatever weight you deem appropriate to the opinion based on the hypothetical, but only if, after careful consideration, you find that all the assumed facts are true. Remember that witnesses, even those with special training or experience, do not decide cases. Juries do. It is up to you whether to accept or reject, in whole or in part, any opinion or conclusion that a witness offered during the trial. Now, you have the same powers with respect to the exhibits that you have and the testimony of the witnesses. Look them over and decide the weight That is the value they deserve to receive in helping you resolve the case as you make your ultimate judgment about whether the Commonwealth has proved its case beyond a reasonable doubt. You do not have to believe something simply because it is written on a piece of paper or appears in a photograph. You are not, of course, required to disbelieve it because it appears there. You decide whether to believe what the exhibit purports to show and how much weight, if any, you give each exhibit. Now, you've heard me talk about the sources of evidence in this case. Those are the tools that we have to decide the case. Now, with the evidence in mind, what can you do with it? As jurors, you may bring to bear all your knowledge and experience. You don't check your common sense at the door to the jury room. Just the reverse. I instruct you to use your common sense. Give the evidence a reasonable and fair construction in the light of your common knowledge and experience. In determining the facts in this case, you may draw reasonable inferences from the evidence that you believe, because you are entitled to rely upon both direct and indirect or circumstantial evidence. Direct evidence is evidence of what a witness claims to have seen or heard or touched or somehow perceived with their own senses. Circumstantial evidence exists where a witness does not testify directly to the fact that is sought to be proven, but you are provided with evidence of other facts and then asked to draw reasonable inferences from them about the fact that is sought to be proved. Such inferences may be considered with all of the other evidence in reaching your verdict. Circumstantial evidence is competent to establish guilt beyond a reasonable doubt. Now, what do I mean by an inference? An inference is a logical deduction or conclusion that you may, but are not required to draw from evidence that you have accepted as believable. Inferences are little steps in reasoning, steps in which you take some known information, apply your experience in life to it, and then draw a conclusion. Sometimes you can draw more than one inference. You have to decide which inferences are reasonable and decide which seems more reasonable to you. Remember, when you are dealing with inferences, you never have to infer anything. You may, but do not have to draw any inferences whatsoever. An inference drawn from circumstantial evidence need not be necessary or inescapable, but any inference which you do draw must be reasonable and possible. It must be logical. It must be a natural one, which is not too remote in the ordinary course of events. You may not guess. You may not speculate. You may not engage in surmise. You should not pile inference upon inference until the pile gets so high that it tips over logically, or the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure that they're still reasonable. Further, when the evidence tends equally to give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all the evidence and the reasonable inferences that you have drawn, taken together, prove that she is guilty beyond a reasonable doubt. Let me give you an example of an inference. Suppose that the issue you must decide is whether the U.S. Postal Service delivered the mail today. If you go home and someone in your household, a child, roommate, or spouse, hands you the mail and states that he or she observed the letter carrier deliver the mail and retrieved it from the mailbox, this would be direct evidence that the U.S. Postal Service delivered the mail. The witness perceived the event with his or her own senses and told you what he or she observed. The issue you would have to decide is whether the witness is credible. On the other hand, if you go home from court and find mail in the mailbox, you may infer that it was delivered by the U.S. Postal Service today. You draw this reasonable inference based on the following known facts. The mailbox was emptied yesterday. You know that the mail is delivered by the U.S. Postal Service Monday through Saturday. The letters in the box are postmarked. You have exactly the same power in this case, not the power to speculate or to guess, but the power to draw reasonable inferences warranted by the evidence in the fashion I have just described. You may have noticed that the defendant did not testify at this trial. The defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that she is innocent. The fact that the defendant did not testify has nothing to do with the question of whether she is guilty or not guilty. You are not to draw any adverse inference against the defendant because she did not testify. You are not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses and the exhibits. All right, that completes my first part of the instructions.
So it doesn't look like she gave the consciousness of guilt.
Now I'm going to turn to the elements of the charges against Ms. Reed. The Commonwealth has alleged that on January 29, 2022, Ms. Reed did assault and beat John O'Keefe with the intent to murder him, and by such assault and battery did kill and murder John O'Keefe. Ms. Reed is charged with second-degree murder. In order to prove murder in the second degree, the Commonwealth must prove the following elements. First, the defendant caused the death of John O'Keefe. 2, the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of John O'Keefe. A defendant's act is the cause of death where the act is a natural and continuous sequence, results in death, and without which death would not have occurred. The second element is that the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, the second element has 3 subparts, which I will call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of the 3 prongs beyond a reasonable doubt. The first prong is that the defendant intended to kill John O'Keefe. This means that the defendant consciously and purposefully intended to cause John O'Keefe's death. The second prong is that the defendant intended to cause grievous bodily harm to John O'Keefe. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that she intended to perform the act, you must then determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. If you have a reasonable doubt as to whether Mr. O'Keefe's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved that the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. If the Commonwealth has proven both elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of those elements beyond a reasonable doubt, you must return a verdict of not guilty. The next is manslaughter while operating a motor vehicle under the influence of liquor. In order to prove manslaughter while operating a motor vehicle, the Commonwealth must prove the following 5 elements. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has a right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was a 0.08 or greater. You'll have both these choices on the verdict slip. Fourth, that the defendant operated the vehicle wantonly or recklessly so as to create a high degree of likelihood that substantial harm will result to another. And fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. So to prove the first element, the Commonwealth must prove beyond a reasonable doubt that the defendant was operating a motor vehicle. A person operates a motor vehicle while doing all of the well-known things that drivers do as they travel on a street or highway, and also when doing any act which directly tends to set the vehicle in motion. A person is operating a motor vehicle whenever they are in the vehicle and intentionally manipulate some mechanical or electrical part of the vehicle, like the gear shift or the ignition, which alone or in sequence will set the vehicle in motion. To prove the second element, the Commonwealth must prove beyond a reasonable doubt that the defendant operated a motor vehicle in a public way. Any street or highway that is open to the public and is controlled and maintained by some level of government is a public way. This would include, for example, interstate and state highways, as well as municipal streets and roads. In determining whether any particular street or road is a public way, you may consider evidence, if any, about whether it has some of the usual indications of a public way. For example, whether it is paved, whether it has street lights, street signs, curbing and fire hydrants, whether there are buildings along the street, whether it has any crossroads intersecting it, and whether it is publicly maintained. To prove the third element, the Commonwealth must prove beyond a reasonable doubt that while operating a motor vehicle, the defendant was under the influence of intoxicating liquor, that is alcohol, and or the percent of alcohol in the defendant's blood was a 0.08 or greater. I will now instruct you on both theories. What does it mean to be under the influence of alcohol? It is not illegal to drive after consuming alcohol as long as the operator is not under the influence of alcohol. However, neither does someone have to be drunk to be under the influence of alcohol. A person is under the influence of alcohol if they've consumed enough alcohol to reduce their ability to operate a motor vehicle safely by decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected emergencies. The amount of alcohol necessary to do this may vary from person to person. The Commonwealth is not required to prove that the defendant actually drove in an unsafe or erratic manner, but it is required to prove that their ability to drive safely was diminished by alcohol. You may rely on your experience and common sense about the effects of alcohol. You should consider any believable evidence about the defendant's alleged consumption of alcohol, as well as the defendant's appearance, condition, and behavior. In deciding this first theory of whether the defendant operated a motor vehicle under the influence of alcohol, you may also consider whether a blood test showed that the defendant had consumed any alcohol. However, no matter what the reading is, the blood test is not sufficient itself to prove that the defendant was under the influence of alcohol. Now, under the second theory, and again, both will be on the verdict slip and you should decide each one. The Commonwealth must prove beyond a reasonable doubt that at the time of operation, the percent of alcohol in the defendant's blood was a 0.08 or greater. The Commonwealth may prove a person's blood alcohol level by a chemical test or analysis of their breath or blood. In deciding whether the Commonwealth has proved the defendant's blood alcohol level beyond a reasonable doubt, you may consider evidence, if any, about whether the test was administered within a reasonable time of operation of the motor vehicle, whether the person who administered the test was properly certified, whether and how the pre-test procedures were followed and employed, whether the testing device was working properly at the time the test was administered, and whether the test was administered properly. You may also consider any other evidence pertaining to the test. Mr. Court Officer, I know it's traditional to not allow anybody in and out of the courtroom while I'm charging, so I'm going to ask you to follow that at this point. Thank you. It's distracting, and I don't want it to be distracting for you folks, okay? The fourth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant operated the vehicle wantonly or recklessly. A person drives recklessly when they ignore the fact that their manner of driving is very likely to result in death or serious injury to someone, or they are indifferent to whether someone is killed or seriously injured. It is not enough for the Commonwealth to prove that the defendant acted negligently. That is, acted in a way that a reasonably careful person would not. It must be shown that the defendant's actions went beyond mere negligence and amounted to recklessness. The defendant was reckless if she knew or should have known that such actions would pose a grave danger or death or serious injury to others, but chose, nevertheless, to run the risk and go ahead. Whenever I refer to the defendant's state of mind or her intent, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite state of mind or intent even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved the element. Here, the defendant must have intended her acts in the sense that they were not accidental, but it is not necessary that the defendant intended or foresaw the consequences of those acts, as long as a reasonable person would know that they were so dangerous that death or serious injury would probably result. As such, the Commonwealth does not need to prove that the defendant intended to kill John O'Keefe. Rather, this is in the category of cases where public safety requires each driver, once they know what the situation is, to determine and to adhere to an objective standard of behavior. In determining whether the defendant drove recklessly, you should take into account all the facts of the situation: the defendant's rate of speed and manner of operation, the defendant's physical condition and how well the defendant could see and could control the vehicle, the condition of the defendant's vehicle, what kind of road it was and who else was on the road, what was the time of day, the weather and the condition on the road were, and what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The fifth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant, by her actions, caused the death of John O'Keefe. The defendant caused the death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death, and without which death would not have occurred. If the Commonwealth has proven all five elements beyond a reasonable doubt, you shall return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the lesser offense of manslaughter while operating a motor vehicle under the influence of liquor includes the lesser offense of involuntary manslaughter. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with the lesser included offense. The Commonwealth may prove the lesser included charge of involuntary manslaughter even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. So I will define involuntary manslaughter. To prove that the defendant is guilty of involuntary manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. First, that the defendant caused John O'Keefe's death. Second, that the defendant intended the conduct that caused John O'Keefe's death. Third, that the defendant's conduct was wanton or reckless. I will now discuss each element in more detail. The first element is that the defendant caused the death of John O'Keefe. Remember, Ms. Reed caused John O'Keefe's death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove the defendant intended to cause the death. You may consider any credible evidence that the defendant was affected by her consumption of alcohol. The third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates a high degree of likelihood that substantial harm will result to another. It is conduct involving a grave risk of harm to another person that a person undertakes with indifference or with disregard of the consequences of such conduct. Whether conduct is wanton or reckless depends either on what the defendant knew or how a reasonable person would have acted knowing what the defendant knew. If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of grave danger. Even if the defendant herself did not realize the grave risk of harm to another, the act would constitute wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that a reasonably careful person would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I have defined them. In deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite knowledge even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now, the offense of manslaughter while operating a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI liquor, and negligence. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with the lesser included offense. The Commonwealth may prove the lesser included charge of motor vehicle homicide, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. You may find the defendant guilty of motor vehicle homicide only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide. So I will define that for you now. In order to prove the defendant guilty of motor vehicle homicide, the Commonwealth must prove the following 5 elements beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has a right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that while operating a motor vehicle, the defendant did so in a negligent manner so that the lives or safety of the public might be endangered. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. Elements 1, 2, 3, and 5 are the same as manslaughter while under the influence of alcohol, as I've previously instructed you just moments ago. The difference between manslaughter while operating under the influence and motor vehicle homicide is the 4th element. To prove the 4th element of motor vehicle homicide, the Commonwealth must prove beyond a reasonable doubt that the defendant drove negligently in a manner that might have endangered the lives or safety of other people. A person acts negligently when she fails to use due care. That is, when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonable person would not do under the circumstances, or by failing to do something that a reasonable person would do. The defendant acted negligently if she drove in a way that a reasonable person would not have, and by doing so created an unnecessary danger to other people, a danger that could have avoided, that she could have avoided by driving more carefully. The defendant's intent does not matter, so do not consider it in determining whether or not the defendant was negligent. There is no requirement that the Commonwealth show that the defendant intended to act negligently or unlawfully. Under our laws, public safety requires each driver to determine and to adhere to an objective standard of reasonable behavior. Therefore, what the defendant may or may not have intended to result from her actions is irrelevant. The issue is whether or not she drove as a reasonable person would have under the circumstances. In determining whether the defendant drove negligently in a manner that might have endangered the lives or safety of other people, you should take into account evidence, if any, about the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well she could see and control her vehicle, the condition of the defendant's vehicle, the kind of road it was, and who else was on the road, the time of day, the weather, and the road conditions, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The next indictment is leaving the scene of an accident resulting in death. In order to prove the defendant guilty of leaving the scene of an accident resulting in death, the Commonwealth must prove 6 things beyond a reasonable doubt.
So many
First,
elements
that the
to these
defendant
charges,
operated a
good
motor
Lord.
vehicle. Second, that she operated on a public way or in a place in which the public has a right of access. Third, that the defendant knowingly collided with John O'Keefe. Fourth, that the collision caused injury to John O'Keefe, resulting in his death. And fifth, that after causing such injury, the defendant failed to stop and provide name, home address, and registration number of the motor vehicle. And sixth, that the defendant failed to do so for the purpose of avoiding prosecution or apprehension. Jurors, I've already instructed you on the first and second elements. The other 4 elements should be given their plain meaning, and the parties agree that I do not need to define them any further. Save a little time for you. Right? As a general rule, you are permitted but not required to infer that a person who intentionally uses a dangerous weapon on another person intends to kill that person or cause him grievous bodily harm, or intends to do an act which, in the circumstances known to him, a reasonable person would know creates a plain and strong likelihood that death would result. An item that is normally used for innocent purposes can become a dangerous weapon if it is used in a dangerous or potentially dangerous fashion. The law considers an item, in this case a motor vehicle, to be used in a dangerous fashion if it is used in a way that it reasonably appears to be capable of causing serious injury or death to another person. In deciding whether an item was used as a dangerous weapon, you may consider the circumstances surrounding the alleged crime, the nature, size, and shape of the item, and the manner in which it was handled or controlled. Now that completes the second part of my instructions. I will now turn to the final instructions. In order for a jury to return a verdict, that is to reach a decision in a criminal case, the law provides that there may only be 12 persons on the deliberating jury, and you will note that there are still 14 of you. To avoid the need for a new trial, if one or more jurors becomes ill or has to be excused for some good reason, we customarily impanel extra jurors at the beginning of a trial, as we did in this case. However, when you begin your deliberations, the law of Massachusetts is that there can only be 12 jurors. Therefore, at the conclusions of my instruction, the clerk will reduce your number to 12 on a random basis. The jurors not selected to serve in the jury will become the alternate jurors. If you are selected as an alternate juror, please do not feel that your efforts in this case have been wasted because, as I've indicated, it is important that we have extra jurors in the case of emergency. If we did not impanel extra jurors and a juror became ill or for some other reason had to be excused, we would have to try the case all over again with a new jury. In the event that a juror has to be excused once the jury starts deliberating, then an alternate juror will be chosen to take that juror's position, and the jury will be required to start their deliberations all over again from the very beginning. Therefore, it is important that the alternates not discuss the case with anyone, including each other, for if an alternate becomes a member of the jury for deliberations, the alternate's views should be his or her own and not influenced by anyone else. Now, different states and jurisdictions use different means to select a foreperson of the jury. In some jurisdictions, the jurors select their own foreperson. In Massachusetts, the judge is responsible for selecting a foreperson. A foreperson of a jury has been described as the first among equals. He or she is responsible for organizing the deliberations, communicating with the court if necessary during deliberations, and presenting the verdict following your deliberations. The foreperson has no greater say or vote in the jury's deliberations. However, in that sense, is exactly equal with all the jurors. I am going to ask juror in seat number 1, juror number 400. Would you be our foreperson, please, sir? Thank you. When you return to the jury room to deliberate, the court officers will deliver to you all of the exhibits in this case, as well as the verdict slips that you will use in returning your verdict. Your foreperson will be given verdict slips setting forth the charges against the defendant. 12 jurors must agree before you have a decision as to any charge.
Picked one of the
That
men.
means that to find the defendant guilty, all 12 must agree. To find the defendant not guilty, all 12 must agree. You should continue deliberating until you have reached a final verdict on each charge. You should not begin deliberating until all 12 jurors are together in the jury room, and should cease deliberating if any one juror is not present in the jury room. It is important that you not communicate with anyone outside the jury room about the deliberations or about anything concerning this case. Further, I instruct you that no juror is better qualified to determine the truth of the facts in dispute or to deliberate on a verdict solely because of education, background, or experience. The parties and I have chosen each of you as fair and impartial jurors, and your voices have equal weight. To reach a unanimous verdict, each juror must agree. Jurors have a duty to consult with one another and to deliberate with a view to reaching an agreement if it can be done without violence to individual judgment. At the same time, each juror must decide the case for himself or herself, but only after impartially considering the evidence with his or her fellow jurors. Don't hesitate to re-examine your views and change your opinion if convinced it is wrong, but no juror should surrender an honest conviction to the opinion of fellow jurors simply for the purpose of returning a verdict. Although how you conduct your deliberations is up to you, I urge you not to begin conducting an immediate straw vote. Rather, I encourage you not to take any votes until you have completed a careful and thorough collective view of all the evidence. At this point, I want to remind you of an important issue that I raised with you at the beginning of this trial. I told you that our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic.
Disability
I also
status?
pointed out that we all have our own built-in expectations and assumptions, even if we are not consciously aware of them, and I talked about some of the ways we can try to deal with them. First, slow down. Do not rush to a decision. Hasty decisions are the most likely to reflect stereotypes or hidden biases. Take time to consider all the evidence. Second, as you start to draw conclusions, consider what evidence, if any, supports the conclusions you are drawing and whether any evidence casts doubt on those conclusions. Double check whether you are actually using unsupported assumptions instead of the evidence. Third, as you think about the people involved in this case, consider them as individuals rather than as a member of a particular group. Fourth, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? Fifth, listen to your fellow jurors. They may have different points of view. If so, they may help you determine whether you are focusing on the facts or making assumptions, perhaps based on stereotypes. Of course, your fellow jurors could be influenced by their own unstated assumptions. So don't be shy or hesitate to speak up. You should participate actively, particularly if you think the other jurors are overlooking or undervaluing evidence you find important. In fact, when you explain your thoughts out loud to other jurors, you are also helping yourself to focus on the evidence instead of assumptions. If you use these strategies, then you will do your part to reach a decision that is as fair as humanly possible. That is your responsibility as jurors. Now,
Jurors, don't be bigots,
during the
please.
course of your deliberations, you might have a question concerning the law in this case. I'm not suggesting that you will, but you might. Perhaps I said something you did not understand. If you have any questions, please feel free to bring them to my attention by writing a note dated and signed by the foreperson and sending it to me by way of the court officer. Because your role as the jury is to determine the facts of the case, I cannot answer any questions you have concerning the facts of the case. I have no role in this case when it comes to deciding what the facts are. Neither is it possible to provide you with a transcript of the testimony, even though we've had a phenomenal court reporter throughout this whole trial. If you send a question to me, I will respond after consulting with the lawyers. Please do not ask a court officer or anyone else to answer any questions concerning anything material to the case. We will not answer a question or take a verdict between 1 and 2. You'll have lunch brought into you and decide whether you want to stop your deliberations during lunch or deliberate. At the end of the day, if you're still deliberating, I'll send in a note asking if you want to continue deliberating or break for the day and return tomorrow morning. Don't tell anyone, including me, how the jury stands numerically or otherwise on the questions before such time as you have reached a unanimous verdict. You are going to notice shortly that the court officers are going to take an oath, and you will hear from that they too, as well as all other persons, are forbidden to communicate in any way or manner with any member of this jury on any subject touching on the merits of this case. Remember that the decision of the jury must be unanimous, and the foreperson should be certain that each member of the jury is in complete agreement with the verdict. After the final vote of the jury, the foreperson should check the appropriate boxes as to each charge, then sign and date the verdict slips and notify the court officer that you have reached a unanimous verdict. You will then be brought back into the courtroom where the foreperson will deliver the verdicts to the court. I'm going to see counsel before we reduce your number to 12.
So that was quite a lot of jury instructions, but nothing in it particularly jumped out as extraordinary other than just they're quite verbose, lots of definitions of things and things like that, down into quite a bit of minutia. And good Lord, so many elements for some of these charges. So let me just recap first. She did give the Bowden instruction after saying yesterday she wasn't going to. She did in fact give it. That was the one that started with the Commonwealth, didn't perform certain tests or take certain actions, and basically tells the jury they can hold that against the Commonwealth in evaluating whether there is proof beyond a reasonable doubt. Did not give the consciousness of guilt instruction that had been asked for by the Commonwealth, that robust argument that she complimented yesterday about, Karen drove the car to her parents' house that Mr. Lally then, used in his closing argument anyway. Did not convince Judge Bev to give them the consciousness of guilt instruction. So nothing there. Here's what the jury is deciding. 3 primary charges: second-degree murder, manslaughter by operating under the influence, and leaving the scene of an accident resulting in death. All 3 of these require proof that she hit him with a car. There are 2 lesser instructions to the motor vehicle homicide, or to the manslaughter by operating under the influence charge. 1, involuntary manslaughter. She did something reckless to cause his death. 2nd, motor vehicle homicide. She did something negligent to cause his death. So there is no option for them to just convict her of DUI. It's not on the table. It came up yesterday, and neither party was specifically requesting that as an option. They are all in on she drove the car or she is not guilty of anything at all. So 3 primary charges, 2 lesser included, just to the manslaughter count. I found it a little bit strange that she picked the foreperson before we picked the alternate. I don't like. So you did. I mean,
you are unmuted.
Are you pulling his name out of the bingo hat?
So, Mr. Clerk, will you choose the alternates, please?
He's going to do it right now in front of us. Also found it interesting she picked a man. Could mean something, could not, but
Could the juror sitting in seat number 3, who is juror 79, step down and take your place as an alternate? And the juror sitting in seat number 2, juror 14.
So 2 and 3. 3 is going to be the new 3 because we lost the first
All
3
right.
this morning.
So, ladies and gentlemen, we need to swear in the court officers. They're going to be in charge of you during your deliberations. I suggest that you listen to the oath that they are taking so that you can be aware of their responsibilities. Now you can swear them, Mr. Clerk.
You swear that you will keep this jury and alternates in some separate but convenient place until they agree, that you not suffer any person to speak to them, nor speak to them yourselves, nor ask them if they are agreed, nor suffer them to disperse until they're discharged of their verdict, except by further order of the court, so help you God. Thank you.
All right, so jurors, I need not remind you that you have an important responsibility, but I believe that you will bring to bear all the wisdom and the judgment and conscience that you possess in reaching your verdict in this case. All that we can expect from you is that you decide the case with integrity and with principle. We all expect you to reach an impartial verdict dictated by your logic, without bias, without prejudice or sympathy, and not prompted by any facts except those that you have heard here in the court during trial. We are looking for impartial judgment dictated by your reasoning and the fullest discharge of your oaths as jurors. You may now retire and deliberate your verdict.
Jurors, this time taking your notebooks. All rise, follow me.
And they have it. I like the random selection of the alternates myself. A lot of courts, they will just choose like the last 2 people that end up being selected, just end up being assigned as the alternates. I don't like that because they suspect that. And so, you know, there's a risk that they don't pay attention along the way because they know they're going to be alternates.
All right, so counsel, I'll give you a few minutes to work with Mr. McDermott on the verdict slip, and then I'll come back out.
Thanks, John.
Working on the verdict slip. I don't know. I guess there's an issue with the verdict slip that didn't get resolved. Well, all I can say is, boy, during those initial instructions, the ones where they're talking about what beyond a reasonable doubt is and the highest degree of certainty, and your role is to decide the truth. Was Mr. Albert there looking shifty. Boy, was he looking shifty. He's licking his lips. He's sucking his teeth. His eyes are darting all over the courtroom. But then when they get to the to convict instructions, when they're talking about the elements of the crimes, seems a lot calmer, a lot more at ease when he's listening to that. Notice some Jen McCabe really eyeballing those jurors, like leaning around to get past the person that's sitting in front of them so she can full senpaku eyes on each juror over there in the box. Well, it's in their hands now, guys. And all we do is wait. Telling them not to do a straw poll initially, not that they can't, but just, discouraging it. I don't care for these sorts of instructions that sort of try to micromanage how the jury does its job. It's in part their job to figure out how to do their job and to decide what they need to look at, how much time they need to spend on it, and so forth. Yes, I recognize that doing your review of the evidence before you do a straw poll is likely to prevent more just knee-jerk reactions, things being overlooked, and so forth. But the straw poll is typically going to give you a heads up to how much discussion do you even need to have, how much difference of opinion is there about what you've witnessed walking into the courtroom, walking into the jury room. So that's, I don't care for it, but it's not really that unusual to have instructions like that. They don't get transcripts. They do get exhibits, but as far as the testimony goes, they are stuck with their memory. And interestingly, they're not allowed to share their notes with each other. Their notes are for their own use. So They can talk collectively about what they remember and refer to their notes, but they are not supposed to make their notes themselves a communal resource there. Well, boy, a lot of you have stuck with this case even through some of the most boring parts here. The instructions, that was long. That was not very riveting. But you hung in there. You hung in there. We still got a lot of comments to go through, lots to talk about here. The crypto tax lawyer, people generally believe what is easiest and alleviates cognitive dissonance. In this case, though, the cognitive dissonance is created by even entertaining J.O. was hit by a car. Doesn't fit the evidence. You have to come up with a lot of bizarre explanations to make sense of how he could have been killed by a car when he doesn't have a bruise on his body, other than the back of his right hand where he's got those 3 ones that look a lot like defensive wounds, look a lot like, you know, the kind of inflammation you get with the boxer's fracture type of situation, that kind of soft tissue damage in the back of your hand when you throw a punch with your bare hand because you don't have them wrapped. You didn't wrap up your hands to get in this altercation. But yeah, I mean, just once again, the disparity between these closing arguments, one that is dealing with the direct evidence of what's happening at the time John is dead, and how do we know that based on his condition, and then the closing argument that is focusing on Karen's texts and what she should have done. You know, this, yeah, I mean, he calls it character assassination, and there's certainly that, but it's more than that. It's just this guilt by judgmental. She didn't call 911, therefore she's guilty. She didn't take off her shoes, therefore she's guilty. This nitpicking of Karen, without any regard to the problems with proving that he was hit by a car. And so, yeah, cognitive dissonance gets you there, but also just ignoring. Don't pay attention to that. Put your common sense aside. Your common sense that tells you a guy that is hit by a car is going to have very different injuries. Put that aside. You have to ignore that to get to entertaining guilt in this case. D-Flesh 60. How could anything like this happen, Trump? Well, it's true that you can never predict what a jury is going to do. You really can't. As much as we might have our own opinions about it, you just don't know. Michelle, Andrea, I couldn't watch yesterday. My first grandchild was born. Congratulations. What an exciting day for you. How did you feel about the defense experts? Seemed like so much reasonable doubt when I watched Peter's recap. The experts nailed it. I mean, I just don't even know why we would look further, quite frankly. The closing from Dr. Rentschler, his final comments to Mr. Lally were, as described here today, the science, the physics don't lie. The rest of it doesn't matter. That's what you have to focus on. And they say he was not hit by a car. We had another forensic pathologist, extremely experienced, very knowledgeable, not nearly as accommodating as the Commonwealth's medical examiner in considering, well, anything is possible. No, not anything was possible to that man. No motor vehicle accident given this evidence, given these injuries, was not possible. And it was persuasive. I thought he was very persuasive. And then both of the experts from the FBI, of course, the jury doesn't know they're from the FBI. They just know they're independent and not hired by either party and not being paid by either party. Both very clear. They entertained all kinds of different possible ways that the damage could have resulted, that the injuries could have resulted, and are left with the conclusion the damage on her car isn't consistent with the pedestrian collision, and the injuries on John are not consistent with the pedestrian collision. So it doesn't really matter which way you look at it. It doesn't fit a car accident. But then we also got to hear about the experiments where Dr. Wolf got to create a cannon. He got to create a cannon to fire a rocks glass at a taillight that they had chilled down to 28 degrees to simulate the conditions at the time, to see how much force it would take to break the taillight to where it looked like the taillight as in the Sallyport garage. Would have taken a 37 mile an hour impact to that taillight to create that damage. So that's certainly, it's not even something the Commonwealth had proposed, that maybe John threw the glass. That was a little bit of an aha moment, I think, for it was for me. I really hadn't considered that. But it could make sense. It could make sense. Although it still doesn't explain where's the rest of the glass then, unless it did get plowed away. You know, you would expect stuff in the road to get plowed away. Unlike all the taillight, you know, that was still materializing weeks later, somehow didn't get plowed away. So that was fun. You know, what a great job. What great life choices Dr. Wolf has made to land in that position, to be able to have a job where you make cannons to shoot rocks glasses at chilled taillights. So they did extremely well, very credible, very qualified, and not particularly impressed with the theory of the accident mechanism that Trooper Paul had suggested. AKA the cat lady, do you think that McAlbert's being there will get Jackson even more fired up, Andrea? I don't know that he needed more firing up, honestly. I really get the impression that he is fired up because he believes in his client's innocence. And I've said before, that doesn't always happen. A lot of cases that you're defending, you're not defending on my client is actually innocent. You're defending on this isn't the charge, this element isn't established. You're coming off the back foot because you're dealing with my client may not be likable. My client may have made some bad choices, you know, along the course of whatever led to the crime. My client maybe didn't know about things that were going on. You don't always have that fire in your belly that you get from the belief that your client did nothing wrong and your client is being railroaded here by a government and by a corrupt law enforcement office. So I don't know that he needed any help from the Alberts to get fired up, but it couldn't, I don't think it hurt. I don't think it hurt. One thing about lawyers, you know, tend to be a little argumentative, tend to like a scrap, tend to be pretty okay with a good scrap. So he's there and you get to say it, not exactly to his face, but knowing he's just sitting there in his chair squirming, I would think that was probably a bit satisfying. Entry required. Jury will do Mercanti of Venice as intermezzo. Yeah, maybe they will. Joanna Petrova. With a reasonable degree of scientific certainty, Andrea is the smartest lawyer on LawTube. Natalie is a close second. Thank you, Andrea. Well, that's very kind. I am a big fan of Natalie myself. I've been on her channel before, loved my time there. Really enjoy her insights. That girl takes no shit. And of course, we have a very similar background, similar perspective, both having worked as public defenders, although, of course, on different sides of the country. But I enjoy Natalie very much. Really appreciate her insights into the case. But thank you so much for that nice compliment. I really appreciate it. Rurally retreated with a super chat. Thank you so much. I'm a little rurally retreated myself. Maybe not relative to everyone, but certainly relative to Boston. Millie Marinade. Could the defense object to BA and JM presence with the OKs as they are not there as neutral observers? How is this permitted? Seems prejudicial to KR. No, they have no grounds to argue for them to be excluded from the courtroom now that the evidence portion of the trial is over. That's the reason why they weren't allowed to be in there during the case, is because of the risk they could tailor their testimony. So they're not allowed to hear what evidence is coming in. They have to be sequestered. But once the evidence is closed, they're members of the public like everybody else. They have a right to be there as much as anybody else does. And the O'Keeffes have a right to, invite them and choose to sit there in the courtroom with really whoever they want. So no, there would not have been any basis to object to them being present. Rurally retreated. Andrea, in closing, can the defense point to Brian Albert in the audience and call out how he came out today but hid in his house while all the activity was going on in his yard, and then sold his house and got rid of his dog? That would have been epic, wouldn't it? It would have. You could. I don't really know why not. Here he is today. I guess, I don't know, maybe, I'm sure, of course, the Commonwealth would object, and they'd probably argue, he has a right to be here. They can't draw an improper inference from the fact that he's there. But it's not the fact that he's there that the inference arises from. It's the disconnect between him being there, but not being there in the morning. Not coming out in the morning, his lack of concern there compared to his grave concern now. I can't expect that Judge Bev would have let him do it, but that would have been quite a dramatic moment, wouldn't it? There he is, right there. Where was he on January 29th at 6:07 in the morning? Where was he then? Oh, his wife was chit-chatting with Jen McCabe on the phone, which they deny. Fighting Usyk, guilty or not, Brian A. has no shame. Nope, I agree, none. Lally, also no shame. Lied to us right there in closing. Lied about the evidence. No shame. John Beatty bought jury intimidation squad in the gallery today. Well, Jen, like I said, I certainly did see her eyeballing those jurors with her little Simpaku eyes. You do gotta wonder. Free at Last is now a YouTube member. Welcome to the crew. Sunny Days 55. Andrea, is it ethical or appropriate that witnesses such as Colin, Jennifer, and Brian are there? The jury is certainly going to notice that they're there. The jury is certainly going to notice who they're sitting with. Not supposed to draw inferences from it, but you kind of got to assume that they will. So they're going to go in there knowing, here they are. Here's who chose to show up. It's definitely an interesting little selection of who chose to show up. Jen, Brian Albert, and Colin Albert. It's just interesting. These are ringleaders. Is that why they're there? And they're certainly going to notice there they are sitting with the O'Keeffes. That alignment is still in place. And frankly, my suspicion, perhaps even more than intimidation, is that that's what they're there for. They're there to show we're with them. We're with them. A vote against us is a vote against the O'Keeffes. They're trying to get a sympathy card, I think, as much as anything. So the jury's going to notice, but is it unethical? Not really. I mean, they're just members of the public at this point. They don't have really ethical responsibilities in the sense that like the professionals do. Appropriate? The jury's going to make that call. The jury's going to make that call. Chuck with a super chat. Thank you so much, Chuck. David Ferris, what happens next if deemed a mistrial? If there was a mistrial, then they would come back and do it again, or at least have the option to come back and do it again, have a whole nother trial. That's why everyone is very deeply concerned about, let's, not let the jury do their job, Jury, you've been instructed so many times, don't go out and investigate, don't do things that are improper. Please don't do that, because that would potentially put us in the position of having to start all over and do it again. And absolutely nobody wants that. John Daly with the super chat. Interesting name there, sir. I recognize that name. How is your game these days? Damaris San Giuliano, can AJ start his closing by playing Bang Bang? That would be funny too, wouldn't it? I wouldn't be surprised if they're bumping that outside the courthouse. I saw the last couple days that the crowd has really been growing of the people back there in the free speech zone, however many feet that is away from the courthouse. The crowd is really going. Maybe they're bumping some Bang Bang. I don't know. Ghost Horse. Jen McCabe is staring at KR, which is creepy and not a good look for JM. I haven't seen many good looks from JM. It's just alarming how very, very intensely focused and cold she is in her expressions. Just a very reptilian type of vibe. Hate to always go back to the well, but yeah, reminds me of Amber Heard. Not a lot of emotion there. Just calculation. That's what I see. Personally, think it would have been better for her to stay away. Like, why remind the jury? Why remind them of how you were? But she's it's because in part, I think, and I noticed this from Mr. Lally's closing too. I think their view is that these are the people that are on trial besides Karen. The whole just setup here is that a vote for Karen is a vote against them. A vote against Karen is a vote for them. So it's really a choose your sides kind of lineup, because they're the ones that are really at issue. Jen McCabe with the Google search and the butt dialing, the running around, trying to handle the cover up. She was at the center of all of those communications. She was in that meeting in Sergeant Link's driveway, all of that stuff. Brian Albert, obviously it's his house. He's the cop that wasn't going to catch any heat. But I did find it interesting, Lally focusing so much on Colin in his closing, and defense didn't mention him at all. They're done even thinking about Colin. He doesn't matter. He's not central to their theory. He was always just kind of an explanation for why they would fight so hard on the cover up, what their motivation would be. If the kids are involved, then that gives you a stronger motivation than maybe if it's just your family friend, Mr. Higgins, or something like that. So I think that could be why those particular three were there in the courtroom, because they see themselves as it's her or it's us. And it's just kind of funny that Mr. Jackson kind of blew that up. He doesn't even remind that Mad Men meme. I don't think about you at all. He's done with Colin. Doesn't matter. Nothing about the knuckles. Nothing about Bang Bang. Doesn't even matter. Cargo pilot guy Bev is currently removing a pro KR juror. Yeah, we got through that. We heard it was juror number 3. Who, yes, I understand, was one of the very attentive ones, one of the very expressive ones. I hope we hear from at least some of the jurors after the fact. I very much would like to get their perspectives. I understand when they don't. I certainly get it. You've gone through this whole process. You're ready to get your life back. You don't need to keep living it over and over and over again. But we would be interested, I'm sure, in knowing just in knowing what they're thinking, what their perspectives are, and stuff like that. Sassy Gal Beauty says Twitter is saying a juror is getting it dismissed for nodding along during defense expert. Don't know why. Don't know what the basis of the challenge is. Maybe we'll be hearing more as the day goes on. But clearly Bev didn't want the courtroom to know, didn't want the public to know. So it's going to be hard to verify until we hear something from one of the horses' mouths. Michelle Lemoyne, jury tampering is in line with the corruption presented. Could the jury issues be related? Do they have oversight other than self-report by jurors? Not really. Not really. It's pretty much an honor system. Now, the difficulty is that if a juror is going to go into the deliberation room and try to cause problems, you got 11 other people there that you gotta kind of trust that they're going to be on board and not rat you out, and that's a pretty tough call. I mean, if there's a divide on the jury, if there's a difference in opinion, you got some people pushing for acquittal, some people pushing for conviction, then, battle lines tend to be drawn. The sides become pretty clear who's on whose side. So it just becomes a lot harder for something like that to really be able to get a foothold. It's hard to corrupt a jury without, getting to all of them, really. So I'm not super worried about that. I wasn't worried about it with Depp v. Heard either, even though, there was concerns about Elon, Elon and money. He's got a lot of money. He's got crypto money you could pass around. Nobody would ever know. There's no record of it, that type of thing. But it's just the feasibility of being able to pull something like that off. It just doesn't happen very often. Of course, I'm not going to say it never happens. It has happened. It's happened. One of the cases I remember might be in Boston. I can't remember now. There's been mafia cases, where there's been attempts to corrupt a jury, but the problem is they find out because the other jurors rat them out. So self-report is big, but the report of the other jurors is an important part of that check as well. Michael Lawless, argument's sake, if she's found guilty, what are the major appeal issues? Well, excluding the third-party culprit would, the direct third-party culprit would certainly be something that they would raise. I'm not sure they ever quite got all the way there with like direct evidence of involvement. It's just that I don't know that they needed to. I don't know that they needed to. When you have medical examiners saying it looks like he got beat up, then you get to start asking, so who beat him up then? And here are the possibilities. Here are the people that were acting shady, had motive, doing things that suggest a guilty conscience. To me, that's going to be an issue on appeal that they're going to raise. I didn't like the Aruba stuff. This is the 404B. The lawyers refer to it as the prior bad acts evidence. This is just so remote. This is such remote evidence of the status of their relationship because it was so long before. And we never heard anything at all that was then going to connect it with what was going on that night. Is the link supposed to be she thought he was kissing another girl in Aruba and then she's calling him a pervert on the voice messages? I mean, is that supposed to be the link? I don't know. I don't see it. I don't see it, and it didn't get argued. I think it's just especially ironic given that we have so much better evidence of Brian Higgins's intent. His reason to have antipathy towards John and or Karen on the night in question and the actual interactions between them. Love how Alan Jackson gave him the timestamp, by the way. That was that video that I think over the weekend, somebody pulled that out and highlighted. Yeah, there did appear to be some kind of interaction between Brian Higgins and John O'Keefe towards the end of the night at the waterfall, and it didn't look particularly friendly. It looked a little on the aggressive side. Call out? Fight me? I don't know. I don't know that we'll ever know. But they just had so much better evidence of that intent, and yet they're not able to argue third-party culprit compared to this extremely remote month before, fighting for a variety of reasons. Okay, it's not just maybe kiss somebody in the elevator, but ditched her to be the babysitter for the kids on New Year's while he's out at the bar getting drunk, out at the bar and at the pool getting drunk. So I don't particularly like that ruling. I think that's one that you potentially bring up. Other potential rulings in the pretrial, the decision not to disqualify the Norfolk County District Attorney's Office. That ruling never made a lot of sense to me. Her own rationale, it seems to be conflicting to me. Like, yes, he went over the edge with his comments. The district attorney did, violated the ethical rules. So that creates an incentive in them to then try to back up what he said to protect him, whether it's true or not. That to me is a problem. So those are just some of the main issues that I see. As an appeal attorney, I'm going to be looking through this record, and those are ones that jump out at me that I would be looking at very closely. Millie Martinez. Andrea, the defense didn't address Karen's voicemails unless I missed it. Do you think that was a mistake? There's a lot that they didn't address. They can't cover everything. They have to pick their priorities. And I think their decision is generally one that I agree with, that focus on the lack of proof of the car interaction with the pedestrian. Focus on the lack of proof of that, because if they don't get that, the rest doesn't matter. It doesn't matter. I would have liked to have seen them focus on, as soon as Lally comes out with that Carrie Roberts testimony about seeing the bear grass underneath him. I'm like, I wish they had pulled out the photo where we can all see for ourselves with our own eyes. There was no bear grass under John. There was compacted snow that his blood dripped on top of. There's just so many things you can't possibly expect to cover all of them. You just can't. So I don't think that it was a huge mistake. It's just the nature of having limited time and having to pick your priorities, have to focus on what's the most important thing. Same thing with I Hit Him. They didn't address that at all. And the problems with that, the evolution of the stories, how it got kind of planted with Katie McLaughlin first. And so that kind of handed Mr. Lally that opening. We all knew that's where he was going to go, because that's all he has. That's what he's got to bang on. I hit him. They didn't point out the problem with the accident reconstruction. Here's the Commonwealth still trying to have it both ways, right? She still went to Fairview the morning before she went to Jen McCabe's. But your own accident reconstruction depends on a very careful mileage calculation that does not leave wiggle room for her to be taking detours over to 34 Fairview. You can't have it both ways. I would have liked that pointed out. But, you can't get to everything. Pure jealousy. Canton PD is as shady as Moscow PD. Up next. Moscow PD, yeah, I'm not quite sure yet what to make of them. That hearing where we got the testimony from Payne and from the I can't even remember his name now off the top of my head, the guy that did the MPD's cell site location analysis. Boy, it just became a kind of game of throw the hot potato and throw up our hands. And, I did what I did and just whatever. Nobody really wanting to step up and take credit for this great investigation that they did. So certainly some common ground there. But I think really the big difference that I see in Moscow PD, and I'm sure there will be people that disagree with me, but this is just my perception. I truly think that the Moscow PD situation, it's a tunnel vision situation. It's not this corruption that, we have alleged here in Canton. The conflict and the, Chief Burke is the guy to go to bury a body or whatever. You need to hide a body. Go to Kenny. Ugh. I don't get the impression that it's that situation. My impression of Moscow PD is just they were under a massive amount of pressure to solve this extremely gruesome, extremely terrifying crime. Probably wanted to solve it before the semester break so that people don't freak out and decide not to come back to school for spring semester. So they had timeline pressure. And as soon as they got somewhere with that trace DNA on the knife sheath, they just went all in on it. They just went all in on the trace DNA, and to the extent of trying to cram the evidence into, a round hole to try to make it fit. And now it just seems like it hasn't. They had their fingers crossed, hoping that once they got him, they'd be able to develop more evidence against him through the follow-up investigation, and it just doesn't sound like it panned out. So I do think that's a difference. That is just my perspective, though, and I realize people are going to disagree. The Chungi Show Live. Could the jury feel uncomfortable with a finding of not guilty because they feel it implies the McAlberts are guilty, but don't like that theory either? That is one of the risks of doing a third-party culprit defense. It is one of the risks that the jury sees it as an either or. And yeah, it's, I think, a very good interpretation of why Brian Albert and Colin Albert and Jen McCabe came to sit there in the courtroom, was to emphasize that, to try to make it even more the case that you're voting for her or you're voting for us. It's a binary choice. It is not a binary choice under the law, of course. They are not on trial, and there is no burden of proof as to them at all. But that is the risk with how it gets presented that way, that interpreting the burden of proof and the Commonwealth's burden to prove it beyond a reasonable doubt, that they look at only the defense case as whether that establishes reasonable doubt or not. And so yeah, in that case, if they don't buy the cover up, they don't buy that the McAlberts were involved, then if that's their view of what reasonable doubt means, they could say, yeah, it hasn't been established. I don't, of course, think that is a right way to look at it. But I'm a lawyer. I'm supposed to look at it in this kind of highly technical way, and jurors are typically gonna take a more common sense approach to things. So that's always the risk with some other dude did it type of defense. That's so Jessica. Karen's first meal after being found not guilty, Yannetti spaghetti. Wonder how that tastes. It's not going to be chicken parm Charlie, is it? Kyle Cowden. I did some napkin math a ways back. KE, the kinetic energy, equals 100 miles per hour plus. Is that to break the tail light? Or is that to throw him 30 feet? I don't know. 215 pounds to throw a guy 30 feet. That would take quite a lot of force. But, it doesn't really matter. That's more than even, the math and stuff that Trooper Paul could give us, the stuff and things and all that. Thrift with Joy. I hope AJ, has security and someone to remove those daggers stared into his back. A true legal artist, in my opinion. It was masterful. There's just no other way to put it. That was a masterful closing argument. That's exactly how you do it. He had that theme that he consistently kept coming back to throughout. Look the other way. And he just tied that up with the ribbon at the end. It is your duty to stare the truth in the eyes and not look the other way. That's what it means. That is your duty to your community, your duty to the legal system. That's what it is, to not look away. And you would have to look away to buy the Commonwealth's case. Extremely well done. Lorraine H., get your pillow and blankie. It's Lally's story time. Yeah, he didn't really captivate us, did he? It was just kind of a repeat. Kind of a repeat of what we got in the opening. Just more of the same. Lynn's with a super sticker. Thank you so much. Very kind of you. Dollyhood, how would you tell the jury this is the FBI without saying FBI? By the way, we'll miss our mornings with you, friend. Well, thank you. I know I'm going to kind of miss it too. Like, I'm already getting a little bit nostalgic, but of course we'll have other things. I'll still be here. Probably won't be here at 5:30 tomorrow, but you never know when we're going to get a verdict. I mean, honestly, so we'll just see. We don't have to get ahead of ourselves. It's not over yet. How do you tell the jury this is the FBI? I don't know that you can. I think they've already gotten as close to that line as they're able to toe with the other proceeding that I wasn't there and the Commonwealth wasn't there and there was sworn testimony and there were independent witnesses not hired by either side. I mean, the jury clearly gets the point that there is something else going on there. They just aren't necessarily going to know who that is. Are we talking about a civil case? Are we talking about another jurisdiction? Are we talking about feds? I think they've given them as much information as they can to try to connect the dots. And from there, it's just really up to the jury to decide, you know, do they even need to guess? Does it matter? Lynn's, Andrea, I have loved watching this trial with you. Don't often chat, but love the laughs that I get when reading the comments in the chat. Chat is awesome. We have a very clever chat here. I really enjoy a lot of these comments that come up and through. If he wasn't hit, you must have quit. Yeah, that's some good stuff right there. That's pretty much what it was all about. If he wasn't hit, you must have quit. Marcelo Frias, I haven't felt this gaslighted since Amber Turd. Oh my God, I hate people. Lol. Loved watching this trial with you, Andrea, and the chat. Best commentary, in my opinion. Yeah, we were very gaslit, and we all shared that experience, and we can all sympathize with each other with that feeling of what that's like. It's, you know, a bit of outrage that how dare they? How dare they look right in our eyes and tell us stuff that we know is not true. We can see with our own eyes, looking at the video, the drink count, it's not 9. It's not 9. It's not even in the ballpark. We saw it with our own eyes. We listened to the testimony about all of the swabbing of the blood stains on John's clothes and what the results of all of those were. Just for Mr. Lally to get up there and try to tell us nobody else's DNA on his clothes. There was so much other DNA on his clothes that some of it they couldn't even do comparisons. They can't even interpret the sample because it's too complicated, too much on there. Yes, your feeling gaslighted is justified. I see you, I validate you in that feeling, and I understand what that is like. Claudine Buzzo, why did the prosecution go last? Don't they usually go first, or is it different in all courtrooms? So I have never seen a situation where the defendant goes first. and the prosecutor goes last. The prosecutor typically does go last because what I'm used to seeing, what I think the kind of majority practice is that the prosecutor goes first, then the defense goes, then the prosecutor gets rebuttal. So if they have, an hour to work with, maybe he spends 45 minutes in the first part and then saves 15 minutes just to come back and respond to whatever the defense had to say. So I was thinking to myself last night, because I heard the comment about Bev made about the defense is going to go first. And I thought, that's weird. I just assume maybe she misspoke, or just maybe they have a weird process here in Massachusetts. It also crossed my mind, maybe Lally just went ahead and reserved his entire hour for rebuttal, so go ahead and let the defense go first. I could see that. So that part to me is unusual, having the defense go first. Having the prosecution go last is pretty standard in my experience. It's because, like you said, they have the burden of proof, so they get the last word. Jedi Jin, so glad I found you through Uncivil Law. This has been the best chat, and I thank you and Jeff for all that you do. # free Karen Reed. Well, I'm glad you found us too. I have enjoyed my time on Kurt's channel. There have been some fascinating Supreme Court arguments over the last. There's gonna be more. There are some every term, so I'm sure I'll get together with Kurt again sometime and check some of that out. Thank you so much for joining us. Really appreciate it. Bad Biscuit, this is an awesome closing statement for defense. Lally just has a hard time helping himself. He really does. He's just so all over the place, convoluted, makes it difficult to follow, while at the same time saying the defense is obfuscating. It's transparent. It's transparent. Duncan, Idaho, how did he get the skull fracture, Lally? Answer the question, Lally. He can't. He can't answer that question. You have to overlook. You have to overlook all of that. He doesn't have just that basic ultimate fact to be able to rely on, that John was killed by a car, by this car. He doesn't have that to rely on, so all he can do is go and spin around what she said, who she said it to, what sort of problems they had in the house, this judgment of the decisions that she made when she's in a panicked state the next morning, insinuating she went to Fairview when, it would blow your analysis if she did. If there is anybody that's obfuscating, it's just so obvious to me that it's Mr. Lally. I sure hope the jury sees it that way too. Carazola X, I hope that when Lally exits the court, a black SUV, he does a ballerina spin and lands 30 feet away, and a raccoon gives him a little nibble. Well, I don't hope that happens, but there certainly would be some karmic justice for something like that, wouldn't there? DG Maffey, Mr. Lally, there is no way a reasonable jury can go along with this malarkey. Sorry, not sorry. It does seem very hard to believe. It seems hard to believe that they could just overlook John wasn't hit by the car. Look at him. Look at him. Never explain the cut over his eye. The defense expert did. The defense pathologist did. Yeah, that happens when you get punched. When you get punched in the eye. Yeah, you might get a cut like that. Anybody who's ever watched MMA, anybody who's ever watched a boxing match, yeah, they've seen eye cuts. Who has seen a cut like that over somebody's eye in any other context? I don't know, maybe somebody in the chat has. I can't think of a time I have. Only time I've ever seen somebody with a cut like that on their eyelid, it's because they got punched. They got punched in the eye. LGT, I've never seen a defense then state closing in Massachusetts. It's state, defense, state. And while I like the time limit, an hour doesn't seem very long. An hour is not really very long, but I don't really hate it. The problem with it being longer is just that you do then tend to ramble, and you lose your focus. I mean, there is something to be said for editing your comments down to just the bare essentials. Saying more is not necessarily saying better. You know, if Lally has another hour, are we any wiser? No. No, of course we're not. But that is an interesting comment that it's state defense. State is the norm in Massachusetts. It's what I would assume. So again, it just makes me go back and wonder, did Lally just go ahead and reserve his entire argument for rebuttal? Maybe he did. Maybe he did. Franz Marks, I started out feeling badly for the O'Keefes. I now realize they are douches, especially Paul. I really don't want to judge them too hard, but I can't say that there aren't red flags here. I mean, if we're going to sit and judge Karen for what she did and didn't do, how am I supposed to overlook that you walked into the hospital and the first thing you did was blame her for dropping him off at the house? For dropping him off at a party. Like, that's a crime. And when I look at John and how he treated Karen, we can all see for ourselves in the text messages who was nice to who was picking fights with who. Lally's trying to put this as, oh, well, she's trying to needle him into a fight he doesn't want to have. She's trying to bring up her feelings about how he treated her, and he's refusing to acknowledge her. He's being rude and dismissive and brushing her off and withdrawing, stonewalling. That's what I see in these text messages. And so, said before, when I see a man at this kind of age that has a problem forming long-lasting relationships with women, yeah, I tend to think there might be some issues with development, early childhood, what's been modeled for you. Not a diagnosis, of course, but it's just a suspicion. A suspicion I'm going to have. Certain parenting styles, yeah, they're linked. They're linked with those kinds of problems in later adulthood. Doesn't mean that that's what happened here, but am I going to be suspicious of that? Yeah, I am. So I still, I feel bad for them. Nobody, they didn't ask for this to happen. Of course, they didn't ask for this to happen. But it is just unfortunate that they have the choice to decide how to deal with this information that's been presented. And it just seems to be to double down on what they want to believe rather than what the rest of us saw unfold. Salem Southpaw, I can make a killing selling Lally-by bedtime recordings for those suffering insomnia. If a bedtime Lally-by doesn't put you to sleep, nothing will. Yeah, you probably could. You might want to jump right on that. Get your trademarks all lined up. I could see it. I could see the Lally-by. Everage, Andrea, I'm going to miss my routine. Watching you do the live and Lawyer You Know is my recap as my morning show. You're a little bit more outspoken, and Lawyer You Know gets me down to earth. Love and thank you both. Well, thank you for being here, for putting me in such great company. I've said before, if there's one lawyer on LawTube I would not want to run into a courtroom, it's Peter Tragos, because he is very, very reasonable, very calm, very collected, very knowledgeable, very persuasive. I am quite sure, is a very formidable adversary in there. We do, I think, have a little bit of a different approach. I'm not really going to pull my punches. I'm going to call shots the way I see them. Peter is going to take a more reserved approach, and there's nothing wrong with that. It's very appropriate to do that too. So I appreciate that little comparison there. I consider that quite flattering. Jay Richardson, Lally is Binger's protege, malicious prosecution. I mean, I don't know what's going on behind the scenes here to motivate it. I don't. I cannot think that this is a prosecution that's based on a good faith evaluation of the evidence, because their own evidence is just so incredibly poor. Their own medical examiner couldn't get in on the case. How on earth do you think you're going to get a unanimous jury? I just, but I've said before, the process is the punishment. And that's unfortunately something I've seen, going forward with a very weak case against a person you don't like, because you can get your pound of flesh. At the end of the day, she's had to spend all this money. She's fortunate she didn't have to spend a bunch of time in jail. A lot of people who can't bail out would have to spend a bunch of time in jail, lose your job, maybe lose your kids. I mean, a lot of downstream consequences from that decision. The process can be the punishment. Aaron Guano Loco Mishler. Why does he keep saying she left him at the waterfall instead of Fairview? That was what was reported by Jen McCabe as Karen's comment to her when she called her in the morning. That Karen had called her and said, John hasn't come home. We got in a fight. I left him at the waterfall. And it was Jen who reminded her, no, we saw you outside Fairview, outside the Alberts house. So that's why he's saying that. He's just repeating Jen McCabe's testimony. Marcelo Frias, had Karen left the relationship before, she wouldn't have to face this bull. I know she regrets that more than anything. I am so disgusted by Lally. Yeah, it's going to be hard to look back over just the chain of events that led to where she is today, and think about that. Think about the decision points she had along the way where it could have gone differently. That's not a happy road to go down, because you can't change anything. It is what it is. The decisions that you made are the decisions that you made. That's karma. That's what karma is. You make a choice, and it has downstream consequences. And the world that unfolds is a product of not just your own decisions that were made before, but the accumulation of all the decisions that have ever been made, so many of them outside of your control. So I definitely don't encourage that perspective, to look back and think about what might have been. But at the same time, I recognize, of course, it's a very human impulse to wonder how it could have been different. And I just hope that she gives herself some grace for that, because of course she could never have known that things were going to go this way. She could never have known that. Steve Bodie, do you think the jury will deliberate longer than a day, or think they're going to see through the smoke and mirrors? Love your channel. Well, let's see. It's 2:30 over there on the East Coast right now. It's been about an hour that the jury has been out. They have had their lunch. They're getting their lunch, so we don't know. Don't know if they've been talking during that time, or if they've gone ahead and just, taken a little break to munch on their sandwiches or whatever it is that they're getting. I would tend to think they've probably got right into it. I would tend to think after all this time, you're ready. You're ready to get down to business, do your part, and get it done. So really the question of how long is it going to take? If they finish today, that means they got another 2, maybe 3 hours if they let them stay late. I don't know when exactly they would decide the jurors are done for the day and, need to be booted out and come back tomorrow. So that really, it's not a lot of time. It's not a lot of time unless everybody has gone back into the jury room and they are all of one mind, which you can't rule out, but you can't count on. You just can't count on it. And there's also the jury is often going to want to appear like they have really taken their time, really been thorough, really gone through everything, even if honestly they didn't necessarily need to do that. They could be afraid, like if we come back too fast, it's gonna, maybe we'll get in trouble. Maybe it's just gonna look bad. I mean, there's just a lot of reasons why they might be able to take a little bit longer than we would otherwise hope. And it's a question too of just how fast do they want to get back to their normal lives. You want to get back to work tomorrow, well then push to get it done today. But if you've already kind of expected that you're going to be out, then maybe you cruise to the 4th of July holiday, And it's just all those factors can play a role. I saw Duty Ron come in. Thank you, Andrea Burkhart, for your expert analysis. I'm watching you with Ed Wallace. Well, thank you both. Great to see you here. Really enjoyed your live last night. I was talking about it with my chatters at the beginning of our show. Encourage everyone to go check that out. We really appreciate your perspective. I told everybody how much I've learned from Ed. Like, yes, I've learned about forensics and things like that because I've had cases come up that involve things. But that means that when I haven't had a case that involves something, I don't know much about it. And so I've never had a snow search. That's never come up in one of my cases. I don't know what the standard protocol would be for that. So getting to hear that from you guys, from Ed, if this was his crime scene, what he would do with that, is very, very valuable. So definitely encourage everybody to go check out that live from last night. Duncan, Idaho, it's really vexing that people like this disingenuous lump have such immense power over others. I'm digging that guy's suit in the back left, though. The guy in the back left, if I remember correctly, had a dark navy suit with a little bit of like almost a lavender kind of shirt underneath. I couldn't get a great view of it. I'm getting a little bit more critical of the fit now. I started, I follow the menswear guy on Twitter. Starting to see these patterns, the difference between people wearing stuff that kind of looks like it's fancy, but something seems a little off. And then once you kind of learn what to spot, oh, it's because the shoulders are too narrow. Oh, it's because it's too tight. Oh, it's because the jacket is too short. And so that moves the lapel point. And so that makes the waist look like it's up, at his sternum. It messes up the whole shape. So I'm getting a better sense for the fit, and that makes it hard for me to judge a suit from a seated position. Other than just, I did notice that material. It was a very nice blue. But yes, disingenuous lumps possess a lot of power in our system. How many people that are in civil service, that are in administrative appointments, people that are not elected, not accountable to the public, but have a massive amount of control over people's day-to-day lives. There's just a ton of them. And we would like to think everybody goes into work hoping, planning to diligently do their job and serve the public and so forth. But we've all been to the DMV, okay? There's a reason why Patty and Selma are the stereotypes that they are, because we've all had that experience. And so Mr. Lally, he's just another bureaucrat like that, He doesn't have to care about his job. He doesn't get paid anymore for caring about getting it right or not getting it right. Franz Marks, Lally's talking reminds me of the buzzing outside a beehive. I rather enjoy beehives myself. I like bees. We plant for pollinators and stuff in my garden. In fact, my crocosmia is just starting to come out, and I'm very, very excited about my crocosmia because this has been a new discovery of a plant for me. It's this beautiful plant that has a flower spike with all of these red flowers. It's a nectar plant, so insects love it, hummingbirds love it. Very new addition to my garden. And then lo and behold, just a few months ago, earlier this spring, I'm down in Chile, and it's like a ditch plant there. It's indigenous down there. It grows everywhere. It's just like all over the sides of the roads and stuff like that. Crocosmia everywhere. That's of a detour there. But just emphasizing, I like my bees here. Bees, I have positive associations with bees. I don't have positive associations with Mr. Lally. Maybe outside like a paper wasp nest, I could go with that. I don't like those at all. Really don't like those. Anton Ivanov, reviewing this SPA is more exciting than Lally. He's just not an inspiring speaker, and some of that just seems to be his own insistence on using words like ineluctable to substitute for having an argument. And some of it is the lack of raw material that he has to work with. He doesn't have the facts on his side, and he doesn't have the skill of a speaker to, charm you into not paying attention to that, into focusing on what he wants you to focus on. Sandra, everyone with Jackson's statements wishing he had more time, everyone with Lally's statements wishing it was over. That is telling. Didn't we just get a great demonstration of how different time can feel depending on your perception of the experience? When you enjoy it, that time just flies. And when you're suffering, it just drags. Every minute is an hour. Entry required. We didn't hear kids' testimony. What don't we know? We didn't get to hear it. It wasn't televised or broadcast on any of the live streams. So we were stuck reading reports from the people who were in the courtroom, basically telling us what that testimony consisted of. It did seem like it was pretty much a recap of Aruba. Neither of the kids was able to, place her in having access to the Ring camera video. And then the daughter, the niece, had described her relationship with Karen had started off very close, but then she just described that things that I guess she took issue with Karen's parenting style, that she would get mad and like withhold things or something if she was unhappy with them. Maybe didn't feel like she treated both of the kids equally. And then, of course, this description that we've heard about just the kids' perceptions of the relationship. To me, this is it's just so beyond the pale to put a child on the stand to testify about something like that. To testify about your perception of parental relationships. Kids are supposed to be allowed to be kids. You're not supposed to parentify them and put them in these adult roles before they have the maturity to be able to process that for themselves, to decide for themselves what their feelings are about it. So to me, that was just one of the most offensive things that came out of this case. With this week-old case, this lack of medical evidence, this shit show of a chain of custody, this complete lack of willingness to maintain basic integrity of these very fundamental parts of the investigation, your physical evidence. And you're going to make up for that by putting children on the stand to testify about grown-up things. It's abusive. I'll say it. It's abusive to those kids. They should be deeply ashamed of having made that decision. Rigid tactical. AJ makes an hour feel like 20 minutes. Lally makes 20 minutes feel like an hour. Just like we just said, it's crazy how that perception can differ depending on how much you're enjoying the time as it's going by. I enjoyed Mr. Jackson's closing tremendously. He just did such a fantastic job. I was attentive the entire time. I wanted to know what he was going to say next. What else is he going to focus on? Where is he going to take us? How is he going to tie this back in with his theme of looking the other way? They want you to look the other way. Mr. Lally, we're just waiting for him to be done because there's no order, there's no coherence, there's no chain of thought. It's just a kind of rambling, throwing out of pieces of information, sort of like we saw at the trial, a lot like we saw in the opening, that just doesn't address the elephants in the room that this case presents. The medical evidence and the engineering evidence. Big old elephants in the room. Never address those butt dials. Spends time defending the Google search. But never addresses those butt dials. Aaron Guano Loco Mishler. Now we know why Brian Albert and Chloe attacked John O'Keefe. He didn't take his shoes off when he came inside. BA, damn it, there's rules in this house. Well, I mean, clearly that's a consciousness of guilt. You know, not removing your shoes would be consciousness of guilt. So as soon as he didn't take off his shoes, they knew there was going to be trouble. John was there with bad intentions. Duncan, Idaho, Lally, and at least one medical examiner said that him being hit by the taillight of the vehicle was not technically impossible as far as she knew. Need I say more, ladies and gentlemen? Guilty. Didn't she say that was beyond? No, that wasn't what she said. She said the force to fracture his skull was beyond her expertise. Yeah, she was willing to say anything was possible. I'm sure if they had asked about the Sallyport video and the people apparating in and out in the fog, would that be possible? She would probably consider that would be possible too. Yeah, she was willing to consider pretty much anything. And so, I mean, it definitely creates a problem when it comes to reasonable doubt if she's just as willing to consider that he was beat up by human fists in an altercation as she is that he died as a result of injuries that are not typical from a motor vehicle pedestrian collision. Then you just you don't have a lot to hang your hat on there. Franz Marks, Lally's the 70s call. They want their leisure suit back. I didn't notice the suit being particularly bad, but I definitely did not care for the tie. It was this like lavender paisley tie. Didn't care for it. Just my personal taste. He was wearing blue. The blue is not awful. In general, a man in a navy suit is gonna work. Didn't really notice any big problem with his fit. But of course, we only got the partial view. Marcelo Frias, did Amber turd in Lally's clothing? It's all turd. It wasn't good. Definitely was not good. Just no idea where he's going or what the point was, other than, yeah, Karen is so bad. Karen is so bad. Never address the elements, never address the proof of those elements, because that would require him to deal with the elephant of the room, proving that she hit him with her car. Vicious 1975, the shoes, consciousness of guilt. Isn't that just ridiculous? It's just ridiculous. She's panicked. For heaven's sakes. She's panicked. She's driving around. She's calling people. She's freaking out on the phone. She's trying to find him, and you want her to stop and take off her shoes, and she's guilty because she didn't. Ridiculous. Zena Sram with the super chat. Thank you so much. Appreciate that. Track worker. 6 inches is now 1.5 feet. Have to use that on the ladies. Well, don't scare them. Don't scare them. Yeah, there's been some man math in this trial, hasn't there? The snow is the worst of it. The blizzard. We saw the library video at 12:30. We saw what the conditions are. There is like no snow on the grass, none. No snow sticking to the road, none. We can see the video from the dash cam the following morning, and okay, the snow is falling, sure, but you know what you notice? It's all pretty much falling in the same direction. None of these 37-mile-an-hour gusts that Mr. Lally is trying to tell us without evidence, a fact not in evidence, that could interfere with throwing the glass, which isn't their theory anyway. I just can't with this case, with this Commonwealth, with this prosecutor. Desert Cat, I'll be enraged if they convict her of DUI cop-out. They will not have that option. DUI is a standalone charge, is not an option for them. Mr. Lally specifically declined to request it. Bev asked, do you want it? They're not requesting it. Defense didn't request it. So it's not on the table. All of the charges require proof that Karen hit John with the car. Stephanie H., are you allowed to lie in closing? You're never allowed to lie as a lawyer. You're never allowed to lie. But they didn't object, so there's no recourse. They didn't object. I mean, what can you do? You can complain to the bar, and Lally will be like, "Oh, I misremembered. It was an accident." You know, there's no recourse for that. You have to object at the time. Get an instruction. The instruction is never really more than jurors, you are to rely on your collective memory of the facts in this case. And I remind you that what the attorneys say in their closing is not evidence, and you shouldn't take it as fact. Something along those lines. They'll never tell them. They'll never tell the jury, "Hey, jury, that's wrong. That's not what the evidence was." So it's just a cheap shot. It's a way to take a cheap shot in clothing. No, of course they're not allowed to do it. You're never supposed to do it. And yet, when people think they won't be caught or there won't be consequences, yeah, some people who lack integrity will do that anyway. D. Higher Ed 1, Dr. Higher Ed 1, Canons versus backup videos, LOL. Yeah, good comparison, huh? Good comparison. These people went and backed up the car in the parking lot. Was that enlightening? Watching that video? Did that help us? I don't know. I didn't find it particularly helpful, but boy, when Dr. Wolf smiled, yeah, I really needed that. Really needed that for that case. He was just so happy to talk about that canon. What a lucky guy. What good life choices that man has made. Rodney Smith, I had a meeting, so I missed 99% of Lally's word salad. This is the one time when a meeting is going to be preferable to watching TV. I've never been so excited for a meeting. I won't go back to watch. Thank you for your coverage, Andrea. Well, you're welcome. I think you lucked out, but duty calls. We had our responsibility to be here and witness it to the bitter end. So we went ahead and endured it so that you would not have to. Be rational and nice when in this global sandbox. Remedy for Lally lying 5 times in closing. No remedy with no objection. You can try to complain to the bar, but nothing's going to happen. Nope, he's going to say, "Oopsie, I just got something wrong. I just had the facts off. I just didn't quite remember that right." Yes, he flat out lied about the DNA on the clothes. Flat out lied. We watched that testimony here. You can go back and check. I could get my notes and tell you exactly which day it's on. Should I do that? I'm going to do it. I'm going to do it. Here's where my notes are at, by the way. That's where we got with the Commonwealth's case here. So we're somewhere in the ballpark of day 19 or day 20, I believe. Ashley Valier is who put the taillight back together. Christina Henley was the glass comparison. Yeah, the bumper sprinkles. Gotta go back now and find. Ashley Valier put the taillight back together. It was after, then we went through some cops and then we came back. Came back to lab people. Was it test chart? I think it was test chart. No, test chart was the DNA from the hair, the mitochondrial DNA. It was Andre Porto, forensic scientist 2 on day 24. Here's where I got it. All the stains from his jeans. Stain A on the upper right leg of jeans, mixture of 3 in the sample. Sample from stain B was 2 unknown, so a mixture of a few males. Stain C was at least 2. Stain D was John and 2 unknowns. Stain E, a mixture of 2. Sample from an unstained area of the jeans had a mixture of 4. Sample from the shirts, the orange shirt. One of the samples was a single male contributor. Stain C on the long sleeve shirt was the single contributor. Everything else is a mix. Stain L, mixture of 2. Unstained area of the gray shirt, mixture of 2. The right instep of the sneaker was a mixture of at least 5. So such a complex mix that they could not do any comparisons with that particular evidence. That's on day 24. Go back and watch it for yourselves if you want to double check what Mr. Lally told you in closing. No remedy for that beyond hoping that the jury took the kind of notes that I did. S. Zena Sram, pathetic, seating Jen McCabe, Brian, and Colin Albert with the O'Keefes to send a signal to the jury that the family supports their position. Sure is what it looks like, isn't it? Going for that sympathy vote and going for the, if you vote for Karen, you're voting against us. And if you're voting against us, you're voting against the O'Keefes. Lori J. Old Man Winter, that weather. Well, it's murder weather. It's murder weather now, we heard. The weather was also a murder weapon. Could we be any more over dramatic? I mean, come on. Silly. Stephanie L., thank you for your amazing commentary, Andrea, through this whack job of stuff. You are a gem. Well, thank you so much. Thank you for being here. Thank you all for your support, your contributions to the chat. It's been a great time for me. I'm going to miss it too. So, done my best to kind of cut through the fog of the stuff that we've all had to endure here. But, again, it's not just my perspective. It's all of us together watching this together. That's what matters. We're not going to be gaslit. We're not going to be intimidated. You are validated in your perspective. We have seen it together. Mike, missing from Lally's timeline, the time of the car hitting John. He couldn't even fit the evidence after 8 weeks of trial. Shake my head. Yeah, much more in there about the texts than about, by the way, when did this actually happen? Couldn't explain that connecting to the Wi-Fi at 12:36, could ya? Because it messes up your timeline. Why does it mess up your timeline? Because Jen McCabe is there texting John at 12:31. Pull up behind me. Karen's already gone. She's already gone. M4A now. This whole trial has been a prosecution of the state by the defense. AJ was perfect for this case as a former prosecutor. It really was a just unusual role reversal. And we saw that throughout the whole presentation, how much more energy and focus was put on addressing the hoax, addressing the cover-up, than finding John O'Keefe's killer. Finding out why he died, how he died, when he died, the circumstances all around it. And it's really shameful. Seeing more of that same trend play out now with, gonna punish Turtle Boy for talking about it. Gonna put more effort into making sure we lean on Turtle Boy than we are finding John O'Keefe's killer. Feynman, Massachusetts, I tell you what, that is giving me some pretty severe heartburn about the law enforcement that I am paying for, that I depend on. This is our public safety, and that's how they are choosing to prioritize what they do. Not finding John O'Keefe's killer. No, because that might implicate a Boston cop. El Stinko farce. Alan Jackson, passionate and well-spoken, believes in his case. Elaine Lally, monotone and deceitful, desperate to be believed. Yeah, Alan Jackson didn't have any problem looking those jurors square in the face, did he? Like he's eager to. He's eager to share what he feels and what he believes, and it rings in his words. There's no artifice. No, I'm saying something that I don't really believe here, but I'm gonna go ahead and hope I can sell you on it anyway. Didn't get that vibe from Mr. Lally. Got the vibe from Mr. Lally that he's almost afraid to talk, and it just shows the things that he is willing to talk about, the things that he does know, are the things that don't matter. He wouldn't talk to the jury about, did she hit him with a car? Because how can he look them in the eyes? How can he look them in the eyes and tell them he sincerely believes, with all this evidence proves that Karen hit John with her car? He can't do that. I think that's part of the reason why he can't go down that road. He knows the jury will see through you. Jury can sniff out your bullshit from a mile away. It's one of the challenges of being an attorney, is learning you cannot bullshit the jury. And so however big of a challenge it is in your closing argument, you better be telling them something you sincerely believe, because they will know. They will know if you don't. And sometimes that means all you have that you can connect with in the case, because the evidence is so bad and you didn't think it should go to trial anyway, but here you are and it's been even worse than you expected. Sometimes all you have is, ladies and gentlemen of the jury, the presumption of innocence is one of the most important principles we have in our system of government, in our criminal justice system. You are the gatekeepers of that. Please hold the state to their burden of proof and sit your butt down. Sometimes that's all you can give authentically. That was not Mr. Jackson's problem. Definitely not Mr. Jackson's problem. He connected with everything that he had to say. Sussex Jackie, watching from the Netherlands. The world is watching. # free Karen Reed. Welcome from the Netherlands. Beautiful country. Beautiful country. I have spent some time there, a little bit of time there when I was a teenager. We lived in Belgium, so we would go up into The Hague, been to Amsterdam several times. Beautiful, beautiful place. Crooked Cat, Crooked House. Lally was president of the Friendship Club in high school. He listed those names of witnesses because those names mean a lot to him, the guy who really wanted to join the crowd. It would make sense if you're a politically motivated or politically ambitious person that, yes, you focus more perhaps on people than on principles, because it's people that get you where you need to be. Principles can get in the way. If the people that have the power to put you somewhere that you need to be, if they don't have the principles, then your principles are going to come up into conflict with theirs. It's not how anyone wants the world to work, but it is just an unfortunate reality of the system that we have. So I see that. I see the names. I think this is a very good point. The names are what matters to him. Look who all is on my side. Look who all is on my side. It doesn't matter if they all got caught lying. behaving terribly, presenting falsified evidence to the jury. It doesn't matter. Look who all is on my side. I'm popular. I matter. Duncan Ideo. Them trapezius muscles, though, looking very fit. A lawyer who regularly exercises boxes, has chickens and dogs. You're living life pretty well. My traps are kind of small right now. Honestly, I haven't been doing I need to do more, especially after the last 2 months of sitting here, sitting so much watching this trial. I need to do more. Need to do more back work. But thank you. It's a big part of my life. Important to me. I watched my grandmother still to this day is she just turned 93, 94, 95. She just turned 95 years old. The woman still lives independently. She's, completely with us mentally and cognitively and stuff like that. I absolutely put it down to activity. She and my grandfather have always been very active people their entire lives. She continues to do that, walks the dog many miles every day. It does. It's an important part of just being well, being generally well, kind of keeping your system operating the way that it needs to be. But I am very fortunate, guys. I'm living the dream. I'm so blessed. Do my best to recognize that every day. Thank all of you for sharing that with me. Laura Smith, do the closing arguments change your mind about how long it will take the jury to return their verdict? Not really. I don't know that closings really change anybody's mind. They just kind of help you validate where you're already at. If you're already inclined towards innocence, you didn't need that push from Mr. Jackson, and nothing that Mr. Lally gave you is going to be persuasive. If you're already leaning towards guilt, then I don't know that anything in the closing was really going to change you either, because you probably have already seized on the things that Mr. Lally is pointing out to you, and that's why you're leaning in that direction. Well, she said she hit him. She said she hit him and her taillight was broken. And you don't want to look at the other stuff. So Mr. Jackson pointing out all the other stuff, we already saw it in trial. If that didn't captivate you at the time, I just don't see that it's really going to catch you in closing. And same thing with kind of the point that was already made. If you're seeing this as a binary, it was Karen or it was the Alberts, and that's how you see it, and you're not convinced that it was the Alberts, then you might be leaning towards Karen. And I'm not sure that the closing would change your mind about that either. So I think all it really does is just solidify where people are standing as they go into the jury room. But it doesn't change how long it's going to take for them to be able to reach a consensus and feel like they have done their duty to be thorough, to come up with a decision that they believe is well supported, and that all of them can go home and look themselves in the eye, in the mirror, and feel that they did the right thing. That is a very important part of being a juror. You have to live with the decision that you made. So no, I still tend to think I'm taking the over on the 3 hours that Mr. Brown set for us in the chat yesterday. I am taking the over on that just because I do think that they're likely to that would be fast. It would just be fast given the scope of everything, all the time that has gone on in this trial, all of the evidence that's come in. I mean, yeah, here we are. I'm going back looking through my notes because I can't even remember the names of people, who did what. I don't even remember. And so I can see the jury wanting to at least take the time to kind of review that and be sure that they're not missing something important, because they do have to live with the decision. But what? It's 3:00 over there in the courtroom. They've been out an hour and a half. So they might get to that 3 hours today, 4:30, and then we'll know they either have a verdict or they don't. So we'll know whether we get our over or under at that point. Charles Argo, there is proof that Karen couldn't have deleted the Ring videos, but Proctor had John's phone with the Ring camera app. Yes, he did. Yes, he did. And there's evidence that video went missing. There's evidence that video went missing because we heard about Trooper DeChico having the handwritten notes from reviewing that Ring camera video and having the note about the video at 0041, 12:41 in the morning. Looks like she's arriving home. And that Ring camera was nowhere to be found. Karen has no way to access it after that point. Never proved she had any access. Couldn't link it to the computer. That's what they were trying so hard to do, is link it to that desktop computer at John's house. But no access ever to the Ring camera that they were ever able to show from that device. So yeah, just not possible. She didn't have his phone. She couldn't have done it, but Proctor did. James Cassatelli, why the anti-jury nullification instruction? So nearly all courts will do this, some kind of instruction that it's your duty to follow the law, whether you agree with it or not. People have different perspectives on that. It's a very complicated question because I don't think you can deny that, certainly historically speaking and even structurally, the jury has the power to nullify. You don't get to ask them about the basis for their verdict. You don't get to impeach their verdict on the basis of how they got there. So if they decide they're going to acquit or they're going to convict because they don't agree with the law, it's hard to have any checks on that. Like that historically has happened. We know that it has, and it is a power that they have, but it doesn't mean that it is a legal power for them to exercise. Jury nullification should be of grave concern, even if there are aspects of the law that you don't care about, simply because it is tyrannical in and of itself. It's just reversing kind of the normal hierarchy. We expect the tyrant sits up here at the top, and the people from whom the jury is drawn are down here at the bottom. And that's the guy with all the power to make the decisions. Well, the jury nullification is the people at the bottom deciding they're going to exercise their fiat. They're going to disregard the collective wisdom, the collective enactment, the social contract that we have about what the rules are and who's going to follow them. So it's problematic from just an overall rule of law standpoint. So that's in general why those instructions are given. Because even if people may think the jury has the power to do that, it does not mean it is legal to do that, and it doesn't mean it's right to do that. I recognize this is a controversial topic that people have many opinions about. The only thing I would just say is I just encourage people to think about the reason why we are supposed to have rules and principles that apply generally to everybody is because you need to think just as much about how they would apply to you and your friends as how they would apply to you and your enemies. And that's how you reach a consensus about what the rules should be, because everybody should be treated equally. And so if you want to throw that out, you need to consider the possibility that that can be used against you just as much as it could be used against the people that you don't like and that you want to see suffer consequences regardless of the law. Duncan, Idaho, Yannetti looks like Quintus from the movie Gladiator. I don't remember which one Quintus is. I'm going to have to go back and watch that. I don't know that I can think off the top of my head, but he does have a very Roman look to him, doesn't he? You could see him. You could see him on a bus, like right there next to Marcus Aurelius and Seneca. You could see him walking out of the Senate. I definitely can see it. Joe Mendoza, my tongue twister on this case. Okay. Let me get ready. Let me take a drink. Lally the lawyer loved to lollygag, lollygagging legally, but when he gagged on his lally dawdling defense became a legal debacle. Say it 5 times fast. Oh boy. I'll try it one more time. Lally, the lawyer, loved to lollygag, lollygagging legally, but when he gagged on his lolly dawdling defense became a legal debacle. I think I did okay, but 5 times is going to be tough. That is going to be tough. That's a pretty good tongue twister. A lot of back and forth between the D and the L is a little bit of a challenge. Angelo O'Dath, let's have a poll, guilty, not guilty. We have the poll up for the over-under. So I didn't want to disturb that and put up a new poll. I did see that Law and Crime has a poll up. I think Court TV has a poll up also. Those are probably broader audiences from a different, different range of perspectives than probably you have here on my channel at this point in time, since I have made it clear what I think about this case. And so it's natural that people who are seeing it the way I am seeing it are more likely to be here. People who don't see it that way are, more likely to be over there watching it on Law and Crime and Court TV. So I didn't do a poll, but please feel free to do it in the chat. I see the poll is now 61% over the 3 hours and 39% under the 3 hours. So yeah, still pretty close. But we are falling on the side of probably not today. Probably going to be tomorrow. Rosemarie Attardo, is the judge saying that if the Commonwealth drunk while driving, then it can reasonably be concluded that she could have killed John O'Keefe? We know they were all drunk, all driving. I'm confused. I think this is going back to the part of the instructions where she's going through the elements of the charges and she's explaining that evidence of Karen's intoxication or whatever, it can be used to evaluate her mental state. It's not that it proves she did or didn't hit him with the car, but it does go to, look, if you're really drunk, how clearly are you thinking? If you're really drunk, maybe you're acting impulsively, you're not doing something intentional. If you're acting really drunk, maybe you're more likely to accidentally step on the pedal of your car and as compared to if you're sober. So that's really what it's getting at, is just your ability to form a clear mental state that's required for these different levels of these crimes. That can be affected by alcohol consumption. So it's what we in my state would generally call diminished capacity. Same thing can come up with mental health. We usually use the term diminished capacity when we're talking about mental health issues and how that can affect your ability to form a required mental state for the crime. But the same thing with alcohol. I mean, you can be blackout, you can be hallucinating, you can be drunk out of your mind so that you can't perceive. And given that, can you really be intending to engage with objective reality in any kind of meaningful way? So that's what that instruction was getting at, is just that intoxication is a factor to consider as to the mental state element. James Brown, you can't count lunch as part of the 3 hours. If we don't count lunch as part of the 3 hours, then unless the jury goes until 5:30 Eastern time, our 3 hours won't run out until an hour in tomorrow. So we'll have some wiggle room. We'll see. We'll see where we get to the end of today. Katie Cat with the super chat. Thank you so much. Really appreciate that. Entry required: no BAC between 12 a.m. and 12:36 a.m. when Karen Reed was at John O'Keefe's house. Yeah, so even their retrograde extrapolation went back to 12:45, right? That was the time they used of the time of her last drink. Nobody did the math on setting up an earlier time frame. How much would that affect it? We don't know. We don't know because they didn't do it. The whole issue with doing the extrapolation over that long of a period of time is it increases the range, it increases the uncertainty about what it would be that much earlier, Nobody did the math. So I think this is an excellent point. If her blood alcohol level were really a key issue in this case, I think they would hammer on that. But it's really not. It ultimately, it doesn't really matter, because if she didn't hit him with the car, she's not charged with just driving drunk. Steve F. RuPaul would have been more credible than Joe Paul. I might have believed RuPaul. RuPaul has a way of presenting things that is pretty charismatic. Andrew Hansen. Guy at my college in Massachusetts was charged with assault with a dangerous weapon for beating a guy with hard plastic $200 sneakers he thought the victim stole. Yeah, this dangerous weapon instruction that's basically telling the jury anything that's used as a weapon can be a dangerous weapon. I mean, yes, anything can be a dangerous weapon under that broad of a definition. Any tool at all becomes a dangerous weapon. Is the weather a dangerous weapon now? Is Mr. Lally trying to get there in his closing? I don't know. I think the worst one I remember seeing is a situation where somebody tried to use their key ring, like their chunk of keys, as like a brass knuckle. It didn't work very well because it's not, you don't get a good grip on it, and they basically just hurt their own hand. But yeah, got charged with the key thing being a dangerous weapon. We have enhancements here in Washington, where you basically get extra mandatory time on your sentence if the jury finds a dangerous weapon or a firearm or something like that used in the commission of the crime. So a lot of incentive to just charge any weapon, any tool at all becomes a dangerous weapon. So it's one of those things where if anything is a dangerous weapon, really nothing is a dangerous weapon anymore. It kind of loses its meaningfulness. I found it interesting here that it wasn't because there's any impact on the charge or on the punishment if they make this dangerous weapon finding. It's because they can assume intent from that. They can infer that if she used the car in a way that was a dangerous weapon, that therefore she intended to kill him, inflict serious bodily harm on him. Some of that seems kind of intuitive. Like you don't need to get to a dangerous weapon to get that inference. Yeah, if you drive your car at somebody at 20 some miles an hour on purpose, you can infer that you intend to severely hurt or injure that person. If you don't hit the brakes, right? You hit the brakes, maybe you're just trying to scare them, but you didn't hit the brakes. Pretty common sense. Not sure that we needed a whole special instruction for that. Katie Cat, I meant to say I really hope to hear from the jurors after the verdict. Yay, my first super chat. Well, I guess this is technically my second. I really hope to hear from the jurors after the verdict as well. I will certainly understand if we don't, if they're ready to be done and just move on with their lives. I would find that even with my own trials, you wrap up, the judge will invite the jurors to stick around. It's not obligatory, just if they want to, they can stick around and chat with us, because we always want to hear from them. What did you think of how we did? What should we have done differently? What stuck out with, in your mind? What drove your decision making? All that kind of stuff. Most people, from my experience, would not stick around for that conversation. They were ready to be done. There would be, usually a couple, one or two, maybe three, maybe four. But most people are ready to be done at that point. But I really would like to hear from them as well. Mama Carter, what if the foreperson is an alternate juror? Wasn't that strange, that order that we just went ahead and decided juror one was going to be the foreperson before we had selected the alternates? Did they just pull juror one out of the bingo? I wonder what would have happened if they had pulled out juror one. I guess maybe they would go down the line. But yeah, that was a little bit strange, because it almost seems like, is this just a free pass for somebody getting a guarantee to be seated on the jury at the judge's selection? Was weird, wasn't crazy about it. Kyle Cowden, hundreds of death incidents. Is he dead is common. I would think is he dead is common. It's the main thing you want to know. It's the main thing you want to know. Is he dead is the bottom line. And so, yeah, you're probably going to be pretty laser focused on your main concern in this situation, which is going to be, is he dead? Not what kind of rehab might he need? Is he going to recover? Does he seem like he's feeling? These are all secondary to the primary issue. Is he alive or is he dead? Is he dead? Jeffrey B., feel like this will be over quick, so we'll take this opportunity to say thank you and Jeff for doing this. You added an entirely different and much better way to observe this trial. Well, I'm glad you enjoyed it. I really enjoy the group watch, the watch party kind of approach. So we can all see it on see what's happening in real time, and I can see your questions as they happen, and yeah, we can just all react to it together. I enjoy it a lot more. When I first started watching this trial, there's a reason why I started on day 8. I did not plan to be doing this. I was just kind of, watching it on my own, seeing how things unfolded. But decided, go ahead, let's give it a shot. We're watching anyway. A lot of this, exciting stuff that I knew was going to be coming, these key witnesses and things like that. I knew we were going to want to watch that together. But it's just kind of a little addictive. It's just too much fun. Too much fun being able to watch it this way. So just thank you again to everybody who's joined me throughout this. It's been a great time. I've really appreciated it as well. Lee Q. Andrea, can you explain why there are individual jury instructions for a trial and not the same instructions for each trial depending on the charges? Thank you for your great coverage. So, a lot of the instructions that we heard today are general instructions that they give in just about every trial. The way that Massachusetts has their jury instructions set up, they have forms, and so then they have parts of the forms that are scripts. Parts of the scripts can be modified depending on what the specific issues are in the case or what the specific evidence is in the case. So that's where we heard the debate about things like, are we going to give the Bowden instruction? Are we going to give the consciousness of guilt instruction? Those things aren't going to apply in every single trial. So it just depends on the facts of the particular case, whether those instructions are given or not. But the other ones, like the definition of reasonable doubt, the burden, the deliberation process, all of that, those are common to all trials. And so those instructions are part of the standard script that's given. The charges, of course, are then going to vary depending on the nature of the case as well. So it's a little bit of a mix of both. But a big chunk of what we heard, they're going to hear that in every trial. Man, how long that takes. How long it takes to sit through that. It really does. Marcia, all charges are that she hit J.O. period. No proof. 100%. They cannot convict of any of the charges without finding she hit John with the car. And I just don't see how they get there. John Daly with a super chat. Thank you, sir. Appreciate that. Enjoy your game today. Patrick Henry, I recently served as the foreperson on a jury for a criminal trial. The next hour in that room will be wild. I would love to serve on the jury. I really would. Never have. Probably won't be able to now, but I can't even get summoned at this point. I haven't been summoned in probably close to 20 years, which is unfortunate. I really would. I would like to. But I imagine it would, just that whole initial feeling out of where everybody is and why. And I have to imagine if there are people on opposite sides of the issue, there's going to be some just like disbelief. Like, how could you think that? Some just sort of shock at the difference of perspectives. I could see that. I could see it being pretty wild. I love hearing people's jury stories, by the way. Always feel free to share me your jury stories. I love to hear about that experience. Still Raven, I think Hunter Biden hit him with his laptop. Well, it's probably about as much evidence for that as anything else we've heard so far. Z, what is scariest client you had? Is BAJM close? No. No, they're not even in the ballpark. There's a published opinion out there if you want to go and look it up. It's from the state of Washington, State versus Michael West. In fact, the opinion opens with the report from the forensic psychologist who examined him and opined that Mr. West was the most dangerous person he had ever encountered. It's a very gruesome case. I don't recommend reading it if you have a delicate stomach. Very unpleasant details in it, but it was a case that turned on an insanity defense. Pretty good basis for it in my book, but he did not win his insanity defense. It turned on a legal issue of basically the way Washington statute is written. A defendant gets 2 bites at the apple with insanity. Even if they have a jury trial, they get to both ask the judge to acquit on the basis of insanity, and then if the judge declines to do that, then the jury gets the ultimate decision on it. So they had not asked for that judicial determination. I argued it was ineffective assistance. I believe there was quite a bit of evidence in the record from which a judge should have concluded that the man was insane. But as a practical matter, they were never going to do that. They were never going to take this man out of the prison setting and put him in a hospital. Just would have been an issue. So even though I think legally speaking, yeah, he probably should have been. There's always pragmatism involved in a lot of decisions about how justice gets done. So anyway, that guy's hands down the scariest guy I ever represented, and he is head and shoulders beyond these people. Angela Becker, thank you for your coverage on the case. Will you be covering the Kohberger hearing on Thursday? I am planning on it. Fingers crossed we have a verdict before then, because boy, I don't want to have a conflict. But yes, Thursday, 10 a.m. Pacific time, there is going to be the hearing on scheduling future motions in the case. So while it's not going to be super exciting content-wise, it is going to give a preview of what sort of challenges is the defense anticipating raising at this point in time. And that'll give us some insight into what they've uncovered, what their strategy is, and what their thought process is. So I will be here live covering that. Please do join me. And we'll talk about what it all means after. Jay Reno, love your passion and details. Hoping for this type of coverage on future strange cases. I know your mod, aka Jeff, has to be smart and good looking, but I still have my $100 on he married up. Well, in a good marriage, you're both supposed to believe you got the better end of the deal, right? So that's the story I'm going to stick with. I definitely plan to keep doing coverage of cases. There is a lot out there, a lot out there. I do find it's been sort of a remarkable coincidence that the cases that I've looked at lately, Karen Reed, Kohberger, they happen to just involve these circumstances where there's such questionable police conduct and serious questions about the guilt of the defendant. That isn't always the case, right? That isn't always the case. I didn't stream the Darrell Brooks trial, but I watched quite a bit of it. Whole different situation there watching that trial, just in terms of what the issues are and what there is to talk about. Having represented people that share quite a few of the personality characteristics of Darrell Brooks, I had some thoughts about it. I definitely had some thoughts about that and about how the judge was choosing to interact with him. Just had maybe a little bit of a sense that the judge has not represented people like that before. But these are just different opinions that people have depending on their experiences and stuff going into that. I do enjoy watching trials, and I think it's important to have the public eye on the process to just not just know what the courts are doing, but to help us understand better why. This shouldn't be something that is specialized knowledge that lawyers have. It's something that I think is important for everybody to understand. So yes, I will be continuing to cover future cases. And as far as strange cases go, I'm going to be going to Delphi. Gonna be going to Delphi to watch that one. We're not going to get the cameras in the courtroom for that one so far. Judge Gohl has been very hostile to the public I don't know, ability to see what's going on and monitor what's going on, all the way down to like sealing a lot of stuff improperly. They had to take that up to the Supreme Court to get some of that taken care of. So just a real mess as far as transparency goes. It's going to be very important to have good information coming from the ground. So I'm going to have that as my goal in Delphi this fall. So you can keep an eye out for that. That is a strange case. Coffee Cake, can you explain hung jury and what happens next? Could another prosecutor try it? So a hung jury is when they have reached a deadlock, they have done their best to deliberate, and have been unable to reach a unanimous decision one way or the other. They will typically let the court know they haven't been able to reach a decision and they're not making any further progress. The judge can do a few different things. She can accept it, say, okay, that's it, declare a mistrial. She can determine that, well, they haven't exhausted the possibility of being able to reach a verdict. Maybe they'll be able to reconcile. Maybe they need to spend a little bit more time on it. She can send them back to continued deliberations. And if they, continue to be unable to reach a verdict at some point, they're hopelessly deadlocked, then what happens is a mistrial is declared. And so, yes, it can be retried at that point. It could be another prosecutor if they thought that was in their interest. It's usually not going to be, though, just because he's the one that's already put in all the time. He's familiar with it. A new person coming on board is going to have an awful lot to learn and prepare. So you're redoing a lot of things that have already been done. So I wouldn't expect that. I would expect if it's going to be retried, it would be Mr. Lally retrying it. And quite frankly, like I said yesterday, under the circumstances of this case, I kind of think a hung jury, the Commonwealth would consider that a win. Kind of think they'd consider that a win. They get their pound of flesh. They get to continue on this campaign to punish her with the legal process. Maureen Francis, listening to you and re-watching last night's triple play. Go Phils. Wasn't that awesome? Wasn't that awesome? Oh, and my boy, Orion Kirkering. I can't wait till I'm waiting for them to make a women's jersey that you can have Kirkering on it. You can get the men's so far, but not the women's. I have been a Kirkering fan from like day one since he, before he was getting called up. Because, Andrew Painter was going to be our top pitching prospect, but he messed up his elbow. He's having Tommy John surgery. So number 2, Orion Kirkering, and his stuff is filthy. It's just filthy. That curveball, that slider he has is just mean and sick. Love that kid. He's gonna be a Hall of Fame pitcher. Watch it happen. He's gonna be fantastic. So got a close from him. He's it's like his first big close. They've been using him in the later innings, but not putting him in that kind of high pressure position of being the closer. I was pretty happy with that. But yeah, the triple play was phenomenal. Don't get to see that very often. Go Phils. Zencat, Andrea and Jeff, I came to this channel through this trial. It's been a blast. You have a lovely community here. Well, welcome. We're so glad you found us. We plan to continue having a good time here. So come back anytime. We'll be here. Steve Trammell, evil alternate movie ending. Karen was in on it and they all got away with murder. The usual suspects kind of twist. Yeah. Yeah, they all conspired to set up Proctor. Proctor pissed somebody off, and it was all a ploy. Melinderp, why can't the expert reports be given to the jury? The expert reports are hearsay. Pretty much all of the reports that are prepared in a case, they are hearsay. They are the out-of-court, unsworn, written statements of people. And so it's their testimony that trumps the report. Because that's where you have the opportunity to observe their demeanor and their ability to recall and their explanations and so forth for, what happened in the report. So they're allowed to rely on the report to refresh their memory if they need to, like, who did I talk to? What test did I do? What temperature did I get the taillight to? No, he didn't need his report. He remembered. He was on it. That Dr. Wolf with his fancy cannon. They can rely on it to refresh their memory so that then they can testify and the jury can observe all of those things. But the reports are hearsay, so they are not admissible for that reason. Chininator, yeesh, I leave the room with the law racks running and return 10 minutes later to Andrea. Just kidding. Love you, Andrea. I've got $10 on not guilty verdict being reached before 6 hours of deliberation. So let's see, where's that going to get us? That'll get us to about, about 11 a.m. Eastern time tomorrow, or 11:30 Eastern time tomorrow. Depends on when they come back in. If they come back in, that would be coming back in at 8. If they come back in at 9, then it'll be about lunchtime tomorrow. So not a bad bet. Not a bad bet. I could see that for sure. Steve A, I don't think that Sallyport video was edited to reverse it. Just a dumb setup that was hidden from the jury to make their version sound plausible. I don't know. I share the concern about the timestamp not being reversed. It just doesn't make a lot of sense to me. It doesn't make a lot of sense to me. I don't buy this explanation that, well, some security cameras are just mirrored. Why? Why would that be? Why would you set up your security camera to show you opposite world? It's very counterintuitive to me. And so I buy Mr. Jackson's explanation. That's what it looks like to me. Like somebody went in and reversed it, and they would have had to also reverse the timestamp. You saw when they went and flipped it back, they didn't do that. So then the timestamp is backwards. That's what I would expect if it was just like some glitch, an accidental setting or something like that reversed it. I don't know, though. I'm not an expert. If I were being asked to say beyond a reasonable doubt, did they do it on purpose? Maybe not just from that. But I still got to come back to the whole circumstances of it. And if you didn't mean to do it, then why were you so deceptive about it? Why did you not just be upfront and direct about what it was and what we're looking at when we're looking at it, and not coming back days later, the following day on cross to concede, oh yeah, by the way, I know you were staring at that taillight there because it looks like the passenger side. I was staring at that taillight. Would have been good to know. Yeah, that's not the right taillight. Very important thing to bring up. And that, to me, has a lot of weight in deciding, was this deliberate or not? Don't know if I'm at proof beyond a reasonable doubt. Could be an accident, but I'm definitely at clear and convincing. If we're in the civil fraud standard for clear and convincing, I'm there for sure. Catherine Clark, what happens if not guilty on 3 charges but hung on included? So if she is acquitted on greater charges, double jeopardy attaches. They cannot retry her on the greater charges. They could only retry her on the lessers that the jury did not convict on. And so then that can change the dynamic about whether they decide to go forward with it at all. They may just conclude it's not worth it at this point. if all they can get is a involuntary manslaughter or a motor vehicle homicide, a negligent homicide, I mean, maybe they would, but it can change the dynamic. In this particular case, a lot of times it'll change the dynamic if the person has already spent a lot of time in custody. If they weren't able to bail out, the pretrial process, as you've seen, it can take years. I mean, people can be sitting in jail for years waiting to be brought to trial, especially during COVID. COVID, messed a lot of that stuff up. And so it can be a situation where even if you're convicted, you've already served more time than you would get for that sentence. So there have been situations, where, they're just not going to bother. You're not going to get anything out of the trouble of going to that retrial. So that's how that would work. No retrial on anything she gets acquitted on, but they can potentially retry her on lessers. Shane Liberty, if it's all not guilty, does the federal government come in and indict the true killers? Massachusetts governor. So the feds don't have jurisdiction to prosecute a local murder like this. They don't. There's no federal crime that would fit these, these facts for the killing itself. Federal murder is very specific. It is things like it involves a federal law enforcement officer. It involves a bank robbery. It's just I can't remember all of the different ways off of my head, but they are very, very specific. And it involves witness intimidation or something like that. Like it's a killing as part of a witness intimidation. It's a killing as part of organized crime. Like just kind of the things that you might expect. It involves crossing state lines. That is not one of the bases. Not that there's evidence of that here, but I have seen, some suggestion, like with Brian Koberger, for example, there's a crossing state line. So there's a federal jurisdictional hook. No, crossing state lines is not a basis for feds to get involved in a straightforward murder charge without one of these other types of situations applying. So they don't have jurisdiction to prosecute the killing of John O'Keefe, barring some other information, that we don't know anything about. This wasn't a bank robbery. It doesn't appear to be organized crime, that kind of thing. But, are they going to potentially drop indictments for whatever else it is they've been investigating? I don't know. We got to wait and see. We know they've been to the grand jury. We know they were investigating as recently as February of this year when they got the report from these accident reconstructionists. Stands to reason you go back to the grand jury with that once you have that evidence. So potentially they already have some indictments. Indictments are typically sealed until they're ready to conclude and unseal them all, and then the process begins. So we just really don't know where the federal process is at this point. The Massachusetts governor, I'm not sure that they would have jurisdiction to intervene either. Don't know exactly how the governmental structure for local governments is set up. Is set up in Massachusetts. But it's usually delegated. The authority to do local prosecutions at the county level, it's delegated to those local prosecutors. So then typically there are statutory bases that would justify state level prosecutors or something like that going in and taking over. I don't know enough about their system to say whether, that's feasible or likely or not. Part of me would think that, well, if that's possible, surely they would have already done it, seeing how bad this case is, seeing how the feds are already involved and stuff. But I just can't say for sure. I don't know enough about kind of how their jurisdictional boundaries work between the different levels of government. Michelle G., first question jury should figure out is, was he hit by a car? If they think no, everything else is irrelevant. If I'm the foreperson, that's where I'm going. That's where I'm going. You just start with the simplest proposition, the simplest solution, and work from there. If somebody believes she was hit by the car, okay, then we go through the, did she do it on purpose? Did she do it by accident? Like, narrow it down what you're telling me you think you're considering as far as a charge, and then go ahead and look at all the evidence for that. Of course, we're not supposed to straw poll. We're supposed to look at it all before we do that. But I mean, I agree. That's really the bottom line. If we all agree she didn't hit him with the car, then we don't need to spend any more time on everything else. Damaris San Giuliano, I have been watching your videos since JDVAH, so this daily stream has been such a treat. Every day I tell my children I have to get ready for trial. Thank you, and Jeff from this wannabe lawyer in Great Britain. Well, thank you so much. It's been a treat for me too, having all of you join me, this great environment that we have here. I feel the same way, like, for all that, yes, I'm getting up early and I'm complaining a little bit about it. I am looking forward to it too. It's good to have a reason to get up in the morning and something to look forward to. You got your day all planned out. We're going to be watching this trial, and this trial has been quite interesting and quite captivating. Mark, what, if any, objections are you most interested in reading the sidebar arguments about? Boy. I'd probably have to go through my notes to remind me, because I have the recency bias now. The only ones I really remember are the ones that like just happened. I'd probably have to go back through my notes and see. I think just in general, I would like to get a sense of so many of these objections turned out to be foundational. Like again, this is maybe just recency bias, because we saw it most recently with the experts. Wasn't allowing him to ask the question about, were his injuries, if he was hit at this speed and sustained these injuries, what kind of force would be, and projected 30 feet, what kind of force would be necessary to cause these injuries? Wouldn't let him ask that question. And it's getting sustained, and then he comes back and he's able to proceed. But the issue had been, he's got to first establish that there would be injuries from that. Like, that's her view of the foundation necessary to get that opinion. It's just very strange. It seems extremely over technical to me. I don't know if that's how she does it. I don't know if that's unique to Massachusetts. I don't know if it's just an idiosyncrasy, because certainly she was not holding the defense to that standard, but of course, or she wasn't holding the Commonwealth to that standard, but the defense wasn't objecting. So just no basis to. I would have assumed, if this is like a Massachusetts practice, that Mr. Yannetti would have been on top of that, But in general, they had a very hands-off approach from the defense side with respect to those objections. So I'm curious about that. Like, what's up? What's up with this weird foundational requirements? What's she telling them at the bench? The ones with Mr. Lally, a few where he was just, flat cut off. I would like to see those, just because, she seems in general to be so accommodating to the Commonwealth, giving them all these compliments for the arguments that they raise and things like that, while at the same time criticizing the defense like they're just performing for the cameras. Haven't forgotten that. But she did at the same time, clearly rule against him, more than once. And so I'd just be interested in kind of seeing the dynamic there. Not even so much like what was her reasoning for the ruling, as much as what is the actual dynamic between them when everybody's at sidebar and the audience can't hear. Blakely Creative, thanks, Andrea. I really appreciate your insights and knowledge. Well, thank you. Thanks for being here. Thanks for your support. I'm just glad that you know, my experience is something that that people find valuable. Z. Chris A. caused a fatal hit and run. Paul O'Keefe caused DUI and called Karen to bail him out, not family, but now pointing fingers at innocent and framed Karen. So much DUI all over this case. All over this case, right? And how curious. The Boston police officer isn't catching any heat for it. He's out there starting to drink from the time he gets back from New York. And Higgins, the ATF guy, can't wait to get home to drink more whiskey. Which, by the way, I'm not buying. I'm just not buying that the Alberts, with their after party, they don't have a bar in their house. They don't have other things to drink besides light beer and White Claw. I don't buy that they didn't have whiskey, especially if Brian Higgins is Brian Albert's close friend. I just don't buy that. But that's just my opinion. So much drinking all over, and the only one that's getting the finger pointed at them is Karen. And these same people doing it themselves, judging her like she's the bad guy. When I look at the drink count, I see 2, maybe 3. When I watch that video, and they're early in the night. It's the drinks at CF McCarthy's, the earlier in the night. So, yeah. A lot of animals, not quite as equal as the other animals in this town of Canton. Thomas, Lally by now with nervous cough. He's had the nervous cough the entire time. So he gets a bad answer. Okay. It's been a big tell. Big tell. Jaragon, it seems the Commonwealth is making the argument that Karen should have known not to drop off John with friends like these, Alberts and McCabe's. I don't know what point they're making. I really don't. I mean, that was that the point that that Peggy O'Keefe was making in the hospital with John? How could you drop them off with these people that are now her good friends that are sitting there in the audience with her? I hope not. I really hope not. That would be alarming. But I can see how people would get that impression. Should have known. Should have known not to do that. I don't think so. I mean, I think in general, the Commonwealth's argument is just the smear of Karen. The smear of Karen. Look at her. Look at how she panicked. Judge her harshly for not doing what we think she should have done. That's what I think their argument is. Dar2, I really enjoy watching your videos. I'm glad. Thank you. I'm glad that people enjoy watching them. It still kind of blows my mind that people like to watch me watch TV and then talk about it. What a time to be alive. What a world. None ya business. After watching the Rittenhouse trial, then Zachariah Anderson trial, and now the Karen Reed trial, I've completely changed my views on the death penalty. I can't trust prosecutors for a fair trial anymore. Well, I hope you will stick with us through Brian Kohberger then. Yeah, he's got death on the table. He's got death on the table. And it's alarming. It's very alarming. So much at stake, so much pressure that gives the prosecutors to be able to put on somebody. Just plead out to something. Doesn't matter if you didn't do it, because you could be put to death by the government if you don't bend the knee. It's a very, very scary place to be. Forever Wander 03. The O'Keefes weren't kind to Karen Reed, yet McLaughlin had the nerve to say consciousness of guilt because Karen Reed didn't want to be with John's family that night. Totally agree. Totally. That was my first reaction. She didn't hang out at the house. Well, probably had a good idea that they didn't want her there after that interaction at the hospital. I wouldn't want to be there. I have my own grief that I am going to be, concerned about. I'm not going to be there to take abuse from people who are lashing out, treating me unfairly. Yeah, I'm not going to be there. It's such a strange argument to me. She would want to be with her own people, the people that support her and care about her. That seems like the most normal thing in the world to me. But somehow that all makes her look guilty because she drove to her parents' house in Dighton and then left the car and the taillight in the driveway for over an hour after she knew Proctor and Buchanan were coming to talk to her. Did absolutely nothing to conceal the car, the taillight. Go put a little tape over it or something. Nothing. She did nothing. Ben Shaw, Haas long to not Gichty. That's the question of the day. Haas long to not Gichty. God, I wish that had been my poll. That's some gold right there. Kyle Murthy, thanks for a month's worth of entertainment. Well, I'd like to say it's my pleasure. It's unfortunate it came at Karen's expense, but I believe in looking on the bright side of things, trying to turn the bad stuff into lemonade. So at the very least, we got some education, we got some entertainment, and so there's always pretty much always something positive to get out of most things in life. Marissa T gifted 20 memberships. Thank you so much, Marissa. What a great gift. Thank you so much to everybody who benefited from those memberships too. Dr. W, after the acquittal, this is a perfect moment for Governor Maura Healey to denounce this police abuse of the justice system and investigate them immediately. Politically, it would skyrocket her. But would it skyrocket her politically with the right people? Would it skyrocket her politically with the right people? The people that have power are not necessarily the same people that have the ballot. A lot of things with politicians, a lot of times they're thinking long term, right? You got to always be thinking about the next election, but you're also thinking about, what about when I lose? What about when I don't run again? What about when a strong challenger comes up? What about when I have a scandal and I need to back away? What's next? They're looking down the road and who's going to be able to put them in that position? What relationships are going to be able to further them the most in the long term? Perhaps I'm a cynic, but I just tend to think that rarely is that the voters. Rarely is that the voters. Law enforcement is extremely powerful, extremely influential in politics. Very difficult to get elected if you don't have the endorsement from your state police, your county, your police union, all of those public safety people, because they can always run against you on the fear campaign. You elect this person, you're going to be less safe. And fear motivates people very, very powerfully. So I would like to think it's going to happen, but yeah, maybe I'm a cynic, but I'm just skeptical that we would see anything like that. Thomas, proper fitting men's suit offers shape and drape 100%. The proper fitting suit creates a beautiful, beautiful structure, beautiful silhouette. It sits right. That looks like a man in that suit. That's what we're going for. That's what we're going for with the good menswear. Brenda Lentz with the super chat. Thank you so much. Thank you for your support. Really appreciate it. Duncan, Idaho. Oh, Andrea, I meant the guy behind the defense table in the Karen Reed section wearing the dark waistcoat and dress shirt. Looked sharp. I'm going to have to rewind and look for him. I didn't notice him. I'll check him out though. There's been a lot of sharp looking people in Karen Reed's side of the witness box, or I keep saying that, but I just mean the gallery. That's so, Jessica. Can you spell that? What am I spelling? Am I spelling conspicuity? Am I spelling ineluctable? INELUCTABLE. That's right. 5th grade spelling bee champ. Ah, hap. Lally have me Dustin Hoffman vibes, aka Sleepers, just there with his tello pads doing what he's told, his yellow pads. Just doing orders, just following orders. Worked for a lot of very famous bureaucrats who found themselves perpetrating pretty evil things to then later find themselves being tried on a world stage with journalists observing, wow, the banality of all of this. Yeah, Lally doesn't give strong leader vibes. Not to me. Not to me. He doesn't seem to have the brain power or the ability to motivate. Lally gives me strong follower vibes. He wants to latch on to somebody's coattails and advance himself that way, not on the basis of his own merit. Perhaps that's an unkind thing to say, but that is simply my perspective from watching him over the course of this trial. If he's hoping to advance on his own merit, he's going to hit a wall. He's probably already overachieved relative to his skill set. So I don't think that's his game. I think his game is the relationships, like the earlier commenter pointed out. Duncan, Idaho. I work in child support. We get parents all the time offering to have their children talk to us or write letters. None of that stuff is ever accepted or considered, at least administratively. Thanks, Andrea. I'm glad to hear that because yes, the children should not be pawns in the parents' conflict. It's just appalling that people would think that that's appropriate, that we should get the children to come in and badmouth one of the parental figures. So damaging. It's so damaging to children. It's a very important part of their development that they have that time to be able to identify with the parent and then figure out for themselves how to create their separate identity. It's just a very important part of figuring out who you are going to be as an adult. And so parents who manipulate that, who try to force children to have a certain perspective on the other parent, try to alienate the children from the other parent. Hi, Alice Evans. How you doing? I'm looking at you. You know I'm looking at you. Looking forward to that financial trial. Keeping an eye out for that one to get set. It's abusive. It's abusive to the children. It's extremely damaging, extremely negative. It shouldn't be tolerated. I would like to see, disincentives for doing that type of thing. That might be a little bit too much to ask, I realize. But no, it's just so inappropriate and shouldn't be tolerated. So I'm glad to hear that doesn't carry any weight in that particular process. James Brown, Lally's tie looked like wallpaper in a funeral home. I could see that. Yeah, I could see that. That sort of lavenderish paisley in a funeral home. I mean, perhaps in just the right, 70s with like a very vivid purple shag, with that wallpaper, I could perhaps see that working in like the campest way possible. Did not care for it in the courtroom today. Leon, what rule or law could be changed to make it more likely that defendants choose to testify? Maybe no cross-examination? Feel like the jury miss out on important testimony. I don't know that no cross-examination is a good solution, simply because it's just so integral to the process, the truth-finding process, seeing how somebody responds to being challenged. What could we do to make it more likely for defendants to testify? You can give them use immunity. I mean, not for this particular charge, you know, you got to be able to convict somebody on the basis of this particular charge. But, you know, the threat of perjury, take that off the table. Maybe. Is that going to help you get more truth? I don't know. I'm going to have to chew that one over. I think there's so many incentives at play in the decision whether to testify or not. Just starting from the standpoint of if this person gets on the stand and tells the truth, is that going to be helpful? I mean, that's kind of the starting point. I think the biggest disincentives are human factors. It's the fear of being judged for things that don't relate to your guilt or innocence of the crime, but just relate to whether the jury is going to not like you. I think that most people have some insecurity about that, about, do people like me? Are people going to accept me? Am I going to embarrass myself? Am I going to look bad? Most people have a little bit of self-consciousness about that. I feel like that might be perhaps more the case with Karen, just because of how we've seen her interactions. She tends to appease, you know, even with the Aruba girls. You know, she's pretty sure about what she saw. She's sure enough to raise a stink about it. But even with that, just back away. Never mind. Let me go ahead and pay for your room to make up for it. The text with John, go, if you haven't still gone to Sleuthy Goosey, find her on Twitter, Sleuthy Goosey, find her spreadsheet. It's been her pinned tweet for a while now. She has got everything compiled, all the exhibits, the documents, the witnesses. I mean, she organizes things to the max. So she's got the exhibits from the trial, including the full text exchanges between Karen and John that day. Those texts were very selectively presented by Mr. Lally. When you go through, you will see who looks like they are reaching out, trying to make peace, and who isn't. It's pretty clear. It's pretty clear. So I think that fear of being judged, or that fear of a negative opinion, you know, it does affect some people more than other people, and that's just a human thing. You know, there isn't really anything institutional that you can do to overcome that. And I understand why people would feel that way. It is a big risk and a big fear that if they don't like me, they're gonna want to convict me, even if the evidence isn't very strong. There's that fear of making that mistake. You know, I was winning, I didn't have to, and then I blew it. That would be a hard decision to have to live with. Diane Hartnett, thank you for your patience and education. I have learned so much. I really appreciate your YouTube. Well, thanks for being here. It's been my pleasure. I'm happy to share what I've learned over the years. Joseph Benway, is it realistic to think none of the jurors see any news like the recent assault on Turtle Boy? Your thoughts? It is hard to imagine, isn't it? Turtle Boy wouldn't necessarily be off limits anyway, would he? Because he's not a party to this case. His whole thing is collateral to this case. The instruction to not go and investigate and get any outside information about this case doesn't obviously extend to Turtle Boy. I can see a scenario where even if a juror is being very diligent, you know, they're watching the news, Karen Reed comes on, they instantly mute it, instantly change the channel, you know, turn it off, whatever. Turtle Boy comes up, you're not going to have that instant trigger. Turtle Boy is just, you may not even know who he is. You might, I don't think Turtle Boy has even come out as a name in the trial, has he? I know they talked about the blogger. I don't think they would. I don't think they knew. So it seems possible that even complying with the court's instructions, they could have potentially come across that and not realized, oh, there's overlap here. We're looking at some of the same cast of characters here. Possible. And only then when they're watching that video of Jill Daniels popping out of that car and assaulting him and wanting to know what's going on. And he's like, well, because they killed John O'Keefe. Well, now you realize, oh, but you've already heard it. How do you unring the bell? So that's even under the best good faith assumption that the jurors really are trying hard to avoid all of this, which I would like to think, but I'm not naive. It's a self-policing system, and there is simply no way to know. And out of 12 people that are going to be deliberating and deciding this case, what are the odds that every single one of those 12 people are people who have integrity, that are concerned about doing the right thing simply because it's the right thing, and are not going to do the right thing only when they're pretty sure they won't get caught doing whatever it is they want to do? Something like 5% of the population is supposed to be psychopathic, right? Not quite 1 in 12, but you got decent odds. You just have to wonder. You really do. You really do. Mari V. Sans, watching from Spain. I watched and admired Jackson's closing, but decided to skip Lally's. I need all my brain cells. Lol, loved your commentary. I am not going to judge you for that decision whatsoever. We all got to look out for ourselves. There's only so much of Mr. Lally I think anybody can take. MLC, motion to consider PO might simply have an RBF. Motion to consider PO might simply have an RBF. I'm not sure that I understand this comment. I wish I did. I know what an RBF is, but I don't know how it relates to the motion to consider PO. Sorry, I don't get that one. Adriana B. Custom Furniture and Home Decor. My daughter is on the spectrum. I homeschool her. I told her to do something and she said, I object. I asked why. She said, because Andrea said she's 11. Oh, sweetie, it's best to do what your mom tells you. You're going to have a whole lot of years as a grown-up to do whatever you want. You're going to have a whole lot of years, and I know you don't see it now. I know you're eager to get free, be a grown-up, make all those decisions for yourself. I remember what it was like to be 11. I really do, like it was yesterday. So I know how you're feeling. I just wish I could tell you what it's like to be my age and look back and remember how good it was to not have to be responsible for all those decisions, to just be able to rely on my mom and dad, to trust them, know that they were going to guide me to the best of their ability. You don't realize it now, but it does end way too soon. Pure jealousy. Moved to Washington 2 years ago. Most beautiful place ever. Living the dream here too. Thanks for the consistent, amazing coverage. It's a great state. It really is. I love it here. I did my law school down in California, down in San Diego. It was certainly beautiful there, but it's just not the same as home. Just not the same as home. Even over here on my channeled scabland side of the state, there's still a beauty to it, to me, to my eyes. Maybe it's just because it's what I'm used to. It's what I grew up with. but there's just an openness and a kind of fierce quality to this landscape. So glad you love it here. It is a wonderful place to be. Sandy, Canton reality, butt dials never go to voicemail. Canton English, ours are spent unless there's a W at the end. Yeah, it's a ka until it's a lore. Finally starting to get the hang of this accent after however many months. Yeah, you don't just butt dial, you butt answer in Canton. It's pretty remarkable. Pretty remarkable. And then there's the weird apparitions on the phone logs where calls just apparate on from nowhere magically. Strange place they got over there. It should be studied. Anna Jasky, love your channel, Andrea, and so appreciate your legal insight, guidance. Very grateful. I'm learning so much about the legal system thanks to you. Thank you so much. It's very validating to hear that. Like I said, this shouldn't be a specialized knowledge. It should be things that is just available to everybody. It shouldn't be so complicated to try to interpret the language that's being used and the process that's being followed and stuff. But here we are. And so I am very happy to be your guide through this process of navigating a criminal case. And thank you for joining us. Cargo pilot guy. Will a judge ever say you haven't deliberated long enough if a jury says they've already reached a verdict? I don't think so. I think that would probably be improper. They'll only say it if the jury says that they're deadlocked. Maybe you need to spend more time on it. But no, I mean, there have been extremely fast verdicts in a matter of minutes. It's happened. There's no law that says it has to take a certain amount of time or you have to go through a certain process or anything like that. That is the power that the jury has. They get to go back in the room and decide the case however they want to decide it. And there's no oversight to that. There's no impeachment for that. The only limitation on that, you can't engage in misconduct. Can't do things that violate the rules that the judge has laid down. Go do outside investigation, argue for jury nullification. Stuff like that can be a problem, can get you in trouble. But otherwise, no, it ain't none your business how they made that decision. It's up to them. Janelle Woodward is a new member. Welcome, Janelle. Welcome to the crew. Sandy, I know I heard murder vehicle, but did I hear murder weather or did I hallucinate during Lally's lullaby? No, that was me being a smartass. He said that the weather was also a weapon here, so I had to pipe up, oh, the murder weather. That was just me. I just found that very entertaining in light of all of the absurdities that we have heard and tolerated in this case, that we get to closing and we get the metaphorical murder weather. Rhonda, Iowa girl. I vote for watching the Donna Adelson trial starting in September. So I have heard of this case for years. The Dan Markle case. I'm trying to remember, like, even when was the first time I thought about, like, long before anybody I think was charged with it. Wasn't it quite some time? They had to flip the one girl who said she was paid off basically to do it. I didn't watch the Charlie Adelson. So I'll take a look at it. I'll see. I'm worried with that one that perhaps there's just so much already under the bridge, so much that's already happened that I don't know if I'll be able to get like caught up enough, to be as informed about it as I would like to be to cover something like that. But I'll definitely keep it on the radar, see what we get. Rita Jackson, I was a juror on a 4-month UK trial. It was life-changing. I would love to hear about that. 4 months is a long time to be on a trial. I can only imagine what that's like. I mean, you got a whole different life for a while. And then what? You're supposed to just stop and go back to your old life the way it was before. Everything's changed around you. There's probably like different people at work. And I mean, in a way, it would be like being taken out of time, for this special thing. And then just kind of being dropped back into the world like nothing ever happened. I can imagine it would be pretty life-changing. Summer is 19. Andrea, the respect, thoroughness, and exacting manner that you provide to each super chat is captivating. I appreciate you so very much, Lizzie. Well, thank you, Lizzie. I appreciate that. I want to respect and show my gratitude for the support that people are showing me. People are paying me money to hear me talk. To share their ideas with me. I absolutely want to show that the respect and the gratitude that it deserves. I just appreciate it so much that it means that much to you, that you would put your hard-earned money out here just to get a response from me. So I want it to be clear that I don't take that for granted. It's very important. So thank you for that. Reza T, consciousness of guilt, redoing basement, selling house, rehoming dog, destroying phones, the audacity. Isn't that the truth? Isn't that the truth? Yeah, destroying phones after you self-extracted them. You chose what you wanted them to look at. And then you went in and deleted those phone calls. Deleted all of those early morning phone calls and those phone calls to John's phone. Deleted all of those and then handed it over. Yeah, that's what consciousness of guilt is. It is. It's been a Darvo case. It's been an exercise in Darvo, in projection, in accusing Karen of the things that they did. And then still turning around and accusing Karen of somehow framing the McAlberts. Like, it's just, you couldn't write the script. You really couldn't. But I guess if you're just determined to be a victim, that's what you're going to do. That's the approach that you're going to take. You just have to, because the alternative is acknowledging, your own complicity, and that's never going to happen. Leandra, I was on the largest federal capital murder trial, started in March, ended in July, and sentencing in September 2006. Intense, to say the least. Wow. Federal capital murder, was that DC? Was that the DC shooter? That's the last one I remember, the last federal capital murder I remember. Just curious about that. I'm sure it was. It's a high pressure. It's a high pressure position to be in, and I do believe most people take it very seriously. I would. Of course I would. You have to live with yourself for the rest of your life with that decision and knowing that there were consequences from that decision. It's such an important job. Franco Cimino. Does the presence involvement of an ATF agent and disposal of evidence at a military base constitute a federal crime? He himself potentially could, be subject to federal criminal prosecution. Mr. Jackson brought that up in his cross-examination, suggesting, the misuse of the government resources from using the FBI equipment to do his personal extraction of his cell phone. Now that would be federal, but it doesn't transform John O'Keefe's murder into a basis for a federal investigation. If Brian Higgins had been the one who had been killed, then potentially the feds would have jurisdiction to prosecute because he's a federal agent. But John O'Keefe is not, so Brian Higgins' involvement in and of itself does not give the feds jurisdiction. AK, if the jury comes back with a guilty verdict on the highest charge, what do you think has been going on in the jury room? Plants? I don't know. It would disturb me. It would certainly disturb me, and I would have questions. As Emily would say, I would have questions. I have questions. I would definitely have questions if that happens. I could see one, maybe two people I'm trying to be reasonable. I'm trying to not be, stuck in my own perspective. I understand lots of different ways to look at a scenario. I could see a couple people maybe having the perspective, well, but if she didn't do it, then the Alberts did, and I don't believe the Alberts did it, so it must be her. I could see something like that, but unanimously on the whole jury, that would just be very, very hard for me to believe. So I don't want to get out ahead of my skis on that. I can't. It seems so unlikely that that would happen. If it does, boy, then we'll grapple with that. Then then we might spend quite a bit of time on the stream scratching our heads trying to sort that one out, because I know I won't be alone if I'm perplexed at that ruling. I will not be alone. Jeremy Morton gifted 10 memberships. Thank you so much. Thank you on behalf of everybody who got one of those. Mrs. Bucket with a super sticker. Thank you for that as well. Kyle Cowden, you have destroyed my screen time limit. Okay with it. What about mine? How do you think mine's doing here? We're almost 3 hours into the verdict clock here. Just going through the super chats and stuff. I don't resent it. I appreciate it. Thank you for the opportunity to be able to have all of these conversations, share what I've learned. But yeah, it's definitely a lot of screen time. I'm hearing court, but I'm on the court TV stream and I am not seeing that they are back yet. So I'm going to keep my eyes on it. Now I'm seeing NBC 10. Let me pull that up. See if they're back in. NBC 10 Boston, here they are. Yes, they are back in court. Let me get that up. Everything I think is still silent. So I don't think we've missed anything. Probably just letting the jury go for the day, but who knows? Unless somebody heard something I didn't hear. They could have a question. Well, he's almost done. He would have kept going forever. He would have kept going indefinitely. Now the Alberts are gone. How interesting. Just there for that closing.
Thank you. Be seated.
All right, jurors. So as you know, I sent you in a note at 4 o'clock asking if you wanted to go home and come back tomorrow. You said yes. I apologize. It took us so long to get everybody together to do this. So I'm going to excuse you for today. When you come back tomorrow, you will start again after coming into the courtroom. So I do have to give you those 3 cautions, and the cautions also concern the alternate. So please do not discuss this case or any aspect of this case with anybody. Do not do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. You've all worked so hard for this last 8, 9, 10 weeks, however long it is. Let's just make sure that you continue to be as secure in how you've done things as you can. We really appreciate it. So we will see you tomorrow morning. Have a good night.
All rise, jury up.
So we are just under 3 hours. If we take the lunch out, then we're at just under 2 hours. So tomorrow will be the soonest we get a verdict.
All right, we'll see everybody tomorrow.
Thank you, Your Honor.
Be a recess.
All right, we will see you tomorrow. Well, I know people may be a little bit surprised. Thank gosh it shouldn't take this long. It wouldn't take me this long. I get it. But it's not a bad thing. I wouldn't infer anything from it. They need to be thorough, and they need to take the time they need to take. I don't think there's anything in this time frame so far that would alarm me. I had picked the over anyway, and you certainly know how I feel about the evidence in this case. But it's normal to take some time and go through stuff and make sure that they haven't missed anything. So, Michelle, concerning your legal career, what is your proudest moment? Again, thanks for helping keep my sanity over the kids' summer breaks. That's a tough one. That's a tough one. I had a win pretty recently, a case that I won on appeal that it meant a lot to me. It was a very hard case. It was a murder charge. A woman was charged with murdering her boyfriend. They had a very high conflict relationship. Part of their final dispute, I guess you would call it, you can see on camera at their house. She comes out of the garage. She's holding the knife. The man is screaming at her, getting up in her face, being very physical. He's getting into the car to leave. She's trying to keep him from leaving. It's her car. She needs the car. She's trying to keep him from leaving. She reaches into the car, and you can't see what happens. You just see her whole torso kind of going inside the car. He ends up with a knife in his chest, and he dies from it. She sees what happened, doesn't have much of a memory of it, and gets in to drive him. She's driving him to the hospital. Made the unfortunate decision to speak with police, which you should never do, because she didn't remember clearly what had happened. So then police go and find this video, watch this video. They're like, oh, some of these details are inconsistent with what she told us. She didn't remember coming out of the house with the knife. Her recollection is just, I had the knife, and then he had the knife, and then I had the knife. She describes being assaulted in the home by the boyfriend, pretty seriously assaulted, and he threatened her with the knife. And then she ends up getting the knife as he's leaving to go take her car and leave. And there is evidence in the house that supports that. just chaos, things thrown around, blood smears, and she's got a black eye when she's arrested. She's got marks around her throat. So it seemed pretty clear that, she was not making that up. There had been a serious domestic altercation in the house. It was a tough case in part because I knew the participants. This was back in the county where I used to practice, and I had to argue ineffective assistance of counsel. I don't like doing that. It's not my favorite thing to do. Because, I've been in that position. I know how hard it is to be making decisions on the fly and stuff like that. But ultimately, it's everybody who is the defense's lawyer. It's everybody's responsibility to put her interest first. So I had argued ineffective assistance of counsel because the attorney had just flat out misunderstood the requirements of self-defense. She had gotten a self-defense instruction for murder and was acquitted of murder. She had gotten a self-defense instruction for involuntary homicide, but the jury never got to involuntary homicide. They convicted her of voluntary manslaughter, on which the defense attorney, for whatever reason, believed she was not entitled to a self-defense instruction. So they weren't allowed to argue for manslaughter that she had acted in self-defense when she recovers the knife, takes it out to the car, and then there's just this whatever struggle. So I did win that one, won that on appeal, got ineffective assistance, and, conviction got reversed. It got remanded. She gets a new trial. I was really proud of that one in part just because, it's an argument that you don't want to make, but you have to because it's the right thing to do. And just because under the facts of that case, she was very mistreated throughout the whole process. I watched her being re-victimized throughout this whole process. Just the things that were said about her, the way the prosecutor had chosen to try the case, the accusations she had made against her. This is a woman who had very severe childhood trauma of her own, which was not a secret. It was very well known, understood. Because she was known in the community from the time she was a child and had her own just family chaos to deal with. So just a girl who was kind of falling into that same pattern that we see over and over again, the cycle of abuse. She had tried to educate herself, tried to learn about it, but still just got sucked right into that. So it was just a situation where I felt like it was, there's no justice. There's no right outcome with something like that, because no matter what, a young man is dead, and that's not a good thing. That's never a good thing. But her life didn't need to be spent on that as well. Her children, deserve to have their mother. This wasn't a situation where she's a cold-blooded person who takes advantage of an opportunity or something to perpetrate this murder that she secretly wanted to or something. It was just nothing like that. So it was a situation where I felt very strongly that justice was done, and that I played an important role in that. So I would say it's probably that one, but there have been a few. I'm lucky to be able to say I've had success. I'll say, one other, I'll give you one other. Had a young man who basically had a mental breakdown. I don't even remember what he was charged with at this point. It was just kind of one of these fairly routine things, from the standpoint of the volume public defense practice. I think maybe he had broken into somebody's house and was sleeping there or something like that. I honestly don't even remember the details. But I had advocated very hard, for him to get basically mental health, focus on the mental health here. There's not a basis for a conviction. I was able to get him a good resolution. As I recall, it was not he gets off scot-free or anything like that. It was just something everybody can live with, acknowledging that, there was a victim here who, they suffered as the result of his conduct. At the same time, his culpability is mitigated because he's got severe mental health issues. it's not like he was not trying to do that. He was trying to access resources, had a really good history of that type of thing. So anyway, I just got a letter from him. I remember like months later, kind of out of the blue, just so grateful for what I'd done. And I just remember him saying, thank you for believing in people and believing in second chances. That was a very proud moment for me because I do believe in second chances. We have to believe in second chances. We have to believe in redemption. Or what are we even doing? What's the point of any of it if we don't believe that people can change and be better than what they were? Not every single person, not every single time, not always on the time frame that we'd like, but we have to believe in that in principle. So that was very rewarding. I'm I'm not going to tear up, but it did. That meant an awful lot to me. Thanks for that question. That was a hard one. Mark became a YouTube member. Welcome, Mark. Welcome to the crew. Kyle Coden, Coptown just came to mind. Canton equals New Jersey. Boston equals New York. Gotta confess, I need to watch Coptown. Need to watch it. I haven't watched it. My favorite, of course, cop drama of all time, The Wire. I mean, The Wire is just so good. Just so good. Not so much that second season. That second season is kind of trash. But all the rest of it, I just loved that show. And I enjoyed how everybody across the spectrum, it didn't matter. Didn't matter if you identified with the guys on the street. Didn't matter if you identified with the defense lawyer. Didn't matter if you identified with the police. Everybody was like, this is just such a good depiction. Everybody understood just the complexity of the system and the corruption and how nothing changes. Nothing changes. It's kind of dark. But you could look at all sides, all perspectives of people watching that show, and everyone could kind of see it the same way. That's a special piece of art when something like that happens. But I need to watch Coptown. Deep Hat, good day for your 24-hour stream. Oh man, I'm already low on my tea. I don't know that I have a 24-hour stream in me at my age, but yeah, it would be the day for it, wouldn't it? No, I'm not going to do it. Not going to do it. Even for you guys, I'm sorry. I'm not going to do it. I want to be awake and alert when we get that verdict back so we can chit chat about it. John O'Neill, cause of death was not the skull fracture coma, but deliberate dragging into the cold by a group, premeditated to avoid implications of the fight. Do all conspirators get charged? Well, if all of the animals are equal to all of the other animals, yeah, everybody who is a conspirator is contributed to the criminal act. Everyone who acted as an accomplice. You don't even have to be a conspirator. These are related, but there are some fine distinctions between those ideas. Conspirators is that we have a plan and then we work together to carry it out. And so then each one of us does some overt act to further the conspiracy. We become guilty as conspirators. Accomplice liability can be a little bit more flexible. You're an accomplice when, with knowledge that you are assisting somebody else commit a crime, you do anything that helps them. Typically needs to be more than just being there. Typically, just being there and knowing that something is happening is not going to be enough to establish you as an accomplice, but being there ready to help, being there coordinating communications, being there suggesting how to delete texts, things like that, those can all make people accomplices to the crime. And when you're liable as an accomplice, it's not like a lesser degree of liability. You are just as liable as the principal who committed it. So if all animals are equal to all other animals, yeah, everyone who helped gets charged with the murder. Everyone who helped. Yeah, premeditated, dragging him out there to die. I mean, I can see a situation where, yes, the accident, the fall and the skull fracture was an accident. But the decision not to get him help and to dump him out in the street to die in the cold. Yeah. That's where the weather is a weapon. That's the irony of that coming from Mr. Lally with the weather being a weapon. Ms. Holmes, hello, Andrea. Just found you and love you. Bev is personally connected to the McAlberts. Was Karen able to go to J.O.'s funeral? Also, I am very frustrated at Commonwealth and the DA's office. Sickening. Well, thank you so much. Welcome. I love all you guys. It's been so great getting to know everybody. I don't know if Karen was able to go to the funeral or not. I honestly don't. That's background I'm not familiar with. I am certainly very frustrated at the Commonwealth and the DA's office. I mean, it goes to the top is the problem. You just go back to that press conference that Mr. Morrissey gave, and clearly improper. Clearly poisoning the jury pool, saying things that any reasonable attorney is going to know. You're not allowed to do that under the rules of ethics, but there he is doing it anyway. And you have to think that's what sets the mood for any type of office like that. The person at the top sets the culture. And so, yeah, between what we've seen here in this case, what we're getting hints of over there with Sandra Birchmore, extreme reluctance to shine the light on law enforcement wrongdoing. And that is very, very troubling and sickening. Bishop 545454, thank you for all you provide us. Your demeanor is good for my blood pressure. Thank you very much. There's plenty of drama out there. There's plenty of drama. It's easy to find, easy to go looking for it. I don't need to be that here. We don't need to be drama here. We can be a refuge from all of that here. So I'm glad that you appreciate that. Cargo pilot guy, you are truly a lovely person. God bless you. Well, thank you very much, and God bless you too. Nobody special. Could local jurors be scared of retaliation? They could. You would hope that they would have been selected for that in the selection process already, that anybody who would acknowledge a relationship with any of these people would have been excluded on those grounds. But you don't know. The judge has a big role in deciding who can be fair and impartial. If they say they can, then the judge can say that that's good enough. And this is a small community. What did I see? 24,000 people in Canton. That's not a super big community. A lot of opportunity for those degrees of connection to rear their heads. So don't know if it's realistic to expect that everybody who landed on the jury got there because they have no connection whatsoever with these people. Very possible that some of them are on there because they said, yes, I know them, or I've met them, or whatever, but that won't affect my ability to be fair and impartial, to decide the case solely based on the evidence. And once you say the magic words, very hard to get that person stricken. So defense has their peremptories, that they can use to try to weed that out, but it just is a question of how pervasive are those tentacles in the city of Canton. You'd hope that would have been selected for early on in the process, but there's just no guarantee. TJ Truth with the super chat, thank you so much. And TJ Truth, why can't jurors argue for jury nullification? So I mentioned this a little bit earlier. It's not legal. Jury nullification is not legal. It's something that there is really, you can't argue that they have the power to do it. They do. They have the power to do it, but that's not quite the same as having the right to do it. And there are good reasons why we should be extremely skeptical of that right, because that is the jury assuming to itself the power of the tyrant, the ability to decide who should be punished and who should not be punished, not based on the rules that society has agreed on that we all need to live under as part of the social contract, but just based on what they think is best. Their subjective decision that this person deserves it or this person does it. Jury nullification, I understand the perspective that, if certain laws are unjust, it would be unjust to convict people under those laws. I certainly understand that. But jury nullification can be responsible for severe injustice as well, for just voting for who is on my side, and not was there a wrong committed here, not was there something perpetrated that victimized somebody. Very, very uncomfortable situation to be in. So they are typically going to be advised that no, you must decide it on the law, because that's what the law is. Video Maker 1289 with a super sticker. Thank you so much. Appreciate that. Appreciate your support. Nick Disnick, just thanks. Well, you're very welcome. Thank you. Really appreciate your support. The Squid. I haven't been able to verify, but apparently 6 MSP officers were indicted by the feds on corruption and bribery charges, and the investigation was in 2022. That makes more sense in how the feds got involved, if true. It definitely, if there had been investigation of related people already, that's brought some of this onto their radar, yeah, I could definitely see that. It's kind of hard to know how things like corruption come to their attention. Sometimes it's going to be a snitch. It's going to be somebody turning. It's going to be, for example, you're already doing an investigation and somebody wants to save their own skin. So, hey, guess what? I'll give you information about something you didn't know about before. And that can open doors to a new investigation. Things like that would definitely make sense, because it does seem like the investigation just would have been broader. Like, they wouldn't open an investigation just because, Karen Reed says she's been framed in the murder of John O'Keefe, that there's some corruption there. That doesn't seem like a logical and clear pathway to get to having a federal investigation. They're not there to audit, the local law enforcement. They need some information of their own independently to give them a reason to go look. And so, yeah, the fact that they're looking at this, the fact that they're apparently asking questions around the Sandra Birchmore investigation as well, that those involve the same district attorney's office, definitely raises some questions for me. Jeffrey B. Haas long before a verdict. That's the $1 million question. Haas long before a verdict. Southern Gigi, can the jurors request transcripts of the witness testimony? What do they do if they can't remember what Jen or someone said and wanted to read it over? They will not be allowed the transcripts. Bev actually said that specifically in the instructions to them. They will not get transcripts. They are to rely on their memory. If they don't remember, they can rely on their notes if they took them. If they didn't take notes, then you got to do your best. They are not going to provide them with transcripts of the testimony. I don't know exactly why that is, honestly, in this modern era. I understand why that would be the rule 100 years ago, when the court reporter is just taking the stenograph there. It's all analog. To be able to prepare a transcript takes time and stuff like that. It makes sense in that old era. I'm not so sure that it makes sense today. The argument is that they are afraid that it will mean the jury would pay undue attention to some parts of the evidence over some parts of the others. But the counter argument to that is, well, they get the exhibits. So you're already kind of prioritizing the exhibits over the sworn testimony, because they can sit there in the deliberation room and look all of those over as many times and as long as they want. But the testimony, they just have to kind of remember it to the best of their ability. Not sure it's a rule that makes sense in the modern era, but that is what the rule is going to be in this courtroom. They're not going to get transcripts. I am me. They need modesty panels for the gallery. When they go in for a close-up on Karen, we get a tight shot on Paul O'Keefe's bulge. As a trashy man, I'm okay checking it out, but most people probably don't wanna. That open little baluster thing there, that is the downside of having the seats set up like that with this particular angle of the camera. You know, you'd like to put some of that on the camera operator, the cinematographer, if you will. Isn't that part of their job to set up the shot? Try to make it inoffensive. I don't know. But yeah, it's the things that you learn through the course of having a nationally televised trial in your courtroom. Maybe next time they'll be thinking, hey, how about some modesty panels? Lawyer's daughter is a YouTube member. Welcome. Glad to have you here. NJ Kathy, treat yourself to a manicure. You deserve it after your excellent coverage of this wacky trial. Well, thank you so much. I'm kind of going to need it. I'm getting a little dehydrated. Hard to keep up on my tea. And summer is always rough on me anyway. We have such a dry, arid climate here. It's a challenge. But I will enjoy that. Thank you. And then I'll go scratch it all up, punching people in the face. I hope you won't hope you won't be bothered if that happens. I can't wait to get back to sparring, guys. That's my one thing. If I were going to say about the trial, my one downside is, you know, I'm getting up very early. I'm putting in long days here, which is totally fine. I'm obviously doing it voluntarily, and I appreciate everyone being here with me, but it's making it hard to spar. I'm ready to get back in there. I'd been out of the ring for quite some time because I was having some issues with my elbow, but that's all better now. All feeling pretty good, feeling rested, feeling energized, ready to go back in and punch some faces. So I'm looking forward to that. I'm not going to lie about it. Looking forward to it. Eric Wolfrick, who believes the McAlberts knew Lucky would be the one on that route and counted on him being perceived as simple to believe hit John O'Keefe with his plow snow accidentally? Possible. Or just, you know, it didn't matter who the plow driver was. That's the other possibility. It wouldn't matter who the plow driver was. They were going to find a way to pin it on him, and then they were going to do their cop stuff like they do. Gaslight him. You must have done it. You must have done it. We got all this evidence. We got somebody who's in the house. We got it on camera. They saw it happen. You can just tell us. Yeah, do that whole little interview stuff that they do. Maybe it wouldn't have even mattered who it was. But yeah, if they knew it was Lucky, I could see that too. Just somebody that they would think it's going to be easy to take advantage of him. Just gross if that's the case. Just gross. Singing Ferret. To be fair to the jury, if I was a juror on this case, I would have spent 1 hour just venting to the other jurors about this investigation. It's true. They could be needing to vent. We have been able to vent together over weeks of enduring this, and they haven't. They're told you're not supposed to talk about the case even to each other until you are in that deliberation room. And if they have honored that, they are ready to pop. They have so much to say. They could just be talking shit for a couple days. I mean, the catching up they have to do with where we are on the tearing our hair out and the oh my gods, and can you believe that happens? Yeah, they got some catching up to do. I think that's a very great, very good observation. They need to vent potentially more than even we do. And here we are, still hours later, still venting. Dreamer Thinker, what does the process say if two jurors hold out in the guilty camp? How does that play out immediately and over time? Also, you're great. Thank you. Thank you. Depends on how long they hold out and how strong they are in their position. If they simply refuse to cave and nobody else is going to cave either, then you get a hung jury and you get a mistrial and people are entrenched in their positions and that makes them hopelessly deadlocked. If they're not so strong in their position, you know, different things can happen. The jury room can get quite heated. It can get quite heated. Can't threaten anybody with physical violence. That would be misconduct. But otherwise, yell at each other, insult each other, call each other stupid, all that type of thing. Yeah, that can happen. That can happen. It's not against the rules. I'm not advocating for that. I'm not saying go out and do that. I'm just saying this is natural. This is conflict. Conflict will happen and will play out in the jury room in these types of situations. And so how they resolve it, do they resolve it? It can be all over the place. You might try to walk them through, play nice. Okay. I hear you. I want to understand your concerns, share them with me. Then let's talk about them as a group. And then we're able to go back and look over the evidence and maybe we're able to move them off that position. Maybe we've tried that and it's not working. So now we're going to be like, what the hell is your problem? I mean, it's just conflict resolution like it is anywhere else. And the question is really, are they going to be open to changing their minds? That's just the bottom line. How firmly are they entrenched in that position? If they can be moved, then efforts will be made to move them. And it may take some time, but if they can be moved, then probably they will be. If they can't be moved, then we would likely get a hung jury and we would get a mistrial and we'd be doing this all over again a few months down the road. Desert Cat, been watching Andrea since Depp. She's the best, sharp and even keeled, but not so bound to being neutral as to ignore the obvious and undisputed. Well, thank you very much for that. I do appreciate that. I don't pretend to be some, above everybody with no biases at all or anything like that. No, we're all human. We all have them. We try to acknowledge them. I point out my perspective is from the side of the defense. That's what I know. It's not that I automatically side with the defendant. That's really not what I mean. It's just that that's how I have seen this process played out so many times. So that is what informs my perspective. I think about cases the way I expect a defense attorney is going to think about them, which is typically critically, asking a lot of questions. I have a lot of questions. But the evidence is what it is. The evidence is what it is. I'm not here to advocate that, Darrell Brooks is innocent just because he's a defendant. Like, no, it's pretty clear. Pretty clear what he did. The evidence is going to be what it is. And I don't know. I'm not trying to be disconnected with reality or anything like that, but just follow where it leads. That's the process of developing a judgment. You become informed. It's the distinction the Amber Heard fans could never quite make, the difference between being biased and being informed. I was not biased against Amber Heard. I became very informed about the case. And as a result of that, I developed opinions about it. Same thing here. Same thing here. I came into this case completely open to the possibility that maybe she did do it. Maybe she did do it. Maybe it was an accident. Maybe she did do it on purpose. But I've watched the evidence, and as the evidence is unfolded, I've become informed, and now I have opinions about it. That's how human cognition is supposed to work. Christine McCoy, would you be interested in revisiting a vintage trial such as the O.J. Simpson trial? I was too young to get it at that time. Love your work. That would be quite a deep dive, wouldn't it? The O.J. trial was long. God, how long was it? It took forever. I feel like it was on for pretty much my entire senior year of high school. There, I just aged myself. It's a long one. Maybe. I won't say no. I'll think about it. It was such an important trial in the history of, especially the televising of trials and just how that works in terms of not giving the media space to create a narrative when it's on TV. I would contrast that with Michael Jackson. It happened much later, but it was not televised. So we were dependent on the reports from the courtroom. And so it followed a narrative. And then people were shocked when the verdict was not what they thought it was going to be because we didn't have the cameras in the courtroom. And still to this day, if we did not have the cameras in the courtroom in Depp v. Heard, there would be an entirely different public perspective on the trial based on the reports that furthered the narrative, and not what we were watching unfold in front of our eyes. So OJ played such a huge role in that whole process, recognizing the importance of having the cameras in the courtroom. And it is a case where, I'm not an expert about it by any stretch of the imagination, but there is a lot of just incomplete information. I think people have a lot of strong opinions about it based on incomplete information. So it's not a case I have real strong opinions about, because I didn't watch it that closely. So I don't know. I'll leave that as a solid maybe. Maybe. Carazola X, my uncle was in Chicago decades ago. A cop ran out in front of his car trying to get touched. Cops backed up their brother. He was trying for PTO. Oh, that old scam. The whole fold myself over the hood scam. Yeah, I mean, it takes all types, right? And police are just a kind of a cross section, just like any other profession is. Of course, there's going to be scumbags in it. There's scumbags. This might come as a shock to you, but there are scumbags who practice criminal defense law. They're out there. There are scumbags who are police officers. There are scumbags who sit on the bench. There are scumbags who perform surgery. There's people all over. There's no real category of saints besides the saints, and we don't tend to recognize them when they're walking around in human form. Ian Kelly, any news on the Marilyn Manson case? We are in the perpetual waiting game with Marilyn Manson. The only things that are really active that I'm aware of right now, the appeal is ongoing, but they've been waiting for a transcript for like 1 million years. So we're still waiting on the briefs. I mean, this is the appeal from the anti-SLAPP motion. Discovery and everything is stayed, while that's going on. It can't go to trial until the appeal is solved. So everything is just really on hold in that case until they get through the appeal, and the appeal it has been, basically just stalled. The Bianca Kine lawsuit, I believe, is also stalled because I don't think he ever got served. I think there was like a motion to dismiss for lack of prosecution on that one. Honestly, I kind of even lost track of it just because nothing had happened with that one. And then Ashley Walters, her case had gotten reversed on appeal. That was the one where the judge threw it out because of the repressed memory testimony. He was like, no reasonable person could buy this justification for getting past the statute of limitations. Well, as the legal heads predicted, that's not what the standard is, not at this stage of the process. It might very well be at summary judgment if they can't counter. Manson's got Dr. Elizabeth Loftus on his team. Just the best possible witness on repressed memory because she pretty much created the field back in the whole satanic panic days. If they aren't able to contest that or just establish other elements, then summary judgment, maybe we'd revisit that. But wasn't ripe for it to get thrown out at this particular stage. That was not the right legal standard to apply. So her case got reinstated. And now, as far as we know, it's just back in discovery, back in the same old process of waiting for something to go forward to trial. Maybe it will get settled. I don't know. Several of the other cases have already been settled. So we're just in the eternal lull of that case, waiting for something to happen. Probably the next thing that I will be paying attention to is once we finally get the briefs on the appeal for the anti-SLAPP. I'm very interested in that because I read the ruling, and from a legal standpoint, okay, it makes sense if you follow these legal propositions. It makes sense that you get to this conclusion. But the legal propositions themselves just seem so freaking crazy, some of them. I mean, the whole issue is, right, she fabricated a FBI, a letter from the FBI accusing Marilyn Manson of being the subject of an FBI investigation, a criminal investigation. She filed this in her child custody case to try to justify withholding her child from the child's father. The FBI agent whose name is on it has told people, no, wasn't me, didn't do that, never talked to these people. Just looking at the thing, it's not a good fake. It's not a good fake. Does not look like a letter that you would expect an FBI agent to be sending for that kind of purpose. So it looks like perjury and it looks like fabrication of evidence. But the way that the standard was applied in this particular case was that unless she concedes that it's illegal, then it's privileged. It's subject to the litigation privilege, which protects basically any statements made in the course of a legal case. Well, of course she disagrees. Of course she disputes that. She says, that's not what happened. I didn't do that. And under the legal standard, that's enough. It seems very, very bizarre to me. So I would like to see that fleshed out. Very curious about how all that works. Really don't understand it, but in fairness to the judge, that did in fact seem to be what the law was, which is just mind-blowing. Paige Price, I read police corruption framing can be RICO. So RICO involves criminal organizations. It's not typically going to apply to like a police department in general, because the purpose of the police department is not criminal activity. And it's probably not going to be the entire police department most of the time anyway. It's going to be some bad eggs. Where it can come up, like, for example, there are police gangs. There are police gangs, their own little like subunits that they form with their own values and systems. They don't necessarily call them gangs, of course. They'll call them like fraternities or something like that. But so you would need some type of group that's organized for the purpose of engaging in criminal activity and actually engaging in criminal activity to be able to pursue a RICO charge. So I don't think that particular angle is likely, but they don't really need it. Like corruption with law enforcement, that's kind of enough. They do have duties to like not be bribed and things like that. Not be conspiring with each other to help each other, fabricate evidence of crimes to frame people. So I don't know that they would, need the RICO to be able to get there. There's standalone charges that they'd be able to pursue if they can prove that stuff. All right, guys. Been a little bit of a long one today, but we had to wait and see what we were going to get today. So I am not going to be jumping on at 5:45 tomorrow morning. I am going to, I probably won't sleep in that much either, because I'm going to want to be on in case we do get that verdict. I'm going to want to see it. So, but I'm gonna wait just until we get some notice that something is happening in the courtroom. I'll be ready to go if it does, even if it's just another question or whatever. I'll be ready to go live so that we can talk about that. But looking forward to getting some resolution here. Hoping very much it's going to be soon. But we'll see. Hopefully it's before Thursday at 10 a.m. I don't want to run a risk of having a conflict with the Brian Kohberger hearing, but it could happen. I don't know. We'll just see. But I'll worry about that when we get to it. So looking to tomorrow, anticipating, we'll probably be going live at some point to address what's happening in the courtroom, and we'll go from there, guys. We'll see what we get. I know that we're all just ready. We're ready for closure. We're ready to put this aside. We're very much hoping that justice is done. And I very much share that. We want to see the system work. We want to see it We want to see it vindicate what we've watched unfold over these past several weeks. The jury is supposed to be the representatives of the community. And even though I'm not there in Canton, you know, I'm not that different from people in Canton. I'm just a person looking at the evidence. And so I have to have some faith that the jury, if they're reasonable people, like I consider myself a reasonable person, they're looking at this and they're seeing things the way that I am. So I'll give them room to have their shit talk, have their vent session that we've been able to have this whole time. But I do hope this doesn't drag on just for everybody's benefit. Long deliberations, very stressful for everyone. So we'd like to see it come to an end. Cross our fingers for tomorrow. I will be going live when it happens. I will look forward to seeing you guys there. Thank you again for joining me. Thank you all for being here. So many people here throughout this whole day. 3,000 of you still in here. Hours later, the jury has already gone home. And you're just here to talk with me. That's pretty awesome. Can't lie. That's pretty awesome. Thank you all. Really appreciate it. So please enjoy the rest of your afternoons. Enjoy your time away. And we will see you when we have news from the jury. Take care, guys.